Welcome, Honorable Justice Kumar, sir, on behalf of MP Law College. We would be starting the event soon. Good morning, Honorable Justice, sir. Welcome to MP Law College.
Good morning. Good morning.
Good morning, sir. Good morning, sir.
Good morning.
It's a pleasure to have you with us, sir.
My privilege, sir. My privilege. All teachers of eminence are there. I am going to learn a lot of things. Good morning, Principal Rao.
Sir, good morning, sir. It's a pleasure.
Same here, sir. You are the custodian of the future generation.
Yes, sir.
We are proud of you.
वॉल्यूम कितना किया?
Sharp 9 बजे शुरू. Netal, are you there?
Yes, sir.
नेतल
9 बज गया. शुरू करो. मैडम है तो
हाँ
सच-
सर आ गए मैडम. ओके सर ओके.
बीसी मैडम से बात करके शुरू करो.
मैडम भी ज्वाइन हो चुके हैं.
हाँ.
We'll talk leisurely. शुरू कीजिए.
गुड मॉर्निंग मैडम.
Good morning. Good morning. How are you?
फाइन मैडम थैंक यू.
Very good morning, ma'am. With your permission, may I start with the program?
Sure, sure.
Thank you so much, ma'am. Good morning and a very warm welcome to everyone for inaugural session of Developmental Approach. I will be final year student convey greetings on behalf of Society's MANIKCHAND PAHADE Law College, Aurangabad, for organizing the training program in collaboration with National Human Rights Commission, New Delhi. We are honored to have with us Professor Poonam Saxena, Vice Chancellor of NLU Jodhpur, presiding as chief guest for today's training program, and guest of honor, Honorable Justice M.M. Kumar Sir, former Chief Justice of Jammu Kashmir and founder president NCLT, presently member at NHRC. We are honored to have such prominent personalities to guide us today. Before we proceed, I request all the candidates to kindly keep their mic mute and videos off for the better connectivity of the session. I here invite S.N. More Sir, Vice Principal, to deliver the welcome address. Over to you, sir.
Honorable Justice M.M. Kumar, former Chief Justice, High Court of Jammu and Kashmir, and former President, NCLT, presently member of NHRC. Honorable Professor Poonam Saxena, Vice Chancellor, National Law University, Jodhpur. Respected Principal Dr. C.M. Rao sir, Coordinator, delegates, and all the students. I take this opportunity to welcome you all for participating in today's online national level training program on correlating women rights and human rights, a human development approach. This program is being organized in collaboration with National Human Rights Commission. And we are going to have a very fruitful deliberation on this. I hope that all the participants who are gathered in online mode will be definitely benefited due to the discussion and the guidance to be given by our guest of honor, Honorable Chief Justice M.M. Kumar sir. With this, I'll conclude my welcome address here. Thank you very much.
Thank you so much, sir. To give a brief introduction of our today's event, I here call upon the Ether Coordinator, Dr. Sheetal Bharate, ma'am. Over to you, ma'am.
Thank you, Nathan. Honorable Justice M.M. Kumar, sir, former Chief Justice of Jammu and Kashmir High Court, founder president of NCLT, and presently member of NHRC, who is going to inaugurate our training program. Respected Professor Poonam Saxena, Madam, Vice Chancellor of National University, Jodhpur, Principal
Really sorry for this inconvenience. Once again, I welcome you all in this online training program, which is organized by MANIKCHAND Law College, Aurangabad, and which is sponsored by National Human Rights Commission, New Delhi. Now, coming to the introduction about this training program, we know that when it comes for human development, it is a process which involves economic, social, cultural, and it's called overall transformation over the time and space, and which should aim at to improve the capabilities, freedoms, and living standards for individuals and realize human rights. Now, as far as women community it is concerned, we have n number of provisions in our in UDHR. Various international instruments, conventions are there. At national level, we have number of legislative enactments uh, just to protect or to which provides for n number of provisions for the women's rights. So this training program is organized with the honest intention to offer a basic understanding of these rights which are contained in various national and international instruments, which if properly implemented will be major contributors in the capacity building of women, and which will definitely will lead to their overall development and the empowerment. Amongst 574 registrations have been done for this training program, which consists of law students, faculties from the law school, social sciences, and advocates. This training program consists of 4 sessions apart from inaugural and the valedictory session. In this session, we have respected Poonam Saxena Madam and Justice M.M. Kumar Sir as the inaugurator and the chief guest of this session. In the first session, we will be hearing a discourse of Dr. Banerjee Chakka Sir from VIT AP University, Andhra Pradesh on human rights. In the second session, Advocate Rama Sarode Madam, a human rights activist from Pune, will be delivering her address on rights of women. In the third session, Ms. Soma Bhattacharya Madam from DSNLU Visakhapatnam will be talking on violence against women and legislative remedies. And in the fourth session, we'll be hearing Professor Jyoti Bhakre Madam from Department of Law, Savitribai Phule University, Pune, on women and health rights. Advocate Dr. Kalpalata Patil Bhasarpe Madam, who is Secretary of MLNJ Society, will be with us for the valedictory session. I hope that every participant who has joined this training program would definitely be sensitized on the issues of women's rights, and this will enable our participants to work towards the proper implementation of these rights, and they will work towards the creation of a gender neutral society which will be helpful in overall development of the women. On behalf of this institute, I express my sincere thanks to the National Human Rights Commission for sponsoring this training program and for giving us opportunity to spread awareness about the women's rights and human rights. I am thankful to respected Principal CM Rao Sir, Vice Principal Sir, IQC Coordinator, and all the members of MLNG Society for always motivating us to conduct such a programs. With this, I will stop here. Thank you to the organizers for giving this opportunity to share my views upon the introduction of this training program. Thank you so much. Over to you, Nikhil.
Thank you, ma'am. Our chief guest, academician and educationalist, Professor Poonam Saxena ma'am, has endless contribution in the field of law with innumerable achievements. Before we proceed, I here call upon Sejal Sisodia to give a brief introduction about our today's chief guest.
Thank you, Neetal. I feel privileged to introduce today's chief guest, Professor Poonam Saxena ma'am, Vice Chancellor, National Law University, Jodhpur. Ma'am is in charge Law Center 2, Faculty of Law at University of Delhi. Ma'am has completed LLB, LLM, and done her PhD in the same. She has been providing her service in Delhi University since 2004. She has also been visiting lecturer at School of Law at Maryland, USA. Ma'am has an administrative experience of 2007 with a gap of 1 year and continuing till date. Ma'am has been Senior Fulbright Fellow and Shastri Indo-Canadian Fellow in the year 1998 and 2000 respectively. Ma'am has got membership of several organizations like Indian Law Institute Delhi, member of Karmika and NGO, member of editorial of IS Genitum Journal of University of Baltimore, Chancellor's nominee at North Bengal, University of West Bengal, and Utkal University, Orissa. Editor-in-Chief at National Capital Law Journal, University of Delhi, 2007 to 10. Ma'am has been awarded with number of awards like Junior Research Scholarship by University of Delhi in 1982, Scholarship by the Indian Institute of Islamic Studies 1981. National Scholarship for consecutive 2 years, LLM 1 and LLM 2. Ma'am has been excellent in academics with first position in University of Delhi in LLB first year and LLB first term and fourth term, and first position in LLM fourth term. Further, she has acquired second position in LLM third term and final term in 1981. Mullah's Transfer of Property Act, Property and Easements, Trusts and Charities, Family Law 1, Family Law 2, under Halsbury Laws of India are certain publications done by ma'am. She has written more than 46 articles and various paper presentations, seminars, conferences and conventions worldwide. Ma'am has addressed judges at National Judicial Academy, Bhopal, addressed foreign delegates in India, participated in medias, addressed students and faculties from various law schools. She has participated in social activities as voluntary member of Karmika and NGO, giving counseling and legal aid to women in distress for having matrimonial problems, and also a voluntary member at Justice Sunanda Bhandare Foundation. Ma'am has delivered several lectures as part of Gender Justice Program to faculty and college students at various universities in New Delhi and Gurgaon. Words will go short to tell about ma'am's success and achievements. I am obliged and thankful to the organizers who gave me opportunity to introduce Poonam Saxena ma'am in today's training program. Please excuse me, ma'am, if I have missed any part of your success story. Thank you.
Thank you so much, Sejal. Without any further ado, I request our chief guest, Professor Saxena ma'am, to kindly deliver the keynote address. Over to you, ma'am.
Thank you very much. You didn't miss out on anything that is important now. I'm at this juncture of my career. But yes, I do believe that when you take out an old CV of mine, it's not 32 years, it's more than 40 years now. Okay, but on the flip side of it, that makes me 8 years younger. Okay, which I'm really very pleased about. Honorable Justice M.M. Kumar, so we're very pleased to see you. Okay, Dr. C.M. Rao, the principal, the faculty members, dear students, ladies and gentlemen. I'm really very pleased to be here, and especially in an online mode with all these rains and everything. Though I love the city of Aurangabad, it would have been a pleasure to come there. But online is such a nice option that we have realized during the COVID times. It saves a lot of time. It makes it possible to see each other and be virtually, except for enjoying a cup of tea together, we can do all these things. So this is one subject that is very close to my heart. And I'll confess that right from my LLB days and LLM days, as a young student, I was always interested in these issues. Those were the days when there were not really very many progressive laws, but yes, we were going in the right direction. As the host said that, today's topic is correlating women's rights and human rights, a human developmental approach. Now, whenever we talk about human rights, the first question that used to be asked, do women have human rights? Do women have rights at all? They are being born here only to perform certain duties and obligations. The rights and sense of entitlement is always with men. Well, that was the kind of a concept that we grew up with. Oh, you have to do this, you have to do this. This is your obligation. This is your matrimonial obligation. You have to make way for the entitled species. Well, that's a thing of past. But now, of course, the times are different and we are talking about it. When we talk about economic, social, cultural rights, I am not speaking about CEDA. I would rather hesitate talking about the international conventions. I would rather talk about Indian Constitution that's there and that gives all the rights that we actually need if implemented in the proper sphere. We don't have to look to the international conventions at all. It's all there in our Constitution. Interpret it correctly, implement it correctly, and I do not think we will have a cause for concern. But unfortunately, whatever the laws that we have that are excellent on paper, whatever are the constitutional guarantees that we have that are absolutely wonderful. But when we take them or when we try to see them in light of the social reality in which we live, then of course there is a dismay, there is a dismal approach to it. All these rights must be visualized in the context of social realities where we live. We don't have to be guided merely on what the law on paper is, but we must also see how the law is implemented. And in this context, in the social reality, and in this particular context, the world that we live in becomes extremely important. What is the conditioning of the society? What is the treatment that we actually get? What is the time when we read the Constitution? Not when we are born. At a much later stage, we are told that these are the rights that you can be given. But right from day one, and I will say, even before a girl child is born, when we see the potentiality of the harm that the society does to a girl child. And therefore, what I feel is that whenever we talk about human rights, we say human rights of women. We are not looking at a 25-year-old woman who has seen youth, who can make up her mind, who can take decision, who can know what is being done to her is wrong in light of the constitutional guarantees of gender parity. But we start with at a time when she cannot speak, when she cannot even show her presence visibly. She can maybe smile in her womb, or maybe her existence has not come into being. It is from that particular time we have to see what is the treatment that society gives to her. We are talking about her rights. Does a girl child in the womb have any right about it? So what we have to see, we have to trace the journey of a woman from womb to tomb. And I classify it while analyzing some of the very, very important human rights that a girl child or a woman or an old woman trace the journey. We start from the fetal stage, go to a stage where she is old, maybe walking with a stick. What are her rights? And I classify them as 4 plus 4 plus 4 plus 2. 4 in the natal family, 4 in the matrimonial family. That is one classification. The other classification is 8 in the private sphere, these 4 plus 4, and a 4 in the public sphere. As far as a woman is concerned, this particular classification is very, very important. What is her treatment within the family? And what is her treatment in the public at the hands of the strangers? What are her rights in the public spaces? And what are her rights in the private spaces? Public spaces, what I have found is the government is very concerned. I'm not saying that she gets a very good treatment, but when the responsibility is taken by the government, they are very concerned. But in the private sphere, when you talk about the rights of a woman or rights of a girl child, then there is a kind of a reposition of a trust in the patriarch of the family. That is, they have the first responsibility to ensure that the girl child is born in the family, is brought up in a decent manner, is given education, is not married at an earlier stage, and is allowed a choice of whether to get married or whether to choose her career. But when it comes to public spaces, occupying public spaces, entering the workforce, then of course the laws that are framed are extremely sensitive. Though when it comes to implementation, there is much to be desired. So I'll start because I have been given 20 minutes, I have been told, and these are 4 plus 4 plus 4 plus 2, and I say 14. So I'll devote virtually 1 minute to each. And I have a tendency of actually speaking and speaking till the bell goes because I'm a teacher. And please stop me therefore when I'm crossing that 20 minutes to 21. So I'll start with the rights in the natal family. I say I identify them as 4 plus 4 plus 4 plus 2. These 2 are essentially human rights that will be with everyone, be it a woman or be it with a man. But these 12 rights that we identify as very important are essentially with respect to a woman, which I feel in identical circumstances, a male will not have to encounter. And the first, of course, right is a right to be born alive in this world. Right not to be a victim of extensive female feticide. That is one of the domain that has come to stay with us under the garb of patriarchy. Now, this right to be born alive in this world, you know, when we talk about economic, physical, she is at a stage where she cannot even register her presence, show her face. She's in the womb of the mother and totally dependent upon her mother, who is supposed to be the most loved person in the world. Now this, as I told you, that right from my LLB and LLM days, I used to be active in these issues. And those were the days where the social consciousness has not gone so much into this particular issue. I'm from Delhi. I'm born and brought up in Delhi, used to roam around in buses. And then there was one famous crossing, a very big crossing near our Delhi University, with all kinds of shops and establishment. And there, being with each other for a space used to be advertisement. Spend 500 today and save 50,000 later. These were the advertisements of ultrasound clinics, wherein you spend 500, get the sex of the fetus determined at that particular stage, go for an abortion to a known or whatever it is the clinic, and then maybe what is that saving that they hinted upon? 50,000 you can save, maybe possibly as a dowry. And these were all splashed over, in public domain, and many people thronged to it. Abortion was no longer considered an unethical. People said, we want to plan our families. We have a daughter, we want a son, and therefore there is no harm. The girl child has not even seen the world. It is as good as, terminating an unwanted pregnancy as not a social taboo. Many people resorted to it. But ultimately what happened in Punjab once, and how it came to limelight, and then socially conscious people took this particular issue as a very grave issue, that there was a very rich business family in Punjab. They had two daughters. They went in for the third pregnancy. They went in for sex determination. Girl aborted. Another time pregnancy, girl aborted. The third time pregnancy, again aborted, saying that is a girl. But unfortunately for them, it was a boy. And then there was a hue and cry. The much desired, prized possession taken away by these prenatal diagnostic. The government woke up. There was a statistic survey that was conducted, and it was found at that point of time, just think about the population. 10 lakhs female fetuses were aborted in Maharashtra state alone. When it comes to Punjab and Haryana, situation was very, very dismal. So the government came up with that prenatal diagnostic prevention of misuse techniques in 1994, then extended it to everywhere, and then 2000, and then that's an old story. But the situation is, it still continues. Clandestinely, it still continues. But why does it do that? Why do people do that? The culture of son preference in India. And I identify a couple of things why people say that there is an essentiality of son. Son is seen as ensuring economic, physical, and old age security and spiritual security. But we have not seen it. We do not want to deny it. At the same time, can a girl not provide economic security? Can a girl not provide physical security, or she is someone who has to be taken care of physically? Nowadays, we have much more advanced than those tribal stages where physical power alone was the determining factor. We are living in a civilized world where security is not limited to that physical power only. It matters a lot. At the same time, we cannot say that the girls cannot provide physical security. On the other hand, my own experience with the public, with the society, with my relatives has been that girls provide excellent emotional security to the parents in the old age. The way you hug your parents, a boy is not demonstrative emotionally. He cannot do it, though it's not, I do not mean to say that he doesn't love his parents, but the girl is very demonstrative in her affection. She makes you feel instantly wanted. So the old parents, when they are parents of daughters, realize at a much later stage that the girls are so precious, they are so wanted at the old stage, yet they must have cried when she was born that we don't have a son. But this is a practical reality. There are business houses that are giving their business to their daughters, not that because there is no son, but because they trust them. So, and with respect to spirituality, a girl can take care of the parents emotionally, a girl can take care of the parents economically, a girl can provide financial and physical security to them also, and very, very importantly, a sense of being, wanted. she will still make you feel that you are wanted, you have a place in her life. And, I'm not saying that boys don't do it. Boys do it, but their demonstration is less than what is demonstrated by the daughters. So parents yearn to see the face of the daughter in their old age, but at the time when they are born, they are really very upset. With respect to the spiritual salvation concept, that is something that we really believe in as far as Hindus are concerned. But I do think, I do read the quotes that are given by some women who had no brothers and they performed the funeral rites of their fathers. And they said, I do not think my father's soul is roaming like a ghost. I perform the funeral rites. It's the hand that counts, not the sex. It is the hand that counts. It's the feeling that counts. Spiritual salvation is one thing that we believe in, but we have not seen. And I do not think that should be such a major criteria for wanting to have a son. That is the one, because I can go on and on, but I'll go to skip to the second part. And that is the second right, and a basic human right that I will say, as far as a girl child is concerned, transforming herself into a woman at a later stage, is a right not to be a victim of female infanticide. I'm presently in Jodhpur, Rajasthan, and Jodhpur is known for the way they treat their female population. Not really very healthy scenario as far as the girl child are concerned. Systematic infanticide used to be the practice at one point of time, but people have not really come out of it. 3 days back, I read a report in Rajasthan Patrika. Girl child was thrown in bushes just 10 hours after she was born. Bitten by ants, there was blood all over her body. When her wailing cries were heard by some concerned people who were passing by. It was a village, a very close-knit society, and the Sarpanch said that we know all about our population, that small population. We know who was pregnant, we know whose child was born, and will take strong action. But at the same time, just think of it. We expect society to respect us. I, as a woman, will say that I have a right to be respected. But whom are we seeking the respect if our own parents, if our own mother ditches us, throw us in the bushes to be died, or to be bitten by ants, to be bitten by dogs, or maybe on the cart of some vegetable vendor? There are several places, maybe left in the public toilet, maybe left in the washroom of a hostel or a hospital, anywhere. I'm reminded of one story. It's not actually a story, it came in newspaper. Even though there is paucity of time, I can compromise on other issues, but this is so close to my heart. In Punjab, again, this case came from Punjab, and the year is 1980. There was a news item that was published, and that said, daughter shouts at mother, mother escapes in tears. Now, biological mother escapes, makes a hurried escape in tears. I was said, how can a daughter talk to her mother like that in public spaces so that she has to beat a history street? And I read the whole report. The whole report, and then the adjoining stories that I confirmed was like this. A woman reported for delivery in a hospital that was run by Christian missionaries. Now, she gave birth to 2 baby daughters, twin daughters. And then after some time, she took back home 1 daughter and left one on the stairs of that particular nursing home or hospital. The head nurse heard the wailing of the baby wrapped in a towel on the stairs, made inquiries. The woman had given a false address. She was not able to locate. And then after those preliminary inquiries, decided to bring up the daughter as her own, child as her own. Now, she was a Christian. She was used to praying in a particular manner. The little girl who did not know what her parentage was, what her lineage was used to seeing, quote unquote, her mother praying in a particular manner, and started emulating her. She thought that she was also a Christian. And she was brought up in a very decent manner. It was given a good education. And then you used to go to church along with the mother. Now, the real mother, who had an identical twin at home, was following sometimes as a mother what my daughter was doing, and she was assured that she is in good hands. Unfortunately for her, this little girl, grown into a beautiful woman, fell in love with a Christian boy and wanted to marry him. At that point of time, the biological mother, see how our society works. And what are these things that cannot be explained at all? This real mother approached the daughter, whom she had abandoned long back, and said, you belong to a Sikh community, you are a Punjabi, and then, it doesn't really matter whether she came from Punjab or any other part of India. But she told her, and you are a Hindu. Sorry, you are not a Christian, and say, so please do not marry him. Otherwise, you will be out of caste. And says, who are you? She said, I'm your biological mother. And this was not a case of a Bollywood movie that the biological daughter will just greet the biological mother and say there will be tears in her eyes. She was a law graduate. And she said, you left me when I needed you more. If you do not meet a history receipt and come up with all these nonsensical ideas, I'm going to lodge a police complaint under section, I think it is 320 or something, for leaving an infant to die under IPC. And mother bet a history retreat. And look at the reporting of the reporter. Now, this idea that somebody can leave the baby girl at the doorstep, and they said, why did she leave? Why did you leave me? Oh, I was not courageous enough to go back to my matrimonial home with 2 daughters. They would have kicked me out. So she said, you had your priorities set. You chose yourself over me. You could have taken care of yourself, but I was an infant. And that was it. Female infanticide, unfortunately, is still practiced. And again, they say, if we do not practice it, there will be a huge, a kind of a thing on population. I want a son, so I will have 1 daughter, 2 daughters, 3 daughters, 4 daughters. I will not stop till I get a son. There are reports that when there are in the nursing home where the delivery takes place, there are instances of people stealing someone's baby boy and leaving their own child there, only just to show that they have got a baby boy. This is a problem that we have to come out of. And we can come out of it only and only when we treat daughters on the same footing as a child, not as a son, as a child. She's a child, a very, very valuable child. We do not want to say, bring up your daughters as son. No, a daughter is in her own value, in her own right, a very, very valuable person, a very, very valuable human right. She has to be brought up as a daughter does not mean that you subjugate her, that you do not give her rights. You bring her with love and affection. You bring her, you give her what is due to her. And that is how the upbringing should be. Not that pseudo kind of a dialogue. Oh, we have brought up our daughter just like as we will do with a son. No, you haven't done it. You bring her up. A woman has some essential qualities. Preserve those qualities. Cherish those qualities. Value those qualities. If a son and a daughter are emotionally different, value that difference, but do not subjugate. Do not say this is inferior, that is superior. Do not say that this human being is inferior, this human being is superior. We are all born equal. It is the gender construct or the social construct that creates this kind of a hierarchy. The third human right that I will say is in which no law can interfere. Nobody can interfere is the right of a girl child to a decent upbringing, a right to education. There can never ever be a law. These things cannot be regulated by law. There can never be a law that the mother should breastfeed the baby girl for the same amount of time that she does to her baby brother. These are the things that comes from within. No law can regulate it. There cannot be any law that can say that put your daughter in the same public school or an English-speaking school as you have put your son in, and do not compromise on her education. These are the things that the parents have to awaken themselves to. Because at that particular time, when a child cannot speak, has absolutely no clue what education would mean in future for her or him, it is the parents who have a responsibility to see that their children, be it a girl or boy, they mature themselves They grow up into confident human beings where they refuse to compromise on their rights given to them under the Constitution, but let them reach the stage where they can understand what Constitution means to them. The fourth right that I'm saying is not to be a victim of a child marriage. Again, I'm not saying that, but I've seen it. People think that when they marry off their girl children, it will bring prosperity to the family. Khatij isn't famous for that. There are occasions sanctioned which are solemnized, even though the government and the administration is very strict about it. But yet people do it. When they're caught, then there are adverse repercussions. There are NGOs, women. How is Vishakha case came? How was it that Vishakha case came up? She had gone to those villages to enlighten the inhabitants of that particular village about the ills of child marriages, about the importance of education. Don't interfere in our culture and society. That was the answer. And that the punishment that they gave her, you are talking about it. And then when we talk about child marriage, I think it should be, the parents must make it clear to the daughter the importance of education and also the realization about what time she should marry, whom does she want to get married, whether she wants to get married or at all or not, whether she would want to make her career be settled, quote unquote, settled is not getting married. Settled is being in a position when one can look after oneself, when they possess of enough economic security that they can look after not merely themselves, but also the parents. That is the time when I will say that they are settled. When they know their mind, they are in a position to lay down their terms. These are the four rights in the natal family that I say a woman possesses, a girl child possesses. Then comes to matrimonial family. And matrimonial family, one of the things that I'm here, I do not know how many girls are listening to what I'm saying, but there is one thing that bothers us all. Justice Kumar is smiling, but I'm telling you, this is one thing that bothers us all. Why is there a compulsory matrimonial migration only for girls? Why is it? This is part of our custom. But we are told, oh, tujhe dusre ghar jana hai. This is something that is the biggest obstacle in the path of a girl child. You have to go, you belong to another family. And this belonging to another family takes away from us so many rights, even an affiliation with the natal family. You are told right from beginning, oh, you will get a very good husband. Good mothers say that. You get very good husband, you will be very happy. What you are not able to do right now, you will be able to do after marriage. So marriage and that family is projected as a fairy tale kind of a thing. Unfortunately, the reality is definitely not the same. They are also human beings. They are not, some people coming out of those fairy tales. So one of the problematic things is the girls have started questioning it also. Why should there be compulsory matrimonial migration for girls only? And look at the other side. If a boy is asked to live at the girl's house in a patriarchal society, he's called names. He's saying no respectable man will tolerate us. So I asked my mother, why is it? So she said, jokingly again, she said, I can feed you, but I cannot feed your husband. That may be one of the reasons, So because it's difficult to tackle a confident young man, who knows his mind and can express his opinion. I want this, I'm not happy with this. But with respect to a woman, she's told the ideals to be subjugated, adjust herself to the matrimonial requirements, and sometimes changing even the food habits. If she comes from a non-vegetarian family and the matrimonial family is vegetarian, it is expected of her that she will also adopt the same food habits. The same getting up in the morning and going to sleep at night, the behavior, the kind of a culture of the matrimonial family, because she becomes an integral part of it. Is it really the truth? Can someone become an integral part of another family so quickly? Because I have seen that matrimonial problems, want to ask questions, then I will not be able to finish it. So can we keep the questions at the end, please? I saw that chat. So the matrimonial
Yes, madam, sure.
In the matrimonial family, maximum problems arise in the beginning when there is a time for settling in. Now the girls were also confident now, and if you are used to a particular system for maybe 25 years, 26 years, and all of a sudden you are supposed to change it, there are bound to be some kinds of hiccups. They are bound to be, give her time to adjust if it is a must. Give her time and also see, does she have her own habits? The second, of course, the right is not to be a victim of dowry debts. Dowry expectations are still there. Even now, the value of a boy in the marriage market is still there. And even though we may not say that there is a cash demand or a household articles are usually brought by the daughter, by the girl. And then there are several subtle things. And one of the most unfortunate or important thing that is happening in our society, even though we may not be aware of it, is the legitimate expectation of the son-in-law from his father-in-law to help him financially to settle in business. That is still there. And says, you know, I have my elevation of status in the society will help your daughter. That is the same status that you can enjoy. And Justice Kumar, I'll be giving instances of certain cases. Please do not book me for contempt of court, because some of the cases are not really very nicely decided from my perspective. Now, this was a case that I regularly write for Indian Law Institute, Journal of, Annual Survey of Indian Law. And I was given this task of writing a piece on family law and succession. And what we write is we take the decisions. And if the decisions are very good, we say that, yes, why they are good. And it's a natural expectation from our enlightened judiciary. But if we find that they have been deeply patriarchal, or there has been a kind of a thing that may have a long repercussions which might not have been sought, because you may not know it, sir, judgments are widely read. Judgments are read by law students. They are discussed in conferences, and conferences having paralegal workers, conferences where people are not even literate. We go by your judgments because legislation is one. It is the implementation of the legislation that gives rise to it, and precedents are a very, very important source of judgment, of law. So judgments are cherishable. We discuss it all round. In fact, it will not be incorrect to say that in majority of the cases, we teach as a teacher judgments in the class, and good judgments and sometimes problematic judgments. So I beg your forgiveness in advance. Now, Kuldeep Singh versus State of Punjab was a case where the parties married, and then after marriage, the parties were blessed with a baby boy. 2.5 years later, the husband had a younger brother who was a good-for-nothing fellow and wanted to go to Canada so that he can make his future. And they fell prey to, or maybe they contacted some agent who demanded a huge sum of money. They did not have that kind of money. So the easiest convenient bank was the bride's father. And that bride was 2.5 years old, 3.5 years old, 2.5-year-old was the son. So they said, go and bring 50,000 from your father. And she said, I have a younger sister also to be married off. My father doesn't possess that kind of money. So the whole family connived, and then they, tortured her. Then even that didn't work. She did not speak to her father in direct tones, but said that, yes, there is a demand for money because the younger brother of the husband wanted to go abroad. Now then, the easiest trick that they can perform is, and which I'm really aghast at the reaction of the society, is they took the bride and the little baby and dumped her back to the parental place. I do not know why people feel ashamed if a married daughter having matrimonial problem comes back to the natal family. Where else will she go? Where else will she go? They are the parents who have given birth to that daughter. And if they cannot understand her agony, who else will? So when the daughter was dumped, the parents had a very, very bad reaction. Who said, no, she's married, she's your amanat, and then, she only her, dead body should come out of your place, and this and that. Okay. And the son-in-law said very clearly, till you pay us 50,000, we need that kind of money, the daughter is going to stay here. And the father gave an undertaking, said, no, please take her away. Please take her away, as if she's a rolling ball. Please take her away. We'll arrange it and I'm sure that we'll be able to give you within a week. A week passed, no money came through. And then unfortunately, or for whatever it may be, she died. And when she died, then the parents woke up to the darling daughter's loss. I blame the parents also. They knew fully well what was going to be the outcome. Yet, miraculous, they waited for a miracle, thinking that somebody will see sense. Now they said, you killed our daughter. They said, we didn't kill it. The matter went to the court, FIR was lodged and everything. And then a dowry demand was there. So they said, if this is not a dowry, first of all, the judge asked, he should not have asked. I'm sorry, I'm extremely sorry. The judge asked, how did she die? This was a suicide or this was a homicide? The matrimonial family said, she committed suicide. Why did she commit suicide? We tortured her. This is an evidence. We tortured her. Why did you torture her? She failed to bring rupees 50,000. And the next question was, why did you want 50,000? We wanted the younger brother to be sent to Canada for making a better future. Now look at this scenario, and this is a factual situation. It may be an isolated case, but it is an isolated case that made way to the law reports. But there may be several cases that were not able to make even to the police files like this. Even after the death of a daughter, parents, I do not know what is the kind of respect they think will come to their way. They do not want to disclose that she was in adverse circumstances. They want everyone to believe that she died a very happy death, natural death, and nobody tortured her. I do not know why this psychology, bad psychology. We should be very open. We should be very confident. Yes, our child is in trouble. We have to come to her rescue. That should be the case. But here what happened? They said the prosecution wanted it to be a dowry death. And they said it was a dowry demand. But the judge said no. And the words that he used was not, and they were not appropriate. They said, if after marriage, the son-in-law, in order to improve his status in the society or for settling, it was not son-in-law, it was son-in-law's younger brother, a good-for-nothing fellow, okay, who was the actual murderer, and the whole family. If he wants to advance in the society and he requests or demands money from his father-in-law, can it be called dowry? By no stretch of imagination it can be called dowry. It was not as if he was, allowed to go without a sentence, but it was a lesser sentence that was given to it under 498A and not 304B. But I feel that these legitimate expectations should not be documented in this particular manner in law reports where we found it. I read the whole judgment, and the pain that this one paragraph or these 2 lines inflicted on me, they were much more than reading the whole judgment that a woman lost her life. Lost her life. How can it be a legitimate demand of anyone to demand money from anybody else on the pretext of, or on the ground that your daughter, I have done a big obligation to you by getting married to your daughter? Now, that is what my problem is. So I say not to be a victim of dowry deaths. That is the second right. The third right is again, sir, marriage and career. After marriage, why is it that the career of a woman always takes a back seat in light of her matrimonial duties and obligations? Where are the matrimonial duties and obligations of the husband? Because he is supposed to be the provider. He is supposed to be the breadwinner. But still in the year 2022, now this judgment is of 2009, and that is of Supreme Court that I'm going to quote. But at the same time, 2009 is not 60 years back. 2009, we had the constitutional rights of employment also. But as far as a woman is concerned, apparently there appears to be a conflict between her matrimonial rights and her career aspirations. Now, assumption of matrimonial rights is not a part-time job. It's a full-time job. Ask me. I am a woman and I am a career-oriented and I am homemaker. I was living in a typical joint family. I brought up 2 children on my own of course, with the support of everyone. I'm really very grateful to my family for that and my husband for that. But it's not fun. It's not something, it's a very, very serious matter. You have two small lives, like I had two small lives, who were totally dependent on me, my children. Similarly, even before they are born, there are other members in the family who need care. There may be parents-in-law who may not be supportive, who may be very supportive. There may be parents-in-law who are young in age. Young in age means 50 is the new young now. So 50, maybe this age, or maybe they are considerably advanced age. The responsibility of looking after all the house, cooking, washing, utensils, clothes, cleaning, mopping, everything is on a woman. Now, domestic responsibilities, therefore, are a very, very big challenge in path of her career. I think I'll just go very, very quickly. Marriage and career, therefore, please, all you students who are listening to me, please read Suman Kapoor versus Sudhir Kapoor. It's a 2009 Supreme Court judgment where her marriage was dissolved on the ground that she failed to perform her matrimonial duties. In fact, the trial court judge said, she was so obsessed with her career that she neglected or failed to perform her matrimonial duties. I have only one question to ask. If it had been a man who was very much obsessed with his career and had failed to perform his matrimonial duties, you know what? He'll be garlanded at a public function for his dedication towards his career, and he'll bring from back his wife and say, behind my success is my wife, who took upon the matrimonial responsibilities and left me free to be in the service of the nation. Why can't the best brains be utilized by these nations? Only because they belong to a woman? Women are also intelligent. You have called me, you have not called a man, it's an even kind of a thing. But yes, why should women's brain not be utilized for the service of the nation? Why should they be, confined only to the domesticity? That is the third right, I say, matrimonial right. Fourth one, reproductive rights. 3 days back, the Supreme Court has come up with a very good judgment saying marital status is no hindrance. If a woman was in a live-in relationship, now there is a breakup, she is pregnant, she wants to terminate her pregnancy, she'll be allowed to. It's not as if only married women are. It's not only when women are in prisons, that Bombay High Court famous judgment that led to the whole debate about women's reproductive rights, a right to better hygiene, a right to better medical facilities, everything is there. Somebody wants to ask a question? Somebody raised their hand. Okay. Now, all these things are there. At the same time, when I look to the matrimonial conflict, I think in the worst situation is a married woman. Because a married woman always needs the support and the consent. When you write something, my eyes go there, and then there is a
Ma'am, we may take questions on a later stage once you are done with your address.
Yes, I have just a little time left with me. I think I have taken too much of Justice Kumar's time, then he's going to...
No, ma'am, once you are done, we may consider taking questions if there are any.
Yes. I'll just go through quickly. Okay.
Kindly continue.
Rights, when it comes to the conflict, when the husband doesn't want the termination of the pregnancy, he wants a baby, but the woman doesn't want, then it is not allowed. It is not allowed, because there are cases where the husband has gone to the court saying, I want divorce, wife is guilty of cruelty. Why? She terminated her pregnancy when I wanted a baby, and the court has agreed with him. Because the baby doesn't belong to the wife alone, though it is in her body, but it belongs to both. And a man is also emotionally like, I want a baby. So that reproductive rights has to be taken with a pinch of salt. Now, these are the 4 matrimonial rights. I'll come quickly to the rights in public of a woman. The first right that I think is, now there is one more right. This is the third one, I think. The fourth right is a right not to be a victim of domestic violence, a right not to be beaten up in a matrimonial family for failing to perform the matrimonial duties to the satisfaction of the in-laws. My law students, please read Vajresh Anvekar versus State of Karnataka. That is the 2013 judgment. It went to the Supreme Court where the husband had slapped the wife across the face for not getting up at 5 o'clock. And this was a jeweler's family, a very rich family, and not giving tea or maybe whatever, performing the household duties with such force that she lost one eye and there was a huge color on one side of the face. And when it came in, then I think within a period of 6 months, she had died also. The question was whether she was treated with cruelty or not. And they said, where a man, where the husband, the trial court had made an observation, asking her to get up at 5 a.m., be respectful to elders, be more inclined towards household works. Husband can beat her up. Can she? Will it amount to cruelty? No. But then the matter, when it went to Supreme Court, Justice Gyanshudha Mishra made very caustic comments on this particular aspect, said we do not expect it from the lower judiciary, these kinds of sentiments. Yesterday only there was a news item coming from UP, Ghaziabad. A drunken man drags wife by hair, threshes her in public, putting too much salt in the food. What is this? Should there be counseling classes for newly wedded men or, soon to be wed men about how they should treat their wives? Because we are still living, as far as marriage is concerned, in that 17th, 18th century. Ideal man, ideal woman, ideal man, nobody. No, we can do whatever we want. Ideal woman, what are her duties? What are her expectations? Her whole self is to be merged, and that. Hurriedly, I will go to rights of women, human rights of women in public sphere. A right to access public spaces, not out of necessity, but as of right. When we come to women really hesitate and avoid the peak hours rush. When there is a mix, except for ladies, special metros, coaches and everything, buses, trams, metros, parks, you will hardly find women only sitting out in the park. You will hardly find any group of girls playing cricket in the village field. It is all a man's domain. A park, public benches and everything. Public spaces should also be available to everyone, including women. If a woman is sitting there, well-dressed woman, people walking the road will pause and look at her closely as if she needs their permission to sit there and then walk away, maybe casting comments. Second right, not to be stopped. Men must learn to take no for an answer. Everyone must have seen that video clipping from Bihar, where a boy is waiting for a girl who comes back from coaching, takes out the pistol, then shoots her and then runs away. Why can't you say take no for an answer? Please take no for an answer. Do not shoot her. Do not spill acid on her. Do not assault her with knives. This is the third right. Fourth, a right of employment free from sexual harassment at workplace. Educational institutions are very important. We have researchers working under supervisors. A female researcher under a male supervisor, a male researcher under a female supervisor. We have all kinds of combinations. We have teachers and students in schools, in colleges, research institute. Then we have in office, private and public, domestic, legal, and even in domestic sphere, unorganized labor, legal, medical profession. This is the fourth right that I identify with women as far as right to public spaces are concerned. Two rights I have identified that should be with everyone, men or women. A right to self-sufficiency that is correlated to a right of employment. And not only self-sufficiency, what is the legitimate expectation from a woman is, there is a man, that is husband, who is going to take care of her financial needs. So she need not work. And this is the reason why we say her maintenance rights are very intact. And sometimes they are very harsh on men. They say she has not lived even for a day, and yet the man is being asked to part with a substantial amount of her salary to pay her. Now that is not something to be done. Self-sufficiency must be the norm for the hour of the day. Men and women both must be told to earn a living, and also not only that, don't stop at that. Use the income for their benefit. It is not as if a man's income is for the wife and the children, a woman's income is for the entire family. It is their right also to use with pleasure some of the money that they have earned. That I think is an identification of a woman right. And the last I see is, it is the right, not merely obligation, of everyone, daughter and son, to look after the parents in old age. If a married daughter wants to look after the parents in old age, she must be allowed to do that. If a son doesn't look after the parents in old age, what we do, we say provide this much of maintenance. But in old age, parents may not want money. They may have even more money than the son. What they want is physical hands to care. They want somebody to tell them that they are still wanted in this world, and their living will be of a considerable loss to them. This is a right that everybody should have, a daughter as well as a son. Thank you very much. Unfortunately, we live in a stage where we are talking about these issues, and I hope to see it the day where we can realize these issues. I have very limited time to have questions because I have a meeting to attend, sir. Please, so I really beg your forgiveness, Justice Kumar, to eat so much into your time. Please forgive me, but I'm saying I'm very fond of talking. Okay, and
Thank you so
Okay.
much, ma'am. Thank you so much for touching sensitive matters like female infanticide. Treating daughter as a child, a very great concept. I believe everyone should consider and think about matrimonial migration, victim of dowry death, and even matrimonial duties, which even a woman can equally take over. Very sensitive topics. It was a great discourse, ma'am. We feel privileged to have this opportunity to hear you. Thank you so much. Moving ahead, I request Dr. C.M. Rao, sir, to kindly deliver the presidential address. Over to you, sir.
Respected Professor Poonam Saxena Madam, Honorable Justice Kumar sir, and dear participants and student friends and my colleagues. It gives me immense pleasure to say a few words on this occasion. We heard about three things. If you are making dan, the sabse acha dan kanya dan. But how many people will know this particular thing? The first dan that is going to give to the Swarg is only kanya dan. The second one is Vijayadan. The third one is Annadan. Everybody talks about Annadan, but nobody bothers about Vijayadan or Kanyadan. Kanyadan. If I had a beti, if I had a daughter, if I am going to hand over my daughter to another family, that gives the punya what these people are thinking of a boy, a boy child, is more than that. Nobody aware of this fact. Out of all the particular danas, Kanyadan is considered to be the number one dan, which is in the hands of the parents who given birth to a girl child. But how many parents are aware of this fact? And at the same time, as Madam rightly pointed out, rule of law. Rules are there, but implementation. Where is the implementation of rules? Everything is there on the paper, but the moment it comes to implementation, there is a vacuum which is not in favor of the person who knocks the doors of justice. That is the problem in this society. Whether it is a male child or a girl child, it doesn't matter. As Madam rightly pointed, why the girl only should go to matrimonial migration? There are occasions who might have studied in Marumakattaina in Kerala. Even today, there are certain families in the border of Tamil Nadu. After marriage, they are going to the families of girl child. This is happening even today. One of my colleague from Aurangabad, now who is working in Ajmer, he married to a girl who belongs to Trichur, and he went to their family, leaving their elder father and mother. This is happening. It is not a new thing which Madam has told. Why the migration of a female only to be made after marriage? There are certain customary practices which were prevalent in southern India, which even today followed by the people when they married to a girl of a particular place where the female member is the kata of the family. They use it to move from the place to the place where the wife resides. And at the same time, it is the attitude. It is the attitude of the people. How you take a male is going to marry to a female after 20, 21 years or 25 years. They are coming to our houses by leaving their near and dear. And they are continue their life with us for almost all 70 to 80 years with us. and we are not caring for them. This is another thing to be taken care by us. So they are reposing confidence on us, but the male members are not having that confidence on the people whom they brought after marriage. This is another dimension which I would like to draw the attention of all the participants. And at the same time, I would like to, nowadays, wherever you see all the areas, now when you look into our college, there are 1,996 students pursuing 5 years course, 3 years course, LLM, PG diploma, out of which 728 are girls. 728 are girls. This is also an indication that women are coming forward to fight for their rights. They are not at homes. They are educated. They are properly educated. They are properly guided by the system which the society provides them. And as a result of which they are educated and they are fighting for their rights. And also they are also seeking the rights to be enforced for the betterment of their future. And at the same time, when you look into this particular college, where it was situated, in 2010, when I joined in this college, there are only hardly 5-6 women of Muslim girls are studying. Now, more than 100 girls are studying law. This is because of the awareness among the public that law is a course where we can learn something for the betterment of our future. So these programs is a tool for the people to learn what is there for them for their future endeavors. And at the same time, I would like to draw the attention of all the dignitaries and also the people who participate in this program. So the awareness, human rights. We talk about the human rights of women, but at the same time, a woman, a sasu, a mother-in-law is also thinking of bad of daughter-in-law, but she thinks that her daughter should be properly treated in another house. When you are not properly treating the other's daughter in your house properly, how can you expect the same thing from other family? This is the thing. The particular serials, the particular cinemas, all these things also going to spoil the mind of the particular woman. And as a result of that, I firmly believe on the particular Chinese project. What you see, it will be in your mind forever. What you heard, what you listen, you can miss that particular thing while you are going to pass the time. But at the same time, you have to think of a woman against another woman. You talk about women's rights, right? Which you agree, as a male member, which you agree that you have a right. But what about the women also destroying the rights of other women? As a mother-in-law, as a colleague, as a fellow neighbor. So always fight for the rights. So this particular thing is also going to be disturbing the particular women rights in the society. Human rights means only the other gender is disturbing your rights. But at the same time, as my observation of 35 years of in teaching, so it is women against women also a problem in the society. If that particular attitude of women and male are not proper, the human rights are in trouble. This is my observation in my 25 years. All the students who are pursuing their courses, any course, if you are properly educated, if you are properly guided by your parents, teachers, and your fellow neighbors, definitely you will be the #1 in this society. If in the process of that particular learning or nurturing by the society, if something goes wrong, that is the place where human rights are going to be coming to picture. This is my observation. And with this little observation, I thank Professor Onamukse Saxena Madam and also Justice M.M. Kumar for giving me the opportunity in this particular August gathering. Thank you, one and all.
Thank you so much, sir.
I'm sorry, but I
Moving
cannot
ahead.
stop myself. I cannot stop myself from making a comment here, sir. Professor Rao, with deep humility and respect, I would beg to differ from you that women
Okay.
is the worst enemy of women. It is a human being who is the worst enemy of other fellow human being. Take it like
Agree.
that. Do not
Ag-
isolate women also, because men are also enemies of men, but nobody speaks about them. But whenever we
Yes.
talk about women's rights, we say, men are friendly, they are easy to be approached by women, but women is the worst enemy of women. No, a mother-daughter will never fight. A father-son may, but a mother-daughter will not. It's only when a man comes in between, a mother-in-law and a daughter-in-law, then the fight arises. So
No,
let's not say that.
Miss
Let's say that
Shivani,
a human
Shivani
being,
madam,
has a
let me
difference with
clarify.
another
Let me
human
clarify.
being.
Let me clarify.
I
When
think
a
it
male,
is the
when a male and female is together, nothing will happen. If a
So
third
everybody
person
is an
comes, then
enemy of
only the
another,
problem
sir.
will come. Then only the problem will come. When the third
Even for parking space, neighbors are fighting with each other who should ordinarily come with each other. So everyone is a enemy of another when it comes to kind of a sense of entitlement
Yes,
about their
yes,
rights
I
and
do
the
agree, madam.
vindication of
I
that.
do agree.
So it's
Thank
not
you.
merely a woman is the worst enemy of women. That's a patriarchal thing that used to be. We were made fool of by coming
No,
saying that.
no.
Look
I
at
am not
yourself,
saying
you
there
are
are
that. No.
occasions. There are occasions where something is happening against women also by the women. I'm not saying. I'm not 100% sure of it. Thank you.
very well.
Okay, moving ahead, I would like to call upon Komal Aher to give a brief introduction of our today's guest of honor, Honorable Justice M.M. Kumar, sir.
Thank you, Neetal. Chief Justice M.M. Kumar sir has an illustrious academic professional record. He qualified his LLB degree from Punjab University. He went to England in 1979 for higher studies and qualified for LLM from the University of Birmingham. After returning to India, he resumed his practice at Punjab and Haryana High Court at Chandigarh. He authored a book titled Control of Exclusion Clauses in India and England, published by Ravenswood, London. He was elected as Vice President of the Punjab and Haryana High Court Bar Association and later appointed as Additional Advocate General, Punjab. Sir was evaluated as a judge of Punjab and Haryana High Court at Chandigarh. Sir worked as Executive Chairman, Legal Service Authority and Chairman, Mediation Committee. During his tenure as a judge of Punjab and Haryana High Court, he delivered a large number of landmark judgments in every branch of law. Sir has made significant contribution to build the Chandigarh Judicial Academy and the Rajiv Gandhi National Law University, Patiala. Later, Sir was appointed as Chief Justice of Jammu and Kashmir High Court. As Chief Justice of Jammu and Kashmir High Court, dealt with many PIL concerning world-famous Dal Lake, violation of Master Plan in Srinagar, Jammu and Katra, corruption cases, popularized use of video conferencing, mega lok adalats, and number of other projects. After retirement, Sir conducted a number of commercial arbitrations, which included the cases referred by Honorable Supreme Court and the High Courts. Sir then took over the charge of as Chairman Company Law Board. He was then appointed as the first President of National Company Law Tribunal on abolition of Company Law Board. During his tenure, 28 benches of the NCLT started functioning from 14 states. Thereafter, he resumed his arbitration and consultancy practice in New Delhi. He joined the NHRC as member on June 2, 2021. Thank you.
Thank you, Komal. Without any further ado, and taking this privilege, I would like to call upon Honorable M.M. Kumar, sir, to address the gathering with the inaugural speech. Over to you, sir.
Thank you. Professor Poonam Saxena, Honorable the Vice Chancellor of NLU Jodhpur, Dr. C.M. Rao, Principal MANIKCHAND, PAHADE Law College. Dr. Banerjee, Professor of Law, who will be taking up the first technical session on human rights. Ms. Rama Sarode, Advocate, who will be taking up the second session of the seminar, Violence Against Women. Then Ms. Soma Bhattacharya, third session, Women and Legislation. And fourth session by Dr. Jyoti Bhakhare, Professor, Department of Law, Pune University, Women and Health. Friends, National Human Rights Commission has been in the service of protecting the human rights all over the countries. We co-host, we sponsor these programs in our effort to reach out to the last person in the queue. And in our efforts, we have succeeded to some extent, but a lot of work is still to be done. If you visit National Human Rights Commission any day, I will show you the complaints depicting the grim situation on the ground. Minor child rape, and in some cases murder. At least I deal with 3-4 cases every day. Other type of sexual harassment. The sexual harassment of women at police station. I start feeling that we are living in a society where there is no sensitization as if it is a police state. I'm reminded of a case which came from Andhra Pradesh. And look at the atrocities. A minor girl of 12 raped. The rapist kept her dead body in his own house. The girl was not to be traced. Eventually, the police was able to find the dead body and the rapist absconded. On the top of that, another ugly aspect of this case is one minister on the housetop, he started shouting that we will have this man killed in false encounter. And next day, after we issue notice, next day we read in the news that his dead body was found on the railway track. What is all this happening? Where we are heading? And the concern noted by Professor Saxena, Poonam Saxena, I think, is very, very appropriate and needs to be redressed. NHRC has been making tremendous efforts in that direction. The friends, United Nations Declaration of Human Rights came. India has its own contribution in amending the declaration. The declaration was framed to start with all men are born free and equal in dignity and rights. We have Madam Hansa Mehta, as a member, she intervened and proposed that instead of all men, the word should be all human beings. And it was unanimously accepted. That is what you read, the Universal Declaration of Human Rights, which was adopted by the United Nations General Assembly in Paris on 10th of December 1948. Our record in the area of women's rights is glorious. If you talk of right to vote, we were even ahead of England in granting right to vote to our women. But as rightly said by Madam Saxena, large number of laws which are on the statute books, they are not implemented on the ground. And these are the social problems, these are the social issues we need today. Somebody like Raja Raman Roy, somebody like Guru Nanak, Kabir, who may instill that spirit to change the social mindset. Why a bridegroom should go to the groom house, why she should be subjected to cruelty, why she should be asked to adjust after 25-30 years of her life in parent house. All these are very relevant questions. I have 2 daughters and I know the way I have gone through some of the stages. So friends, there are large number of, there is no dearth of law. There is no dearth of judgment. Madam has pointed out a judgment of the Kuldeep Singh versus State of Punjab, that instead of 304B, 498A was invoked. Fine. But I tell you another judgment. Shard Birdi Chand versus State of Maharashtra, 1985 Supreme Court. Justice Fazil Ali. The person having been convicted by all the courts, Supreme Court starts discussing the evidence threadbare and record acquittal. It was a case of dowry death. There was cogent evidence. Many a time I criticize this judgment. I was teaching in the law department, Punjab University from 1984 to 90 and had the occasion to deal with such like cases for the benefit of my students. Satya versus Teja Singh, another judgment, 1975 Supreme Court. There are so many judgments. I share with you another judgment which I delivered sitting with my colleague Justice Ritu Bhari. The question arose before us that when the state of Haryana made recruitment of school lecturers, they made a reservation for women to the extent of 33%. A number of women came to the court saying that the male person who have been appointed have far less merit than the petitioner before the court. On examination, we found that the reservation was 33% for women, and that 67% reservation is not for the men. Therefore, we issue direction as per the various judgments of the Supreme Court that whenever reservation is made, then the first thing to do is prepare the list according to merit. Whosoever comes in merit on 67% open list, they should be taken whether male or female, because reservation was only for women. Then give 33%. Can you believe? The judgment was not implemented. Contempt petition filed in Rajya Sabha. All the female MPs cutting across the party line discussed this judgment. Frontline carried a huge article. Eventually, the state of Haryana has to give way. So this is the patent inherent prejudice against the women's rights. This is the mindset with regard to the women's rights. I was heading the Legal Services Authority, and in Punjab, the sex ratio between the male and female was dismal low, 823 against 1000. Despite PNDT Act, the sex ratio was declining. Fatehgarh Sahib district was the lowest. We conducted series of seminars. In one seminar, the then Chief Justice of India, Justice Sabharwal, Y.K. Sabharwal, came, and at Patiala, we had a gathering of about 20,000. All people coming from villages. And can you believe the Chief Justice of India delivered his address in Punjabi so that he may be able to reach out to those who were attending the conference from various villages. These things have its impact. In Haryana, we held a seminar in the presence of the Chief Minister of Haryana, and the sex ratio later improved. It is now 902 to 1000. Even still it is low, but it is much better than 800 something. In the seminar at Karnal, where the Chief Minister was present, I raised an issue that you talk of spirituality, Vedas, that the sun is required for performing the last rites, etc., etc. I ask a question, and can the Chief Minister name the grandfather of his grandfather? You are talking of ancestral. You are talking of becoming immortal. You are talking of spirituality. The answer was no. Who would remember the name of grandfather of his grandfather? These are inbuilt prejudices which are continuing in society. These law cannot teach. Although it is said that pulse of the people beats in the parliament, but when the parliament framed law for the whole society, for the nation. But the weaknesses of the law are tested in the hands of those who have taken oath. And then the interpretation process is start. This is the interpretation process by which a judge can even mold the law to have a correctional effect on the society. I am happy that you have kept a session on the legislation, human rights and legislation. I tried to prepare a list of various fundamental rights, Article 14, 15, 16, 19 and 21. These are all embracing fundamental rights, and many of them constitute basic structure of the Constitution. The important legislation which I would like to highlight is, and which are aimed to protect the rights of women. Protection of Women from Domestic Violence Act 2005. Under this act, a woman can approach the court for living in matrimonial home. The Immoral Traffic Prevention Act 1986. Indecent Representation of Women Prohibition Act 1986. Dowry Prohibition Act is now very old, very well known. Maternity Benefit Act 1961, both are 1961. Medical Termination of Pregnancy Act 1971. Preconception and Prenatal Diagnostic Technique Act 1994. Muslim women as a co-partner of the HUF. Then sexual harassment of women and workplaces. After Vishakha guidelines, this act was framed. And with regard to PNDT Act, I would like to share my experience in Punjab. Under the aegis of the Legal Services Authority, we framed a scheme. In every village, whenever a pregnancy takes place, registration of the woman for the purposes of providing nutrition, for the purpose of providing medical aid, was made compulsory. And then follow up to the time of delivery, and then taking care of the child. Paralegal volunteers were also deputed to ensure that the scheme attains success. Because once a female is registered, then it is very difficult to terminate the pregnancy on the basis of sex determination. Then the accused are going to face prosecution. And then huge control on the diagnostic center was also practiced. It is true that, place like Gujarat is a paradise for PNDT, for having surrogacy. All types of things happen there. But still, the law has taken some measure to control it, and I would say that the fear of law has gripped many, and there is prevention also. Then the amendment in the Hindu Succession Act, I think, goes all the way. If you read the judgment in 2020, Vanita Sharma versus Rakesh Sharma, the Supreme Court held that the daughters have equal co-partnership rights in HUF. The court held that the right arises by taking birth. When a daughter is born, she also steps into the co-partnership as that of a son. However, a daughter born before can claim these rights only with effect from the date of the amendment, that is 9 September 2005, with saving of past transaction as provided in proviso to section 6 within bracket 1 read with section 6 within bracket 5. The court clarified that since the right in co-partnership is by birth, father co-partner does not need to be living as on 9/9/2005. This is a very, very important landmark judgment. Then Vishakha, all of you know, Vishakha has now merged into the 2013 Act. Vishakha guidelines are no longer relevant in that sense, but 2013 Act has gone much further. Then we have, I would also highlight 3-4 more judgment. Lakshmi versus Union of India, 2006, acid attack. Lakshmi, an acid attack victim, filed a petition seeking measure to regulate the sale of acid and provide adequate compensation to the victim. Taking cognizance of the number of cases relating to acid attack against women on the rise, the Supreme Court imposed stringent regulation on the sale of acid in 2013. The ruling banned over-the-counter sale of acid. Dealers can sell the acid only if the buyer provides a valid identity proof and states the need for purchase. I wonder whether regulating the acid sale could prevent a jilted lover or a completely depressed person to attack the victim. That is why I right in the beginning said that we need social leaders, we need moralists, we need existence, the person with vision, whom the general masses may listen. If you study the history, whenever a saint came and tried to spread the message of social reforms, that message remained effective, say for 50 years, 100 years, 150 years. But human nature is such that pendulum is made to swing on one side for some time, and human nature compels it to come back to the same position after some time. People visit the holy places, temples, gurdwara, churches, but for a little while they start thinking otherwise, according to the precepts, according to the exhortations of the priest. But after 15 minutes, 20 minutes, a day, all vanish. So this is required to be inculcated regularly. It is required to be inculcated in the family setup. Unless these social changes come, the type of mentality displayed by the by the crime, by the criminals, and making victim of their crime to young girls and to female would not stop. Laws are there, but the implementation is very poor on the ground. I would also cite one more judgment in the case of Babita Punia, the Secretary Ministry of Defense versus Babita Punia. It is a progressive judgment breaking the glass ceiling in the Indian Army. The Supreme Court in this case said that all women army officers are eligible to be appointed in commanding roles and are also entitled to permanent commissions. The court further said the submission made by the Ministry of Defense are based on sex stereotypes promised on assumption about socially ascribed roles of gender which discriminate against women, underlying the statement that it is a greater challenge for women officers to meet the hazards of service owing to their prolonged absence during pregnancy, motherhood, and domestic obligation toward their children and family is a strong stereotype which assumes that domestic obligation rests solely on women. The court held that such notions are flawed and are in clear violation of Article 14 of the Constitution. The judgment shall always be celebrated, which pave the way for gender equality in defense services. This is Justice Chandrachud, I think. Then, State of Rajasthan versus the State of Rajasthan versus S. They have not deliberately given the name. A girl was sexually assaulted and she unfortunately conceived. She filed a petition seeking permission for termination of pregnancy. The medical board was of the opinion that there was serious threat to the mother if the pregnancy is terminated. However, a single judge of the Rajasthan High Court held that the fetus in the womb has a right to life as enshrined under Article 21 of the Constitution. When the matter appealed to the division bench, the bench set aside the judgment of the single bench and held there is no doubt that a woman's right to make reproductive choices is also a dimension of personal liberty, as understood under Article 21 of the Constitution. It is important to recognize that reproductive choices can be exercised to reprocreate as well as abstain from procreating. The crucial consideration is that a woman's right to privacy, dignity, and bodily integrity should be respected. This means that there should be no restriction whatsoever on the exercise of reproductive choices, such as a woman's right to refuse participation in the sexual activity or alternatively the insistent on the use of contraceptive methods. So such are the progressive judgments which Madam Poonam Saxena has also highlighted, that these choices should not be curbed in any manner. There are so many other 2020, Shahrabano versus Union of India 2017, court declared the practice of instant triple talaq against the basic tenets of the Quran. Talaq-e-bidat is a practice which gives a man the right to divorce his wife by uttering talaq 3 times in one sitting without his wife's consent. So some of the judgment I have highlighted, few pieces of legislation I have pointed out. I am sure in the seminar, 4 sessions you have kept, you will discuss other various aspects and let there be realization by everybody that women today cannot be enslaved, cannot be restricted cannot be stopped from reaching to the top. NHRC conducts an internship program comprising of 75 students from all over the countries. We invite applications, and I get a chance to address these students. Can you believe that out of 75, 63, 62 would always be the girls? When I was teaching in the law department at Chandigarh, out of 100, 65, 68 would be the girls, if we go by percentage. So girls are showing their power, intellectual power, their mental power, and we must recognize it. There is no dearth of talent, and the girls should not be restricted by showing them that they are to be in the domestic area more and more. They are to be in the kitchen. They must be allowed to flower to the best of their ability, to their capacity. And the basic object of NHRC is to bring this awareness that let us facilitate the women rights to the optimum, so that 50% population, almost 50% population of this country, which is women, they are empowered. And if the woman is empowered, 3 generations are empowered. You will have, if a family is the unit of the society, then by empowering a female, you are empowering all the children which are likely to come. I express my gratitude to the chairperson of NHRC and the MANIKCHAND PAHADE institution, MANIKCHAND PAHADE Law College, for providing me this opportunity to share my views with you. Finally, hold more and more seminar. We are there to support you. We are there to help you in whatever manner you like. Thank you so much.
Thank you, sir.
Thank you so much, sir, for your address. Moving ahead, I would like to call upon Aparna Kotapalle ma'am to propose the vote of thanks.
Thank you, Nitin. Honorable Justice M.M. Kumar, sir. Honorable Vice Chancellor, Srimati Poonam Pradhan Saxena, ma'am. Our beloved Principal, Dr. C.M. Rao, sir. And the August gathering. I feel privileged to stand before you to propose vote of thanks for this inaugural session. Many times it so happens that we dream of having interaction with the luminaries, legal luminaries. We dream of having interaction with honorable judiciary. And I feel on behalf of our college, I feel on behalf of our students, I feel that today is the day when we feel that our dream has come true. Let me first of all thank Honorable Justice M.M. Kumar, sir, for being with us, for inaugurating this training program and guiding the participants in such a beautiful way that we feel that, yes, we are committed towards training the society being gender neutral. I am also thankful to Honorable Professor Poonam Pradhan Saxena, ma'am, who has not only shared her views but enlightened the participants with this 4+4+4+2 rights that are there with women. And of course, I would say that with the blend of both the legal luminaries to whom we have heard today, now we understand the role of judiciary. We have found the plethora of judgments from the content from Honorable Justice Kumar sir, as well as Madam Poonam Pradhan Saxena, and certainly the law students as well as law faculty who are attending this training program certainly will go into the depth of those judgments. So thank you very much to both of you, Honorable Justice M.M. Kumar sir and Honorable Shrimati Professor Poonam Pradhan Saxena, Vice Chancellor of Jodhpur NLU. I'm thankful to Dr. C.M. Rao sir, a Principal MP Law College, for his presidential address. Before proceeding ahead with the vote of thanks to others who were the part of this inaugural session, I would be failing in my duties if I don't express my gratitude towards NHRC. We are really grateful to NHRC for not only sponsoring this event, but they were the continuous support and guidance for conducting this event. And hence, we are thankful to National Human Rights Commission for the same. And with the words of Honorable Justice Kumar sir, we are further inspired to continue with the seminar and other activities in support and collaboration with NHRC. Thank you so much. Further, proceeding ahead with this inaugural session's vote of thanks proposing, I would like to thank Mr. S.N. More, sir, Vice Principal of MP Law College, for the welcome address. I'm also thankful to Shrimati Dr. S.S. Barhate ma'am, for who is a coordinator of this training program, for introducing the event. We are also thankful to Netal, Sejal, and Komal for very nicely conducting and introducing the guests of this event. I am thankful to all the participants for their active participation during this inaugural session. And I consider that this training program will certainly inspire all of us to train the society leading towards gender neutrality. I'm thankful to the organizers for giving me this opportunity to propose vote of thanks for the inaugural session. Thank you so much. Jai Hind. Over to you, Nita.
Thank you so much, ma'am. With the permission of dignitaries, I would here like to conclude the inaugural session and hand over the charge of the first session to my dear friend, Govinda Zalde. The next session will be based on rights of women, which will be delivered by Advocate Rama Sarode, advocate and human rights activist, Pune. Thank you everyone for joining for the inaugural session, and now we'll be proceeding with our first session shortly. Thank you.
Dear participants, it is kind request to stay tuned with us. Within 2 minutes, a resource person of the next session will be joining with us.
Anchor, get ready. Madam आ गए.
Thank you, Netal. Greetings to everyone. I, Govinda Zhate, student of BLLB4, cordially welcome all the dignitaries and attendees on behalf of MLNG Society's MANIKCHAND PAHADE Law College, Aurangabad. We are gathered here for the first session of online national level training program on correlating women rights and human rights, a human developmental approach, organized by MLNG Society's MANIKCHAND PAHADE Law College, in collaboration with National Human Rights Commission, New Delhi. Our first session deals with
Your
rights
voice
of
is
women.
breaking. When your voice is breaking.
Okay. Am I audible, sir, right now? Sir, am
Go
I
ahead.
audible now? Okay, sir. We are gathered here for first session of online national level training program on correlating women rights and human rights, a human developmental approach, organized by MLNGE Society's MANIKCHAND PAHADE Law College in collaboration with National Human Rights Commission, New Delhi. Our first session deals with rights of women, and to address us on this topic, we have today's resource person of this session, Advocate Rama Sarode ma'am. I request Dr. Abhay Zadal sir to kindly introduce the theme of this session. Over to you, sir.
Thank you, Govinda. Let me first welcome to the first session of this online program on correlating the women rights and human rights, human right development approach. In the first session, we have with us a person who is known for as being a human right activist from the Pune, Advocate Rama Saroda ma'am. And the theme of the session is the women's rights. I think you all maybe agree with my statement that a woman is known for the duties than that of a right. A woman is always being known for performing her duties than exercising the rights. No doubt there are many legislation, many people have tried at best to protect the rights of women in the form of feminist jurisprudence, but still we are lagging behind in order to protect the rights of women. The theme of this first session, the rights of women, if you see the woman being one of the victim of the society, I must say, woman being the one of the greatest victim of the society, as she everywhere in every sphere she has to compromise. There are many efforts taken place, not only in, because this is not just a local issue, this is not a country issue, this is the global issue. So now the time has come to create an awareness about the rights of women, and time has come to actually protect the rights of the women. So there are many efforts took place at international level, even the United Nations to the CEDAW, one of the important convention on the protection of the rights of the woman. Because she is also human. She should be treated like a human at par with the men. So there are many reasons behind non-protection of the women's rights specifically, but at international level, such kind of a convention, which is a good example of having a law has come forward to protect the rights of women at the international level. Coming back to the fundamental law of our country, the Constitution of India has also expressly provided and protected the rights of women. Coming back to the National Commission for Women, National Commission for Women is there. That is a statutory body in India, which has been bestowed with a function to protect the rights of a woman. In introductory part, just I wanted to tell you all that today's resource person, who is, and I must share that I had been associated when I was a LLM student in Pune. I had been associated with the Advocate Rama Saroda ma'am and Nasim Saroda sir. So it was really a great experience, because to understand the rights of women, we should have to, or we can understood it better those from the persons who are actively involved in protecting the rights of such persons. So today's research person, Advocate Ramaswada ma'am, she would be interacting with you all. I'm sure that, I assure you that this would be a great intellectual feast for all of us to listen her. And because she always act for the protection of women rights. So with this, I once again I welcome you all, including Advocate Ramaswada ma'am, for this first online session. And with this short introductory speech, I stop over here. Thank you.
Thank you, sir. I'm extremely overwhelmed to get this opportunity to introduce our resource person for this session, Advocate Rama Sarodhe, on this national level training program. Advocate Rama Sarodhe ma'am is a well-known advocate, human rights activist. Ma'am is also director of MGZ EduTech Private Limited. Ma'am is well-known advocate and trainer in the area of prevention of sexual harassment at workplace, child abuse, juvenile justice, public interest litigation, socio-legal training programs. Ma'am completed her BA from Rani Parvati Devi Arts College and secured first rank in the subject of history in final year. Later, ma'am pursued her law degree from ILS College, Pune, and secured third rank in Pune University. Also, ma'am completed her LLM from Pune University. Thereafter, ma'am completed her internship at Self-Employed Women's Association, Ahmedabad in 2003 and National Center of Advocacy Studies in 2004. Advocate Rama Sarodhe ma'am has experience of more than 20 years in human rights and especially women and child rights. Ma'am has worked as external member with 15 plus organizations for prevention of sexual harassment at workplace and is also member of local committee for Pune district. Ma'am has conducted various training programs for judges at Maharashtra Judicial Academy, even for police at Police Training Center in Daun and Lonavala, paralegal training program for prisoners of Yerwada Central Prison. Ma'am was a recipient to many awards, to name a few: National Gandhi Forum Award for Excellence in Social Work in the year 2013, Achievers Award for Sundarji Institute, Sarthak Puraskar by Bal Vrunda Foundation in 2014, Rotary Navdurga Award in 2019, Swayam Siddha Samajik Award in 2020. There are few instructions for all the attendees. All the attendees are requested to kindly keep your camera and mic off for better connectivity. I request all the attendees that if they have any question, please put them in chat box. Your queries will be answered right after address of the resource person. Without any further ado, I request respected Rama Sarodhe ma'am to please enlighten us on the topic. Over to you, ma'am.
Thank you so much for having me here for this session to talk about women's right. I congratulate MP Law College for conducting this kind of program, to discuss the various aspects of human rights. And I think that's much needed. While I will talk about certain laws related to women's rights, I am also going to bring in a lot of experience from the field of having worked with women. So in the last 20 plus years that I have worked as a lawyer, I'm not a litigating lawyer, I must say that. I'm more of a trainer. But I think the beauty of my work is that I do deal with cases of mostly women and children. And I get to take that experience of actually handling cases and the challenges that we have of dealing with those cases to the people who are actually implementing the laws, be it various officers, because I work very closely with the Women and Child Development Department, be it officers from that department, or be it police, or sometimes, we get an opportunity to interact with judges, with students. So with activists who are working at the ground level. So I think it's a combination of the learnings from the field that I apply to the cases, and what I apply to the cases back to people who are implementing the law. So I'm going to be talking mostly from those experiences. But having said that, I think we need to understand that It was in the year 1975 that we declared it as a decade for women. And since then we have, I mean, when we say we, it's the United Nations and a lot of countries, kind of joined that. Just as we have joined them in the millennial goals that we have to attend. So I think a lot of changes started happening post that. I'm not saying that there was no women's movement before that. In 1995, it was Hillary Clinton, in the Beijing conference, who said that women's rights are human rights. And I think that became a big hit. Not that women's rights were not considered as human rights before that. I think the entire exercise of even having the decade especially dedicated for women from that declaration that came about in 1975 was important. And there were these waves, the feminism, the first wave of feminism, the second wave of feminism, that did bring in a certain contribution towards women right. For example, started way back in the 19th century, where the first wave of feminism was more about talking about ending suffrage, getting women the right to vote. And that was a struggle back then during the first wave of feminism. The second wave of feminism started talking about that women are not confined merely to take care of families, and women have more rights than that. And that's where the discussion about domestic violence and trafficking kind of issues started coming in the second wave of feminism. It also started with this whole criticism against the Miss America pageant, where the whole concept of objectifying women started happening. The third wave of feminism brought in some kind of local, national level or transnational level kind of changes, where recognition of rights of women in the second wave was more about reproductive health rights. In the third wave, we see that individualism of women and the entire diversity, how women need to be a part of that diversity, started being discussed. And I must say, I mean, if you look at the corporates now, diversity, equity, and inclusion is a buzzword these days. And we say that, and look at the gender gap report. I mean, we have a long way to go, I would say. Even in the gender gap report, if you compare to our ranking, in 2020 as compared to 2021, we've moved down in our ranking in 2021. There is still a lot of work, I would say, that we need to do when it comes to women's right. But yeah, the fight goes on, and it's been going on for a long time. We take 2 steps forward in doing something, we take 4 steps backward, again with some kind of an impact that impacts the women, I would say. And that has been the scene for many decades and many centuries now. But we need to relate this to the contemporary issues that we still have, and we need to relate it to how it has been translating in terms of its implementation. How has the judiciary been a part of this entire thing? While there have been some good judgments, there have also been a lot of myths around women's right, and there have also been certain judgments that has taken us, backwards. So we will have to look at all of this, I would say. Another experience that, I mean, I kind of correlate when you see why is a particular law come into place, and when you look at a little bit of its history, you would see that, at least I think so, and you can feel to pitch in your ideas if you have something else as an idea. But I have always observed this, that a law related to women has come in only when as a response to some kind of an incident that has happened. And I think that is very unfortunate, because which just indicates that we do not have the foresight to think of what is the possible situation that a woman is going through as a vulnerable category, I would say. Vulnerable category, the United Nations has also accepted it as a vulnerable category. And we also, in our constitution, while we talk of right to equality, we do have a positive discrimination that we talk of. And women are considered to fall under that category. And that is why we are allowed to have certain laws specifically that are gender specific. And we do have certain laws that are very gender specific. And that's the reason, because when we talk of equality, it has to be among equals. And definitely when you compare men and women, we are definitely not equal, though we do have some fancy ways of telling that khande se khanda milakar chal rahi hai, and kisi se kam nahi hai, and all that. There have been so many instances where you see that women have got opportunities pretty late. Look at NDA. This is the first year that women are allowed to give exams for NDA and be a part of armed forces through NDA. It took us so many years for them to decide that women are capable of getting into NDA. Look at the person who heads SEBI. We got a first woman to head SEBI recently. Till then, do we think that we didn't have women who are intellectual enough to head an organization like SEBI? I don't think so. That's not true. And yet those opportunities were not given. Look at the number of women we have in the judiciary. So how many years did we take for women to go up there at the Supreme Court and be a judge in the Supreme Court? How many women do we have as parliamentarians? How many women do we have as CEOs and at important positions? So yeah, we have a long way to go, and let's accept that. Only when we accept that, I think will we be able to bring a change in our attitude, in the way we look at women, and the way we look at laws that are specifically made for women, right? So I was saying that every law that has come, especially which is very gender specific, has come as a response to incidents most times, I would say. So look at the change that we got in the Evidence Act, where they said that the onus of proving that a sexual violence is non-consensual, when the woman says it's non-consensual, the burden of proof is not on her, but the burden of proof is on accused. We got this change made in the Evidence Act only after Mathura case happened. So what was Mathura's case? Mathura's case was where a young Adivasi girl, where the family thought that she's going to elope and run away and get married to somebody, and they didn't approve of that, went and told the police that, warn her, usko kuch samajh do, so that she doesn't run away and get married. And what happened when she was taken to the police station? The men in uniform gang raped her, and the court said that it was consensual only because she did not retaliate to that gang rape. Imagine the power imbalance in the power equation, both physically as well as in terms of one Adivasi girl and police, I mean men in uniform raping her, and even in terms of her strength physically to stop them from raping her. It was only after the women's group really protested that the change in the Evidence Act really happened. Or look at how did section 498A come about, or how did the section for dowry death come about. It was only when the numbers of women dying after getting married, soon after getting married, went up, and the idea was to stop those deaths from happening for dowry, rather than letting them die and then call it a murder, is when the whole discussion around including section 498A to stop cruelty from the in-laws came in, or the recognition for dowry that came in, that if there's a suspicious death happening within 7 years of getting married, then so then you call that a dowry death. So these are changes that came in because of the situations that were happening around in our society. So when we talk of women's right, it is not just the law that we are talking about. Look at the cultural context we bring in, look at the social context we bring in, look at the political context we bring in. Sometimes there are certain laws that are made just to appease, and they really don't have the kind of meaning that it should have to stop violence against women. If we really meant to stop violence against women, year after year, year after year, the NCRB report would not be saying that 80% rise in cases of violence against women, 85% rise in cases of violence against women. So if our laws are so good and they're implemented so well, then why is there a rise of violence against women is a question that always disturbs me. And that is because we have not really been very successful in applying or in implementing it in the real sense, or sometimes the political will to make that law in a way that there are no loopholes, or probably it would be a utopian idea to say that a law is without a loophole, with lesser loopholes, I would say, where that really protects the rights of the women, has not really happened. Because it's not just the lawmakers, it is also people who implement it, is also how it is presented to the judiciary, it is also whether we are sensible enough and sensitive enough to understand women's right from these various angles, and not just look at it from the literal interpretation of the law, but do we understand it from the cultural context, do we understand it from the social context, do we understand it from the political context, and do we understand that each case is different, and each case will come with a different questions that it's addressing, and we cannot give a cookie cutter treatment to these cases, and we will have to look at every case independently and see what is the requirement in that particular case. Sometimes we have failed in doing that, and unfortunately women's right, some of these rights, when they get violated, are a violation of fundamental rights. But you go with this argument to the trial courts, you go with this argument to the courts that are not high courts and not supreme courts, they will say, oh, don't talk to us about fundamental rights here. Fundamental rights, you go to the high court and supreme court. We have kind of compartmentalized all of this, which I think is the sad part too. When I'm fighting a case of domestic violence, and when I'm representing a woman in a case of domestic violence, her fundamental rights are violated. A fundamental right to equality is violated, a fundamental right to life, a dignified life, is violated. But if we are not going to talk about it, and we are not allowed to talk about it, saying that you can't bring in fundamental rights when you're fighting cases like that, we are not able to translate, and see a bigger picture where women's right, when we're talking of women's right, it is fundamental rights too. We are not able to do that, and that, I think, is a sad part in our entire system. We need to go beyond the literal interpretation of every law to look at the objective of the law. And as law students, I would say that don't just start reading the law from section 1. I would say start reading the law from its reasoning and objects, because that is where you get to understand the purpose of that law. If you don't understand the purpose of that law, we will just be merely interpreters who interpret the law in a very archaic and in a very parochial way, I would say. And if we want to broaden our horizons of how we interpret the law and how we apply the law, I think we need to be aware of what's happening around us. And if we are aware of what is happening around us, we also need to be empathetic towards the person who is coming to us. And unfortunately, that's not part of our syllabus. We are not taught how to be empathetic to people who come before us. We need to understand inequalities to understand right to equality. Just reading right to equality from the Indian Constitution is not going to help us understand equality. We have to understand the various levels at which inequality is happening. We have to understand at various levels the discrimination that is happening. And only when we are empathizing with them, when we put ourselves into their shoes and understand how this discrimination happens and what is the impact of this discrimination and this inequality, is where we will be able to understand laws better. I've always been a believer that a person who comes to me saying that you are a lawyer and I need help knows the solution to their case. You just need to get it out of them. I am merely a facilitator here as a lawyer, where I am trying to understand what this person needs. How is it that what she wants or what she wants as to protect her rights can be fit into the framework of law? And how can I present it to the court? I think we need to step back a little, dissociate, and understand and give them the chance to think of the solutions that they want, because that will be a practical solution, rather than we telling them I know the law better and I'll tell you what happens and what you need to do. I think this whole paradigm in the way we work as lawyers also need to change for us to really understand women's rights. Having said that, there are a lot of good part. I mean, I was very fortunate enough to be a part of this entire consultations that were happening to bring about the Protection of Women from Domestic Violence Act of 2005. And I had just passed out of my law college, and I was still figuring out what I wanted to do with my knowledge of law. And I happened to meet some really committed people who are working on women's rights. And I got to be a part of this entire discussions that were happening, all the consultations that were happening on how to phrase every section of the Protection of Women from Domestic Violence Act. And there was a lot of thought process that went through in getting that law, I would say. And one of the first democratic law, I would say, where people's opinion mattered. People drafted that law, where people from various fields came in to pitch in their experiences in the field. So we had judges, we had lawyers, we had victims, we had counselors, we had people who from the NGOs. We had many people who contributed throughout India in drafting the Protection of Women from Domestic Violence Act. It was Lawyers Collective and Indira Jaising who took the lead, but it was an organization called Action India who traveled across India to meet up with all these people and get the consultations done so that this law could come. And talking of, I mean, various forms of violence that we do talk about, 498A was an important and still is an important provision, I would say, to stop violence within the four walls of the house. But having said that, the Arnesh Kumar case and the Supreme Court guidelines in the Arnesh Kumar case has made that section 498 a little meek and weak, I would say. So while yes, if you Google search for 498A, you will find more write-ups and blogs and people voicing out how it's a draconian law and how women really misuse law and why such a law should not be there. You might find more write-ups there. But I think we need to question all of this, and we need to think through a little bit. I have been part of many such debates on television, and every time a group that only talks of men's rights has come up on such debates, I've questioned them, and they really didn't have the answers to them. So some of the myths around women misusing a law like 498A would be that, look at the number of suicides men have committed. Fine, I mean, yeah, probably men have committed more suicides than women have. So where did you get the statistics from? You got the statistics from NCRB. Okay, now NCRB usually has the way of giving statistics is if suicide is a crime, which it shouldn't be anymore because of the Mental Health Act, and Mental Health Act says that anybody who's attempting to commit suicide has mental illness and they should be treated rather than punished, right? But abating to suicide is wrong. Yeah, so people who've committed suicide, if you look at the numbers, you would definitely see the numbers of men going up. But then in Maharashtra, we have seen a lot of farmers committing suicide. And all these farmers who have committed suicide have been men. Now, you don't really bifurcate when you give the statistics of every year. You don't bifurcate to say, oh, so many men committed suicide because there was a case of 498A filed against them. So many men committed suicide because they failed in their job. So many men committed suicide because they failed in their exams. So many men committed suicide because they were farmers and they didn't have the money to repay the loan. There is no bifurcation in the terms of reasons why a person would have committed suicide. Now, relate this to property rights. Relate this to who's the owner of the property, who is tilling the land, who owns the land, how many women own the land as compared to men. And you will see that it's more of men who own the land as compared to women. There was this entire movement where they said ghar doghancha navani, or the house has to be in both the partners' names. And there have been organizations who had to push it, through gram panchayat resolutions and through resolutions at various level to say that when you buy a house, buy it in the name of the woman and men. But even now, if you check, you put in an RTI and check how many men have their houses in their names and how many women have houses in their names, and you will see obviously that men have more houses in their names as compared to women. They don't find the need to have women as a co-owner or as a sole owner. Right? So now if men are committing suicide for various reasons, you can't really say that the number of suicides men are committed are all because of 498A. And there have been examples where women, after her man has committed suicide, has been tilling the land and has been struggling and fighting and yet has not committed suicide. So who's a stronger person here? Right? So then they say, look at the conviction rate. Right? The conviction rate is very low. Acquittal rate is high. Right? That doesn't mean that it's a false case because it's an acquittal rate goes high. In a lot of times, in many cases that we have seen, when there is a case of 498A or now domestic violence case under PWDVA, that's 2005 law, you see a lot of men going and filing cases of divorce. If a woman goes and files a case of domestic violence, you see men going and filing a case of divorce. Now, when the divorce case is also happening and the domestic violence case is also happening at the same time, you see a lot of time that the court is also pushing for mediations and settlements, or they are tired fighting the case because these cases can go on for 3 years, 4 years, 5 years, whatever it takes for them to fight those cases. Right? So now we see a lot of people compromising and saying that, okay, let's end all these fights and let's come to some kind of a settlement. So a lot of contested cases are also being converted into mutual consent cases. Now, one of the grounds for a mutual consent case, if you have a case of 498A or a case of domestic violence filed along with a case of divorce filed, is that you withdraw all the other cases and then let's bring in a settlement. So you can't have so many cases happening at the same time. Now, a 498A section is a non-compoundable section. You can't really show a compromise there. So what happens? The court tells the woman to self-incriminate there. She's been told to say that I lost my temper. Most of the time, this is the reason given. I lost my temper, so I filed this case, and now it's not true. And there was no case of domestic violence. So she's been asked to deny domestic violence that she's actually faced. And that is how that case goes on to become a case of acquittal rather than that of conviction. Now, where is the data for all this withdrawal that is happening? Because all the cases that are being withdrawn are not being withdrawn because domestic violence has not happened. They have been withdrawn because there's a settlement that has happened in another case. But they are all going in the statistics of being acquitted. And if they have been going in the case of being acquitted, obviously this kind of a statistics or data is an eyewash. There are more cases that are not reported than there are cases that are reported. So there is no law. I'm not saying, and I'm absolutely not saying that there is no misuse of law. As lawyers, think of one law that is not misused. Every law is misused. You don't stop making laws because it is misused. Not a single law is, you cannot point out at any law that is not misused. A simple law like a traffic signal is also misused. How many of us wait when there is a red light when there's nobody on the road? We would say, oh, there's nobody on the road. Why wait for a red light? And we still cross the road without waiting for the red to go green. Isn't that a misuse? It is. Do we stop making traffic rules? We don't. It would be a chaotic situation. So we have to understand that these laws have also come because these are social legislations. These laws have also come because there is some kind of an imbalance that is happening in the society, where one section of the society, one community of the society has to face some kind of a violence that is terrible. And these laws are to stop that. So just because we have a few percentage of few people misusing the law, this benefit of the law cannot be taken away from a lot of others who are in an abusive relationship and are not able to come out of it, or need some support to come out of these relationships. Some of the interpretations of these laws have also been very parochial. If you look at the Batra case that was decided by the Supreme Court, they said that they interpreted the understanding of a shared household in a very narrow way, in a very parochial way. And they said that if the house belongs to the parents-in-law, you cannot really claim because your husband doesn't own that house. Now, a lot of time, and if you look at the section, the way it is written, when you ask for an order for residence, or when you read share household under the Protection of Women from Domestic Violence Act, it could be a rented place, doesn't matter. Agreement is always in one person's name. It is not in everybody's name, and yet it becomes a shared household. But that has that interpretation changed recently in 2020, when there was Satish Chandra Ahuja versus Sneha Ahuja case, where then the Supreme Court gave a very, very broad definition to say that even if it's not, the meaning of shared household is, even if it's not in one person's name and it is in somebody else's name, it can still be a shared household. Or I would say that Prabha Tyagi versus Kamlesh Devi case took us a step ahead, where this lady was a widow and she claimed a resident right from her in-laws after her husband. And the in-laws said that she's never stayed with us, so we cannot give her the resident right. And in this case, the Supreme Court said that it is okay not to stay in that same household, but she still has a right to residence and it's still a shared household. So I think these are the kind of interpretations that we really need. And when we look at, some of these, this is these are a few examples, I would say, of the violence happening within the four walls. It is about how you interpret this also. I can share you some of the experiences that how do you need to look at as a lawyer and as students of law who are probably going to be practicing lawyers or are going to probably be judges in the future. How do you interpret all this? And like I said, it's not a cookie cutter that you apply the same rule everywhere. In one of our case, very interestingly, there was this girl who was a PhD scholar, and she had got some fellowship and she was able to support herself. And she had lost her father, and so her older brother was forcing her to get married, and she didn't want to get married because she wanted to pursue her PhD. Now, what he did was he used to use the mother, to force her to marry. Now, in the Domestic Violence Act, you cannot have mother as a respondent, because a daughter cannot file a case against a mother. So now you had to make the brother the respondent, but we knew that that was not sufficient. So when we asked for the protection order, we said that while the brother is the respondent, the possibility of him using the mother to coerce our applicant or our aggrieved woman to marry cannot be ruled out. And that is the whole imbalance in the power equation within the family, where a older brother and a mother can coerce the younger sibling or the daughter to get married. And so under the right to or under the protection order, we would say that while you give the protection restraining order against the brother, we would also request you to add in a line to say that the mother cannot force her also, and or the brother cannot use the mother to force her into getting married. Now, the judge was a little perplexed, and he said, I mean, the mother is not the respondent. How can we do that? We said, no, the mother is not the respondent, but the respondent brother can use the mother to coerce her into getting married. And we want to avoid that, because if we don't add that the brother cannot use the mother also in coercing her to marry, and we don't give that as a protection order, just having a protection order against the brother will make sense in this particular case. And somehow the judge agreed, and the judge said that, yeah, I mean, he saw merit in the argument that we were making, and he allowed us, or rather in his order, he gave us that, he said that fine, the respondent brother cannot use the mother to coerce the daughter into getting married, or the sister getting into married. Now, this is what I mean, that you have to understand when I say empathize and understand the situation, or what is it that your clients want, this is the broader interpretation that you have to bring in. When we talk of limitation act, or when we talk of jurisdictions, so there was this lady who was a wife of an ambassador, and it was in the year 2000, even before the Domestic Violence Act was passed, that she, because of the whole violence that she went through, from the husband, she had to flee that country, and she had to come back to India, and her brother was helping her. And while she was fighting a case of maintenance and divorce with her husband, the husband being an ambassador and had all the protection and political immunity and all that, he was not appearing for the cases, and she was fighting this case for many years, almost 4 years since after she came to us. And the Domestic Violence Act came into effect in 2006, and she came to us and she said, can I fight my case under this law? Now, all the physical violence had actually happened in 2000. Okay, so now we said that, yeah, I mean, we have to fit this case, because she's still going through a different kind of violence that is emotional and psychological and economical, even though they are not staying together since the year 2000. So when we filed her case in 2007, there were 7 years they had already were staying apart. And we knew the kind of argument that would come from his side, that I'm not even staying with her, so how can I really be violent with her? And that is why we brought in this whole concept of how the violence is retroactive. We are not looking at a retrospective violence that, that happened in 2004, the year 2000. Even in 2007, is the violence still retroactive? Is it still active? Answer to that is yes. He's an ambassador. She is not earning anything. She was a homemaker because she was traveling all those countries with him as his wife. So she was not earning anything. The economic violence is still there. The kind of pressure, she doesn't have a house to reside. She's still dependent on her brother. That is a violence, and we brought in all these aspects, and she finally got resident order. They were allowed to open the house that was otherwise locked, and that was in his name. She was allowed to stay there. But look at the impact of violence. Her 23-year-old son, who had seen violence when he was a child, went into a mental illness, and he couldn't bear to even hear his mother narrate it to the lawyers of what happened. So there are a lot of impacts that happen on children while we talk of women's rights. So sometimes women's right cannot be really isolated to say that it's just women's right that we are going to talk about. We have to look at the child rights with it, because there is a kind of a connection that we have to see. Right, but these are just a few examples, I would say, of where that whole broader interpretations have to be done to bring justice to your client. And this is true of every law, right? I was talking about laws coming as a response to what has happened in the society. Look at how the law on preventing sexual harassment at workplace has come. It has come because Bhavri Devi faced a case of gang rape. So Bhavri Devi was a Sathin, she was a community leader, and in Rajasthan, she was working as a Sathin for a project of Ministry of Women and Child Development in United Nations to bring down the prevalence of child marriage, because Rajasthan has a very high prevalence of child marriage. And on a particular day called Tej, which is supposed to be a very auspicious day, she was basically, she got to know that a 9-month-old baby is going to be married, and so she went to stop that marriage from happening. And the family did not like it, because they said that a lady is coming and telling us what we are not supposed to do, and that lady is from a lower caste. Look at the caste politics that comes in, right? And so to teach her a lesson, a few family members went and gang raped her. Unfortunately, Bhavri Devi is still fighting her case. But it was because, and it was not just because she was gang raped and she was fighting a case of rape. It was the insensitive comments made by the judge who was hearing a matter. And he said that in the Indian cultural context, where a man of an upper caste family will not even touch a woman of a lower caste, where is the question of rape? And with this kind of a comment coming from the judge, the women's group went to file a public interest litigation in the Supreme Court. And we had a very sensitive Chief Justice at that point of time, Justice J.S. Verma, who also gave us the Verma Committee report after the Delhi rape case. And he basically looked at this whole thing that, India is a signatory to CEDAW. And I'm sure you all know what CEDAW is. So Convention on Elimination of All Forms of Discrimination Against Women. So what is the use of, ratifying an international convention if we don't put it to use at a local level? And that is where he gave Vishaka guidelines in 1997. But Vishaka guidelines were weak in terms of implementing. And that is why there was again a lot of advocacy done by the women's group to say that just these guidelines are not enough and we need a law to come in place. And that is where we got the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. That is how we got that law. Now, if you look at the Criminal Amendment Act of 2013, that came about because of the Delhi rape case that happened. Now, Justice Verma gave us a report, and it is one of the most democratically made report, I would say, because there were 80,000 people who wrote to Verma Committee to say what is it that they are looking for, when they're looking at sexual violence. And it's a 631 pages report, which is beautifully drafted. As law students, I would say you should read that report. But what did the government do? They took bits and parts of what the Verma Committee had suggested to bring in a change under the Criminal Amendment Act of 2013. And that is where, at that point of time, we just had two sections that were talking of sexual violence. One was outraging modesty of women under Section 354, and the other was rape. And in a rape, the definition of rape till then was that it has to be a penile vaginal penetration, even if it is slightest. That is how rape was defined. One, it has to be non-consensual, and there has to be a penile vaginal penetration to call it a rape. Now, disrobing a woman is equally a heinous crime. Imagine the dignity of a woman when she's disrobed. और हमने ये सुना होगा कितने काफी बार ऐसा हुआ है कि SC/ST एट्रोसिटीज एक्ट तो लगे ही है, लेकिन a lot of times caste based violence, so many times we have heard that a woman is disrobed and uski nakedly she's been taken around in the village and her dignity has been violated. This did not amount to rape, but it was just saying that it is outraging modesty of the woman was a very trivial way to look at it, I would say. And hence a lot more needed to be be a recognition as a sexual violence needed to happen, right? And that is where the inclusion of section 354A to talk about sexual harassment, section 354B to talk about disrobing women with criminal force, section 354C to talk about voyeurism, and section 354D to talk about stalking were important. And the whole change in the way the definition of rape changed, that it was not just penal vaginal penetration but even object penetration or body part manipulation were also called as rape, was important. And I think while this was happening, the boys who were young were not getting protection, and in 2012 the entire law to protect children from sexual offences act came about in the form of POCSO, which was also an important contribution, I would say, and an important piece of legislation, I would really say. Now, while all this is happening, look at some of the movements that has happened even presently. The Me Too movement. A lot of people criticize the Me Too movement, and I think the Me Too movement had its own limitations, because in the Me Too movement, it was only the urban women who had access to the social media who were able to speak of the violence that they have gone through. A lot of people questioned the credibility of Me Too movement, saying these people now cannot file cases based on the limitation period. They have, how can you go back 18 years down the line to say that, you were sexually harassed at workplace, or you were sexually harassed by somebody? The question here was not about every woman going and filing a complaint under the IPC or filing a complaint under some other law. The question here was, did we have the systems in place to support women who faced this kind of a violence? And the answer to that is no. Look at the Priya Ramani case. The moment she and some other women started talking about MJ Akbar, sexually abusing them, he filed a case of defamation against her. And the kind of to and fro that case has done, because MJ Akbar at that time was a member of the parliament and was also a minister. Look at the imbalance in the power equation here. And it is the imbalance in the power equation is not just in designation and position. The imbalance in the power equation is also in the representation that was happening in the court. Guess how many lawyers represented MJ Akbar's case? 97 lawyers were representing MJ Akbar. And there was Priya Ramani with her one lawyer fighting that case. And I think while there are certain parts of, I would say, Priya Ramani's case that did talk about the kind of, stereotypes about women, I would still say that it was a good judgment in terms of recognizing that women take time to talk about the sexual harassment that they've gone through. It is not easy for them to report. And just because they are reporting a case and just because they are talking of a case of an incident that has happened to them, it does not amount to defamation. And that ruling in favor of Priya Ramani, I think, was a landmark judgment. Or look at, we are in our 21st century, very modern, technologically very advanced. And yet we had to fight the Sabrimala case to say that periods or menstrual cycle of women is natural. allow them into the temple because they also have a right to go into the temple. Or the Shani Shingnapur case that had to be fought, where women had to be given access to go to the temple. You know, all these cases have happened in the 21st century. Whether I was asked this by a lot of reporters, that do you believe in going to the temple? Will you ever go to Shani Shingnapur? Will you ever go to Shabrimala? Probably I may not go. I may not believe in going to a temple, but for women who believe, and for women who want to exercise their right to religion by going to a temple, or that is their way of expressing what they feel about their religion, I think they should have a right. Why should they be discriminated that because they are a woman they are not allowed to a prayer place? So I think the fight is not about whether it is whether that is really development, or women going to temples is really going to bring about a development. I think that's not the discourse that we're talking about. It is about giving them a choice, of whether they want to go or don't want to go. But not having the right to go at all, and not having the choice to make at all, is the worst part. And these fights have been about choices. And I would say I'm pretty glad that we do have a law that talks about giving the right of the woman to choose whether she wants to go through an abortion. The Medical Termination of Pregnancy Act, I think, is an important piece of legislation, especially when I see a developed country like America still fighting for rights of abortion. Look at the Roe versus Wade case that has happened. It had to be through an executive order that the president had to say that women have a right to abortion. So her body, she decides whether she wants to be a mother or not be a mother. She decides how many children she wants to have. She decides how she wants to space her children, because it's her womb that is being used. But when I say of her womb that is being used, look at the surrogacy bill that is still pending. Look at how there is commercialization happening, with the whole surrogacy concept that is coming up. And I would say that there is a lot of vulnerability there, because if you look at who are those people who are willing to be surrogate mothers, these are people who want money and they are poor, and that is the way to support their family. And people are paying money to get these surrogacy mothers done. Now, if you look at the way the surrogacy bill has been drafted, while there are certain things that are good, there are certain things that are absolutely impractical in that bill. And it has not yet been passed. Right? So while they are saying that paid surrogacy will not be allowed, it has to be to help somebody, some family who's not been able to conceive a child. It is to help, which is good. That commercialization of surrogacy will stop. But I think this entire thing will also go underground as a trade, because there is, for so many years, we've just allowed them with some ICMR guidelines. We've allowed them to do surrogacy the way they want to do it. And most of this surrogacy, where women's womb is purchased, it is for a trade in money, without considering the emotional part that a woman goes through when she becomes a mother, without considering the importance of breastfeeding a child. We celebrate one day to mark it as a day of breastfeeding and say that it's an important child right. And yet in surrogacy, the child is taken away so that there is no emotional bonding that happens between the surrogate mother and the child. So I think with the advancement of technology, there are also these certain adverse impact that, as a society that we are facing. Look at the number of cases of violence that went up in the pandemic. While we do talk of women's rights and women's equality, the fact that, what the third wave was talking about, or what the second wave was talking about, that she's not merely a homemaker, she has a space outside in the outside world too, that she also can be a breadwinner. And you saw the pandemic happening and the increase in the cases of domestic violence happening. The way we as a society react to adversaries around us is something that is to be observed, and we need to see what is it that we need to do to for such kind of violence to stop. Even today, while a lot of, I mean, the United Nations had to come up with a paper against domestic violence during the pandemic. We didn't have services to provide. I got so many calls, and not calls from victims, believe me. These were calls from neighbors, these were calls from family members, these were calls from people who knew that this lady is going through violence, but she couldn't call me, she couldn't reach out, because they were everybody in the house. The perpetrators were also staying in the same house. She didn't have services from the police because the police were busy with bandobast. She didn't have services in the shelter home because nobody could step out during the pandemic and the lockdown. Later on, she started, the services for counseling were not available, not because the counselors were not working, because she couldn't have an open discussion with the counselors with her perpetrators being around her. The expectation of the family to, for her to do her work at office, to take care of the family, to be there, that entire me time that she had before the pandemic was lost. If she was a homemaker, she would get that me time when everybody else in the family went out for their jobs, or to their schools or colleges. If she was a working woman, she would get that me time when she would step out of the house to do her work. But that me time for her was lost. I have seen cases of very high ranking women in high ranking position, where she said that if I didn't give that cup of tea to my husband, he would come and snap me and slap me while my meeting was going on. So you see the kind of sometimes the hypocrisy that we have, while we want our women to go out and work and earn for the family, yet when it comes to her own individualism, sometimes that individualism is lost for her. And I think these are the shackles that we need to break, and law is merely a tool for us to help these women discuss these issues that they are facing, and to break those shackles in the court. I would probably end this with two things, I mean rather three things that I want to share, which are very recent, I would say. One is the Shakti bill that is passed by the government of Maharashtra. And I was part of the people who were invited to mention the objections that we had to the earlier draft of Shakti bill, and we did raise our objections before the entire committee, to say how this bill is not going to help in stopping violence against women. But now they have still gone ahead and passed it, and we have got the Shakti bill now. And it is more about, they think that curbing the violence against women will happen when there are more stringent punishments. So in Maharashtra, with the Shakti bill coming up, everything has changed. I mean, for a rape now you have a death penalty. And as part of the women's group, we have been saying that death penalty is not going to stop rapes from happening. Because with death penalty, you equate the murder, the offense of murder has death penalty, and the offense of rape also has death penalty. The person would say, I would rather kill this, I will rape and kill this woman so that there is no evidence left, rather than keep her alive. There is even more danger to women when you say that there is a death penalty for rape. Think about it. So in Shakti bill, all they have done is increase the punishment, and say that we have special courts to handle these cases. Where is special courts are already there to handle these cases. In camera proceedings are already happening. It is about how you strengthen the existing mechanisms through judicial reforms, how you strengthen the existing mechanisms through police reforms, through prisons reforms, to look at it as reforms in the entire criminal justice system. if we really want to stop violence against women. So we need to take some of these laws with a pinch of salt, because sometimes these are, like I mentioned in the beginning of my lecture, that sometimes these are just political gimmicks to appease people. It has absolutely no meaning when it comes to converting it into practical solutions. The two other incidents, or rather three other cases, that I cannot stop myself from mentioning is the recent judgment coming from the Madras High Court, which gave this man his divorce case that was pending for a very long time. But I think the entire comment that I would say that it was also misreported by a lot of newspapers. So this judge, this was a case where the husband and wife were not compatible with each other, and the husband had filed for a case of divorce, and the wife, the divorce was not granted at a trial court, and it finally went to the high court. And while it was in the high court, this lady went to the man's workplace, and she started accusing him of having an affair with somebody. And that was a big humiliation for him. And so this matter, while it was being heard in the high court, it was also brought to the notice of the judges. And the judges said that when you make an accusation like this, that he's having an affair with somebody, who is the person whom he is having affair to? If you cannot support your case by evidence, then we cannot believe it. And that is where the divorce was granted to them, which I think till here it is fine. But the later on, the comment that the judge made was that if you are not wearing your Mangal Sutra, it is an indication that you are not really, you do not really want to be in this marriage. And hence, so why are you opposing the divorce? So I think for a judge to even bring in these symbolisms that a woman has to follow, and to say that this indicates this, I think to me was objectionable. Granting the divorce was not objectionable. Asking her to provide proof for the allegations that she's making was not objectionable. But why bring in these symbolisms? And now we need to think as lawyers, who has these symbolisms? How do you recognize whether a man is married or not married? Are there any symbolisms for man? So now when we talk of women's right, we also have to challenge these stereotypes that always come up in cases. When you're arguing these cases, when you're fighting for these cases, these are stereotypes that will always come up in the court. And we need to fight that too. We need to have answers for that too. The other case, a very recent case, is the Kerala High Court giving bail in a case of sexual harassment to this man called Civic Chandra. So they said that the sexual harassment happened on a beach, and there are so many people who were there on the beach, and nobody really came in to support the complainant. So how do we believe her? There is no evidence to say that Civic Chandra should be arrested. He is a person with disability. How can he really sexually harass another lady? And because there is a lack of evidence, we want to give him bail. Absolutely fine. Bail has to be decided basis the evidence that is put forth in the court. But I think what was horrible was that Civic Chandra's lawyer submitting some photographs of the complainant, and then the court commenting that if the lady is wearing such provocating dresses, then how can she be sexually harassed? I think this kind of a statement coming from the court to say that if you wear certain kind of dresses, you are not sexually harassed, is a horrible way of, again, objectifying the woman, to say that we will decide your character basis the dresses you wear. And my work with sex workers, I have worked extensively for the rights of the sex workers. A lot of people thought that, we are not raped because there are sex workers in the society. Hello. I mean, sex workers also have a right to say that we have been raped when it's a non-consensual sex. Just because they're sex workers doesn't mean that they have to entertain every client who comes to them. As a lawyer, when I can say I don't want to take this case and I don't want to represent a client, The sex worker also has a right to say no to a client. And I think we just conveniently forget that because of the kind of profession that they are in, or because of the kind of work that they are doing, which is not considered to be dignified. But believe me, I mean, I chose to be a lawyer. All of you have chosen to take up law as your profession. A woman doesn't say that I choose to be a sex worker. She's pushed into that business because of circumstances. So when we stereotype all this and we character assassinate, when it becomes very easy for us to assassinate the character of a woman, is where we are closing down spaces for her to talk about her rights, because we are setting such derogatory precedents in the court. So I would say that a comment coming from a judge in the High Court to say that because you're wearing provocative clothes, which means you will not be sexually harassed, I think is an objectionable thing to happen. And lastly, I will have to mention what has happened in the Bilkish Bano case. I mean, such a heinous crime of rape while she was pregnant, and these unknown people. And believe me, I have worked in Gujarat. I was there for 6 months in Gujarat when the Gujarat genocide had happened. In 2002, the Gujarat genocide happened, and I went to Gujarat in 2002 once to study and meet certain people at Godra. And then I went in 2003 and stayed there to look at how the genocide has impacted women, especially women in the home-based industry. And for us to say that everywhere else, when remission has stopped, in the Bilkish Bano case, for these perpetrators to get remission, I think we are defeating the entire struggle that these women had to go through as being a minority in a situation where it was the violence came from the majority there. And to say that now their perpetrators are free on the remission and good behavior, so what are the rules that we are framing, and how conveniently we are bending these rules to give benefit to a few people? And this definitely needs to be objected on. So while we do have certain good laws coming in to fight against some of the social evils that women are still facing, the disparity that women are still facing, I still think that we have a long way to go to fight against all these discriminations and all the inequalities that are there in the society at different levels, right from starting at our own houses. The way a girl is treated, the way a boy is treated, right from their discrimination starts. And then I think we have larger battles to fight. And all this can change only when we change our perspective of looking at not just women's right, but every vulnerable group who's struggling up there to get that equal to come to that equal level where right to equality will be realized in the real sense. And I think this fight will go on, and what we need is a sensitive we need sensitive lawyers, we need sensitive police officers, we need sensitive judges, we need a very sensitive society to support women who are fighting for these rights. And I think that change has to begin from us. Like Mahatma Gandhi said, that if you want to see the change in the world, you have to begin that change from yourself. And if we don't do that, we will just again be having seminars and workshops like this. So it's time that we stand up for these rights and we demonstrate it through our behavior, we demonstrate it through representations that we can do as lawyers, and later on if some of you become judges, with the judgments that you give, because these are setting precedents for others to follow. I once again thank MP Law College and their team for having me here to share some of my experiences from the field and from what I understand, of how I've been working on interpreting in these laws. We still have about 15 minutes. So if you have any questions for me, I'll be more than happy to take those questions. Thank you very much.
Ma'am, I see no questions in chat box.
Sure. Are you going to read them out for me?
Ma'am, there are no questions in chat box. Those are from previous session, I guess.
Okay, I cannot see any questions on the chat box. So, yeah, if there are any questions, please feel free to ask.
Like the one I built out of old mufflers, can we there? Yes, can we do?
Hey, Gloria, what's up? What's the problem? Yes, so what? It's Jay. He's not getting that award.
Ma'am, I see no questions in the chat box. With your permission, we may.
I'll be right there.
Ma'am, there is one question in chat box. Please share your views about NCW, working of NCW.
Sorry, share?
Share your views about working of NCW.
NCW. Okay, so yeah, I would say NCW is an important body, I would say. It has its own, though it's an alternative forum to go to, you still have to fight your cases in the regular courts. But I have experienced where NCW, or rather the State Women's Commission, has also come handy. During the pandemic, when I said that a lot of women could not reach out or get services, a lot of them were able to reach out to forums like NCW and forums like State Women's Commission to get assistance. In one case, I was appointed as an independent expert in a case of sexual harassment at workplace by the State Women's Commission, because the internal committee, it was a complicated case and they couldn't really handle it. So these are forums where women can approach, and where they will be heard and they will be understood, and they get some kind of a remedy when the regular remedies are not working. So a directive coming from an commission like an NCW or SCW really helps women to take their cases ahead. What I am a little wary about is that these are all political appointments, and not every member of the NCW or SCW will have the same experience of working on women's right, or they may not have the perspective of working on women's right. And I think that needs to change from it being a political appointment. It should be where women with real experience of working in the field on women's rights should be part of NCW and SCW like forums. That component is totally missing from these appointments. But I would still say that it's a useful forum to go to, especially when you're not being heard at the where you have to seek remedy at the local level and you're not getting your remedies there. I think these are the forums to approach and get your remedies from, or get directives from them.
Thank you, ma'am. There is again one question from Mihir Karnik. Ma'am, what is your view on recent Kerala High Court judgment about the provocative clothing and complaint of sexual harassment?
I just mentioned that in my talk, that they can decide the application of bail basis the evidence that have been submitted to the court. That is absolutely a done thing and fine. But for a judge to comment on somebody wearing provocative dress and hence cannot, be a victim of sexual harassment is objectionable, and that is not acceptable. I just shared that, in my talk.
Yes. There is again one question from Arun Sherkhane. Why the human right activities always and only speak about women rights? Do men have any rights, or men are not human?
Yeah, I mean, male have rights. It's not that they don't have rights. Most laws are gender neutral in their application. There are only several laws that are gender specific, and they are gender specific for a reason. How many cases of men being raped do you really hear? You know, of children, boys being sexually abused, yes, you hear, and there is a POXO law for it. Of course, we got that after a lot of struggle and fight. How many cases of domestic violence do you hear men facing? So some of these sensitive laws or social legislations happen because of what is generally happening in the society, and not on the exceptional cases that are happening in the society. I'm sure you would know men who say that they have been abused also. So I'm not talking. I'm not saying that it shouldn't be safe for men or they shouldn't fight their case. But there are certain social legislations that come because of the social evils that are happening in the society, and that is why they become laws specifically to protect the interest of that community. So whether it is a certain specific laws to protect interest of children, or certain laws to protect interest of the minorities, or of SC/STs, or people with disability, or people having HIV, or women, that is because these groups are considered to be vulnerable groups. Or certain laws to protect rights of the elderly people, that's because they are vulnerable. And it is this vulnerability that we have to understand, to say that this is a particular community that needs laws to protect them, so that they are brought to an equal footing. Otherwise, the meaning of equality, I mean, it would be meaningless to talk of equality if we are not able to give that kind of affirmative, if we are not able to take those affirmative actions to protect the vulnerable groups. And so I'm not saying that men should not be protected. We work with men as well, but while we work with men, we don't lose sight on the right based approach that has to be there. I don't advise men who come to me with their divorce cases and who have to pay maintenance. I don't advise them that let the woman struggle to get maintenance. I in fact, I tell these men who come to me as clients that okay, you are earning better than your wife is, or your wife is not earning, you should give a maintenance, rather than fighting a case to say that I'm not going to give a maintenance. It is a right to get the maintenance. Let's see what is the quantum of the maintenance. Let's talk on the quantum of the maintenance. Half of the battle is over there. I think this is the perspective that you need to bring in as lawyers when you're fighting these cases.
Thank you so much, ma'am, for answering most of the question. Due to paucity of time, we can't take all the questions. Thank you, ma'am, for your words of enlightenment and pointing out importance of object and reasons of statute in order to interpret statutes in a precise manner, and sharing and narrating plenty of real life based examples on the topic. Now we are arriving at the concluding part of this session. With permission of dignitaries, I would like to propose vote of thanks. At the very outset, I would like to express my deepest sense of gratitude to respected Advocate Rama Sarode ma'am, a resource person for this session, for gracing us with her presence. I thank our respected Principal Dr. C.M. Rao sir, Vice Principal S.N. More sir, IQAC Coordinator Dr. Aparna Kotapalle ma'am, Coordinator of this program Dr. Sheetal Bharate ma'am, Teacher Coordinator Professor Abhay Jadhav sir, the management and the technical support staff who made this session a big success today. I also thank the attendees for the valuable participation for this session. Thank you all. For the next session, I hand over to Ms. Chaitrali Daborkar. The theme of next session is women and rights, including mental, reproductive, maternal, and issues related to sex. We have Dr. Jyoti Bhakre ma'am, HOD and Professor at Department of Law, Pune University, as resource person. Over to you, Chaitra.
A very good afternoon, everyone. On behalf of Marathwada Legal and General Education Society's MANIKCHAND PAHADE Law College, I, Chaitrali Dabholkar, LLB final year student, welcome you all to session 2 of online national level training program on correlating women rights and human rights, a human developmental approach, which is in collaboration with National Human Rights Commission, New Delhi. For session 2, we have with us Professor Dr. Jyoti Bhakre ma'am as resource speaker on topic women and health rights. Before moving to actual address, I would request Mrs. Pratibha Girbani ma'am to introduce us with the theme of this session.
Thank you, Chaitrali.
Pratibha ma'am.
Yes, thank you, Chaitrali. Good afternoon to all the dignitaries and participants present for this session. In this session, respected Dr. Jyoti Bhakre ma'am is going to interact with us on women and health rights. And I am here to briefly introduce this topic to you all. When we talk about right to health of women, this right is related to number of other rights, like right to food, right to life, right to privacy, education, and even prohibition of discrimination. Women's health right, it includes right to physical and mental health, as well as reproductive and maternal health. Even this is recognized in many international instruments. Like CEDAW, it indicated that the woman's right to health includes their sexual and productive health as well. And therefore we can say that state have obligation to respect, to protect, and to fulfill health rights of women. For that, or these rights can be protected with help of various healthcare services, and which should be accessible to women physically and economically and without any kind of discrimination. For fulfilling this obligation at national level, government have passed different laws and even have framed number of policies for protection of women's health. Now, despite of all these attempts, there are violations of human rights of women to health because of, say, like inequality of access to the healthcare, inequality of access to food and nutrition. To overcome this situation, this particular issue, there is need to work together to meet the specific needs of a woman's health. And with this aim only, this theme is selected for this session for the purpose of sensitizing and awareing you all about various rights of women related to health, what steps government has taken to protect these rights, how these rights are violated, and what can be done to overcome this particular problem. And I'm very much sure that respected resource person will guide us on all these aspects. With this, I conclude the brief introduction, and I thanks to the organizer for giving me the opportunity to introduce this topic. Thank you.
Thank you very much, ma'am. For session 2, we have with us Professor Dr. Jyoti Bhakre ma'am, who is going to guide us on the topic. And a brief introduction before we move ahead about ma'am. Professor Dr. Jyoti Bhakre, Head of Law Department of Savitribai Phule Pune University and Director of Savitribai Phule Pune University Law Department. Ma'am has got an expertise in the field of medical negligence litigation, legal aspects of healthcare management, healthcare and law policies. A book has also been authored by ma'am which is titled as Introduction to Health Law, and which has been approved as a reference book for medical sciences by Maharashtra University of Health Sciences. She is also a member of various administrative committees of Pune University. She is also a member of World Association of Medical Law and has been nominated as a member of focus groups for examining the medico-legal aspect. Other than that, respected ma'am is also a legal advisor, has been also a legal advisor at MES College of Nursing, Ratnagiri, and she's also been a member of Sexual Harassment Prevention Cell, Maharashtra Education Societies, Abasaheb Garware College and Garware College of Commerce, Pune. And at present, 7 students are pursuing PhD under guidance of Dr. Jyoti Bhakre ma'am. And there are more than 48 published research papers and journals by ma'am. And one of them I would name is Impact on Legal Region on Hospital Administration, a Critical Analysis. And ma'am has also completed her interdisciplinary research project in law and Sanskrit on changing dimensions of women property under Hindu law from ancient to modern Indian context of critical study. On behalf of Marathwada Legal and General Education Society's MANIKCHAND PAHADE Law College, I take this opportunity to welcome you. And without further, and without taking much more time, I request Dr. Jyoti Bhakre ma'am to address the respected participants. Jyoti ma'am. Is my voice audible, Jyoti ma'am?
Chaitrali, please wait. There may be some technical glitch.
Yes, ma'am. Jyoti ma'am, is my voice audible to you? Jyoti ma'am, can you hear me?
Yeah, I can. Am I
Yes,
audible?
ma'am. Yes, ma'am, we can all hear you.
Yeah, you may start.
Yes, ma'am. I now request you to address the attendees.
Just a minute.
Jyoti ma'am, we've made you presenter so that now you can share your presentation with us.
Okay, should I start?
Yes, ma'am.
Am I audible properly? Because there is some connectivity issue. So am I audible properly?
Yes, ma'am, we can hear you.
Okay, okay, thank you.
Ma'am, we aren't able to see your screen yet.
Yes, yes, yes. I'm just connecting. Is it visible now?
Yes, yes, we can see it.
Okay. Okay, at the outset, I express my gratitude to MP Law College and NHRC for having called me here and share my views on women and health rights. So for that, I would like to specifically mention Professor Dr. Principal Dr. C.M. Rao sir, Dr. Aparna Kottapalle ma'am, and Dr. Bharate ma'am for all this. It's really a very good venture from the college side to introduce such kinds of dimensions of human rights to the students and the participants. And it's really an appreciating effort from the NHRC side also to reach out to audience in order to spread the awareness regarding human rights. Such kind of program even we had organized in our department, so I know how useful it is to the audience. So first of all, I would like to appreciate the efforts of the organizers in this regard, and I express my gratitude for having called me once again here. Okay, with that, let me go to my topic, that is women and health rights. I express my means I'm really sorry for getting delayed into this, because all this arrangement I had to do all of a sudden, and we had some connectivity issue. Okay, coming to women and health rights, what comes to your mind when it comes to women and health rights? Everyday newspapers, if we see, or when we come to the news by any electronic media or otherwise, we come to know that okay, there are so many kinds of debates going on. News are just popping up everywhere, and we find that okay, are women so unsafe in this world? If it is so, how the world will progress? So with such kinds of questions, when we are thinking of, we can't remain away from this, because we know that the situation is not so good, but that is not so bad also, because when such kinds of atrocities are committed against the women, at the same time we observe that there are so many people who are coming forward to protect the rights of the women, to make the world better for women. And these are our legislators, this is our judiciary, media people, and civil society organizations, and so on. They have done a lot in order to make this world better. Okay, so if it is so, then who is doing what? We can't keep neglecting all such developments that are taking place around us. Recently, you might have heard about the debate that was taking place in USA regarding pro-choice and pro-life. Okay, and such bills were when being debated in the houses in US. The common man also had taken part into it vehemently. The picture that you can see here is a representative part of it. The women who were pro-choice, pro-choice means they wanted their choice to decide when to give the birth, how to give the birth, whether to give a birth or not, whether they want a child or not. So this is their choice, and this comes under their right to life and liberty. And that's why the women were claiming, whereas there were many, some activists or some legislators who were thinking that it's the God gift and you can't choose it, because when you choose it, you are terminating somebody's life. And that is how this debate between right and right of say a woman and right of unborn person was going on a very large scale. Considering this, again that debate of pro-life and pro-choice came into forefront, and that is how the matter of Dobbs versus Jackson Women Health Organization was decided by US Supreme Court, whereby such questions were again brought into practice. If we see such kind of debate, we think that in spite of being a developing country, of course that's my opinion, and you are free to differ from my opinion, but it's my opinion that India being I think a less developed country is still in a very better position to protect the rights of women, especially the reproductive rights of women. If we see the law that regulates reproduction, or I mean the abortion, we find that we are quite progressive as compared to many of the developed countries. Now, after this judgment has come, as it became a law, and of course the legislators also had lobbied in this regard, the solutions were sought to be uh, put before the people by many of the corporate side and institutions and so on. So it was seen that after this judgment, there were many Google workers who had filed a petition before their employer, that is the Google corporation, that they be given the abortion benefits. And as such kinds of benefits, like say there were some leaves and some medical benefits were given to the regular employees, but such kinds of benefits were not percolated to the contractual workers. Just on the ground of such kind of status between two different categories of women as regular employees and contractual employees, can they be justified to make such kind of difference? Because after all, when you are a human being, when you are a woman, biologically you need to have the same benefits as your counterparts are having. And that's why such kind of petition came before Google, and these employees started demanding that such rights be made available even to the contractual workers. So this is in order to protect the privacy and dignity of such kind of women. and they also be given such kinds of benefits. This is really a serious questions we also need to think over, not just we, rather all the jurisdictions over the world, to see whether all the women in the world get such kinds of benefits. Okay, with so many such kinds of developments, India also is not left behind. Recently, just last month, the Supreme Court also has come up with such kind of ruling that abortion can't be denied because woman is unmarried. Okay, I'm going to discuss about MTP Act later, but we had such a law which prevailed for over more than 50 years in India, whereby the law was just made a tool in order to protect the abortion rights of the married women, because the aims and objects of the act at the time when it was passed was population control, and when it means during those times when population control was the aim to be achieved, it was meant for married women. The society has undergone a tremendous change over the period, and the situation has changed whereby it's not necessary that this should be restricted to married women. Taking cognizance of such a development, the Supreme Court ruled that this act actually needs to be thought over with the intent that the legislators had at that point of time. And that's why Section 3 needs to be thought over in this way. Of course, the view of the Supreme Court was already taken care of by the legislators when 2021 amendment came into practice, whereby in Section 3, the word married was removed and the word partner is used. Termination of the pregnancy, instead of husband, the word partner is used, and termination of pregnancy was no more restricted to married women only. Okay, let us see what else is happening when we speak about the health rights of women or reproductive rights of women, because the topic that is given to me is reproductive rights of women, then mental health and women rights, and the role conflict when women is performing her
Jyoti ma'am,
plight of
is my
women.
voice audible to you? Yeah.
Hello, hello, am I audible?
Jyoti ma'am, I'm really sorry for interrupting the session, but it would be better if you switch off your video. We would see and hear your voice clearly.
Okay, okay. Just a minute.
Ma'am, we can also stop at our end. So can we do it? Like,
Just a minute.
ma'am, we can hear you now
Yeah,
clearly.
just a minute.
So
Am I audible now?
yes, ma'am, we can hear you.
Okay.
Even we are able to see presentation.
Okay, okay. Okay, so with this, what I was talking about was that was the movie wherein the violation of of women rights, especially the reproductive rights, were talked about in that movie. When we talk about such rights, what comes to my mind is that many a times the health rights are talked about, when health rights are talked about, many a times people talk a lot about reproductive life or reproductive health. It's not restricted to that only. When we talk of health, health as a human being, that is one part. Health as a woman is another part. Okay, I need not get into that part because under constitution you must have studied about right to health as a fundamental right, or as an extension of right to life, and right to liberty. You might have studied about it, so I need not get into that part. But when I am talking about right to health, I would like to talk more about sexual health and reproductive health in general, and reproductive health in particular as well. Okay, so what is sexual health? Let me just say, WHO has defined that sexual health. You can see that in the slide, that it is a state of physical, emotional, mental, and social well-being in relation to sexuality. It's not merely the absence of disease, dysfunction, or infirmity. And it has further said in that definition itself that this health requires a positive and respectful approach to sexuality and sexual relationship, as well as the possibility of having pleasurable and safe sexual experiences, free of coercion, discrimination, and violation. Sorry, and violence. Okay, so this is about sexual health, which is different from reproductive health. You might have seen that there are certain offenses defined in IPC that talk about sexual health. If you see section 375, 376, 377, they were about sexual health. There were other laws also that came to be passed in this regard. For example, POXO. So all of them talk about sexual health. Reproductive health goes again in a very say narrower way, I would say, or in a particular way, instead of saying narrower, in a particular way, to talk about reproductive health. This is about again same physical, mental, social well-being, and not merely absence of disease in all matters relating to reproductive system. Okay, it's about reproductive system. So when it is about its regular functions and processes, then maintaining good health, I mean the good reproductive health, is very much necessary, and that implies that people are able to have satisfying and safe sex life, and that they have the capability to reproduce and freedom to decide if, when, and how often to do so. The today's topic, in my topic, reproductive health is mentioned. That's why I'm going to focus on reproductive health. Okay, coming to this, what comes when we talk about reproductive health? Reproductive health care system in India also matters a lot, because after all, when a problem occurs, when there is a violation of a right of a woman, that becomes a matter of public health, because that woman is alone not facing such kind of violation of her right to health or a right to reproductive health. There may be similar such kinds of women in society, and that's why when such number gets larger, it becomes a matter of public health, and that's why the government has to take this into consideration, and then lay down the policies and pass the laws or implement the laws in that regard. So what comes in that? There are various methods, techniques, and services that come under consideration of reproductive health care. So there may be various kinds of schemes and policies relating to it. There may be healthcare infrastructure that is relating to it. There may be various kinds of methods to be adopted with respect to family planning, with respect to protection of rights of women, with respect to strengthening the ecosystem in order to enable the women to enjoy such kinds of rights. Now, what comes in such kind of strengthening of ecosystem? Perhaps the gender budgeting may be a part of it. Perhaps even the creation of, say, sufficient manpower, or I would say human infrastructure in that regard, also would come in this particular category. Do we have it in sufficient number? Do we have it equitably spread all over India? Or is it so available only in urban area and very scarcely available in rural area? All these parameters have to be seen, because public health, after all, is a matter of social concern as well. And when such reproductive health becomes a matter of social concern, we have to make a strong ecosystem in order to enable that women or strengthen that women to enjoy her right. Okay, what comes under this? Coming to our rights, when we have seen what is sexual health, what is reproductive health, what are the rights? So here it comes as like, say, right to decide freely and responsibly on the number, spacing and timing of their children, and to have the information and means to do so, and the right to attain the highest attainable sexual and reproductive health. Do we have any laws in this regard? Do we have any conventions at international level, protocols at international in this regard? Yes, certainly we do have. Okay. When we talk about human rights in the earlier sessions, you might have seen that human rights are inalienable, inexplicable, and so on. So having considered all that, when we are talking about reproductive rights are considered to be human rights by all such human rights instruments that are considered to be strengthening such kind of system. So when it comes to these rights, how can a woman decide the spacing and timing and the number of children? For example, if she has sufficient information about, say, some kind of instruments that are used for this, some kinds of methods that are used for this, for example, say contraception, would she be able to take a proper decision in this regard? What needs to be done in this regard? What policies should we have and how should that be implemented? Such questions also come to our mind. So when we talk about this, it's not just law that would play its role. It's not just the government that would play its role. It's all the elements that are associated with such kind of system that would have to play their own role. Okay, so the right to sexual and reproductive security also matters a lot in order to give you the right to live. What is this right to live? There are so many dimensions of right to life that you might have studied under Constitution. So right to life includes right to live in good environment, to right to live in gender in an atmosphere where there is no gender based violence. Okay, so many issues are associated with gender based violence that also has impact on the reproductive rights of the women. When there is sexual violence, as you have studied under IPC, it has impact on reproductive rights of the women. When the women are forced to have sexual intercourse or otherwise, that certainly have impact on their rights. Then there are many women who are the victims of other kinds of violence, for example, physical or mental abuse, dowry, and so on. That also has impact on health of the women, and then ultimately it has impact on the reproductive rights. So by just recognizing reproductive rights, will they be able to get justice? Because justice needs addressing so many problems that are associated with these rights. There may be social uh, situations, there may be political situations, there may be some other kinds of discriminations against women. For example, we have seen in case of PCP and DT, the act itself was meant or is meant for prevention of female feticide. And in case somebody undergoes that or takes part in that, in order to punish that person, it's a kind of discrimination, and that certainly affects the reproductive justice that a woman deserves to get. There may be some situations that are associated with inequality. Okay, so n number of examples can be given in this regard. I'm not going to give all such examples. With this discussion, you may be able to relate the situations with what I am discussing with you right now. So, this reproductive justice focuses on the vulnerable women who actually deserve to enjoy their rights. How can that be done? That's why such kinds of programs are there who create awareness in this regard. Okay, so we need to create workforce. It's not just the medical or paramedical workforce. is even the legal workforce that needs to be created in this regard. And then when such things are coming forward, I think we will be able to render reproductive justice. It's not just the function of the court itself to render such kind of justice. In order to get justice, it's not necessary that every time one should go to court. Justice can be rendered even within the society. Okay, when you create such situations within the society whereby the women is not forced to go to the court. Okay, going to the court is always the last remedy for every woman. So that's why we as the law workforce need to create, rather it's our responsibility that we need to create such ecosystem whereby the reproductive justice is actually rendered. Okay, so many issues are associated with such kinds of situations. Okay, I initially gave the example of abortion, okay, as a right, or say I also gave the example of contraception, sex determination. There are so many things that are not just restricted to this. They were just talked by way of an example. Okay, so how they are connected with each other. The figure to the right hand side may indicate that reproductive health is necessary. Okay, when it is necessary, it can be brought about by so many means. It is a part of reproductive rights. In order to enjoy reproductive rights, you need to ascertain reproductive health, and you have to ensure that such health is attained to the highest attainable standard by the women. I give an example. When you talk about human rights, you talk about accessibility, then availability, then affordability, justice, and so on. If I want to talk about, say, some right associated with it, then I need to see, is it accessible to me? Is it denied to me because of my poverty? Is it denied to me because they are not available at all in my location? I happen to come from, say, a remote area, say in Western Ghat. I don't have any healthcare infrastructure in my area. There are no doctors available, no nurses available. And my family tries to ensure that health is attained to the highest attainable standard to me. How would it ensure without having such infrastructure over there? So this, though it's considered to be a reproductive right, or though it's considered to be, say, a human right, which is imbibed in me, how will I be able to enjoy it? Okay, so that's why justice comes at a very later stage. I need to ensure all these things. And that's why there are so many cross-cutting and intersectional socio-political, economic, and identity inequalities that are associated with it. If we work on such kinds of issues, then perhaps we would be able to reach the goals that the law wants to achieve. What comes under this? In these rights, this figure may indicate in a better manner. Right to health, all of you know. Right to live, under Article 12, under Article 21, you know. All are connected with this. Right to privacy, right to decide the number and spacing of children, right to consent in marriage, and to equality. What is this? Consent in marriage, does it have anything to do with sexual and reproductive rights? For example, during COVID, we have seen that the child marriages increased to a very large extent because the parents would have to work and the children will be at home. Instead of keeping worried about such children, the people preferred to get them married, and on a very large scale child marriages took place. Within few months, it was observed that the flow of such young women coming to the gynecologist raised on a very large scale. What did it indicate? That these girls, though married, were minors and they were pregnant. What about the rights of such women Could they say no, or can they say no to marriage and then further pregnancy, or even choice of contraception in that regard? So many questions arise in such case. So consent we talk about, but are they aware that they need to exercise their right to consent? Are they aware? Even though they are aware, can they exercise their right beneficial to them? Such questions one needs to ask. Right to be free from discrimination. What is this? Free from discrimination. Okay, for example, when it comes to malnutrition, in many a times it is found that women are found to be anemic, and that's why many a times they are victims of so many health issues. Why does it happen? Why are they anemic? There are so many reasons. Either they are not aware about what should they eat in order to work on malnutrition. So lack of education may be the reason. Lack of opportunity may be the reason. One of the reasons may also be the discrimination at home, that men have to have their food first. They would be given good food, and whatever is left, that is given to women. Perhaps in urban educated family, this may not be the picture, but that may be a very common picture in rural areas or undernourished areas. Right to be free from practicing that harm women and girls. Free from practices that harm women and girls. What are such kinds of practices? One example I gave was child marriage. That is a practice that harms women and girls. Any other practices? There are so many. I'm going to show that in slides. Right to be free from violence, gender-based violence. So all these are associated with sexual and reproductive health. See how they are interlinked with each other. In the definition of sexual health or reproductive health, I had shown that WHO has considered even well-being as a part of health. And how can that be ensured? That's why all of them are connected to each other. For example, in sexual well-being, when I am talking about sexual respect, sexual self-esteem, okay, forgiveness of past sexual experience, comfort with sexuality, sex determination in one's sexual life. So many are there. I give the example, even in Pune, we have seen such kinds of incidences where the virginity tests are conducted before the marriage in some communities. What are such kinds of tests? Are they aimed at sexual well-being of that woman? Do they consider woman as a dignified person? It certainly has impact on sexual justice and sexual health. Okay, so that's why I say they are connected with each other. Okay, so they are not able to make their decisions for various reasons. See, this is the data. They face various barriers in exercising their reproductive and sexual health and rights as well. When we talk about human rights, when we talk about accessibility, availability, quality, and such kinds of parameters, what's the reality? You can see the percentage in Asia. Now, there are so many issues associated with it. If we talk about even the health budget, not even 6% of our budget is allocated to health. And even when it comes to women health, much is talked about various kinds of schemes that are undertaken by the government. But then the reality about how much it percolates to rural women, that needs really a rigorous research. Had it been so, the issue would not have persisted. See the statistics, and this is the official statistics. About half of India's women of reproductive age want to avoid pregnancy. How many of them have access to modern contraceptive method? Half of it, just half of it, see. And out of 47 million pregnancies that occur each year in India, 45% of them are unable to go for this. Then what happens? When it comes to sterilization policy or two-child policy that was adopted by our central government, and then when it was percolated even by the state governments to the society. When it is talked about sterilization, who are always the focus group? It's the women. And that's why the women's sterilization percentage is very large as against men. Okay, there are many issues associated with mass sterilization campaigns that are taken up all over India, because they are always target based and targets are women. And then there are so many complications in such target based campaigns. There are many issues related to pregnancy, care, newborn, and sexually transmitted diseases as well. Okay, I need not get into details of these statistics. Let me go ahead with this. I'll just show these slides. This is the data that was published and referred to by NHRC in its assessment of reproductive rights of women in India. That was published just few years back. Okay, why am I showing this? You might have studied about sustainable development goals that we need to achieve now by 2030. You might have even heard about Millennium Development Goals that we were supposed to achieve by 2015. In both of it, we have always lagged behind in reducing MMR, that is maternal mortality rate. And we have failed. Though we are marching towards the target, we couldn't achieve it by 2015, and that's why that period was extended for India. When it comes to MMR, we are behind even our neighboring countries. And what are the issues associated with that? So many. Now, coming to law that came to be developed, as we are law students, we have to look at the development of laws also in this regard. Okay. So in human rights development in earlier sessions, perhaps you might have discussed about various human rights conventions that came to be introduced to the world. So these are the developments, and especially from 1965, much is talked about reproductive rights as the human rights. Okay, coming to toxic practices that are around this reproductive rights and reproductive health. I mentioned about virginity test. Apart from that, there are so many things associated with reproductive rights. Exclusionary practices during menstruation. Even in today's era, we find that during the period of menstruation, in some families, the women are required to sit away from the other members in the society, other members in the family. Okay, why is it so? Because there are certain practices in that family that are considered to be holy and unholy, and that's why in Marathi call it as vita. Okay, so women are expected to observe that it, and they are excluded from mixing up with the other members in the family. And when it is done so, every time it's not assured that whether her hygiene is properly maintained. This is again a kind of practice. Okay, the kinds of clothes that are used during this period, all that is been shown even in Padman movie. Okay, so that are not properly taken care of. Then further virginity test I talked about. Then shaming of C-sections. What is this? C-section? That is cesarean section. In urban area, it is found that cesarean section is preferred by many women and is also considered to be a lucrative practice by the doctors, but it is not so in many areas. If it is good in the interest of the health of that women, it would be allowed, but instead of that, in many um, parts of rural India, it is seen that C-section is not good. So at the cost of health of that woman, she is kept at home, and then the institutional deliveries don't take place. Okay, some midwifery women come to help that woman, and then such kinds of deliveries take place. Then regarding PCOS or PCOD, there are so many misconceptions and some kinds of bad practices that are observed within the family. Then even the doctors are judgmental about premarital and non-marital sex. I have conducted such kinds of projects whereby I have seen that many doctors ask the woman that comes for examination whether she is married or unmarried. Okay, it's not their question to ask whether she is married or unmarried in order to see what kind of treatment is to be given. Okay, if it is found that she is unmarried, then they deny contraception kind of facilities to that woman. This is the first hand experience I have seen because I have conducted research on this. Okay, I have also seen that premarital consultation is given, but such kinds of services are not given. Further, it is also found that when a girl is found to be pregnant before marriage, then in that case, her boyfriend or whoever is there is required to come to give the consent. Even the parents are required to give the consent if the woman is pregnant before the marriage. Okay, I had to deliver some kind of consultation even to the Doctors Association in this regard as to what is considered to be consent under MTP Act and whether their practice fits into it. Okay, then that's why consent procedure in abortion also have some wrong practices that are adopted by the medical practitioners as well. Okay, so many are such practices. One of the practices here you may see is about female genital mutilation. There are certain communities in India. What I know is about Bohra community in India. I know about Pune that there were certain such kinds of practices that were followed in case of such young tender girls. And while undergoing such genital mutilation, what would be used was such kinds of razors, that too at the hands of some midwifery women, or say, I would say even those women who were not trained into it, even at the places that were not clinically considered to be good and hygienic for such kinds of purposes. Okay, and such is the practice in some kinds of communities in India, not just in India, in some other parts of the world, like say some African countries and in Middle East countries also, such kinds of practices prevail. And it is utter violation of the reproductive rights of women. See this. This is the percentage prevalence of FGM in girls and women between 15 to 49. Rather, in India, it is done at a very tender age, say about 6 to 7 years. See here, this is the report of UNICEF. At least 200 million girls and women alive today living in 30 countries have undergone FGM. This is the data that was published in 2016. In India, when such cases are reported, generally such cases are always means they are kept under carpet. But in case they come before the court, or say when the FIR is filed in this, that is filed under POXO, because it has the provisions in that regard. But so far, it is been still practiced in many parts of the world. This PIL is still pending. And this is the quote of Honorable Justice D.Y. Chandrachud. And at that time, the Chief Justice of India was Honorable Mr. Deepak Mishra. Our genitals are as private as any other body. Why nobody should be allowed to have the genital of a human being by bodily integrity should be violated and compromised. Okay. I talked about forced sterilization. In this regard, one may study the cases decided by Supreme Court, especially Devika Biswas versus Union of India and Ramakant Rai and another versus Union of India. In Ramakant Rai and another versus Union of India, the Supreme Court had taken the cognizance and had asked the ministry to lay down the guidelines in this regard. Accordingly, the guidelines were laid down, but they were not at all followed. And that's why when it came before the Supreme Court in Devika Biswas versus Union of India, the stringent strictures were passed by the Supreme Court regarding such forced sterilization measures. I remember in my childhood, there would be separate department that was meant for this, and government employees would be given targets about that they were supposed to achieve by the end of every month, that these many sterilizations should take place. And the people would, by hook or crook, procure such women, and they would be forced to undergo such kinds of sterilization. Okay, this is about gender-based violence. It is considered to be violation of human rights that has certainly impact on reproductive health, and they are very much associated with multiple human rights. Okay, right to life, right to be free from torture, right to health, privacy, education, discrimination, and so on. What are the various kinds of violations? Okay, there's so many causes and consequences. I have already talked about few of them. Now, in this regard, what laws we have? We have the laws, but they are either not implemented properly as usual, or there is no great awareness created in this regard. Now, so many issues, when we talk about, each issue is either kept unregulated or is regulated in an inefficient manner. That's why we find the incidences happening around us. For example, we have PCP and DT Act, but we find that yes, there is still such kinds of practices observed around us. We have, means in India, we have banned commercial surrogacy, but we found that commercial surrogacy, when was banned under the carpet, it was still practiced, and the surrogate mothers became still vulnerable. Since 2008, we had seen that, okay, various kinds of bills were drafted. But recently in 2021, the acts came to be laid down. The bills were passed by the parliament. They were notified further, and the act is still there. Now it will be interesting to see how actually the justice is rendered to those who deserve it. For example, surrogate mother. They are poor women who are not aware of their rights, and when they are made aware about their rights, how to actually avail them of. They are unaware. They do it for the sake of livelihood, and then they become the victim of the system. Recently, in 2021, another law that came in this regard, that is amendment into MTP Act. In earlier law that was passed in 1971, only married women could avail of the benefit of that law when there was contraception failure, because contraception was considered to be a major for married women only. But as I mentioned earlier, that the society has undergone so many developments wherein the people live in live-in relationship, or there is consensual sex between two major persons. In that case, if an unmarried woman becomes pregnant, then does she have any right on this ground? So on the ground of such discrimination, such amendment had taken place, which has now cleared such kind of discrimination. Then even gestational age limit that was increased from 20 weeks to 24 weeks. When in Nikita Mehta's case, it was found that the fetus was abnormal and there were less chances of survival, the court had interpreted the section in a very literal manner, and has also expressed that the law needs to be needed to be amended in this regard. There were so many such occasions in which thereafter, after Nikita Mehta's case, various high courts and Supreme Court also had taken cognizance of such need and had expressed the need for change into law, taking into consideration that now the gestation limit is increased to 24 weeks. If you see such development, I may show you that India is ahead of many of the countries in the world. Okay, where the abortion is allowed to take place just till 20 weeks or even 12 weeks in some countries. So on the ground of fetal abnormality, this is a very good step that our legislature has taken up. Then even medical practitioner opinions. In the earlier act, it was thought that if it is between 12 to 20 weeks, then 2 RMPs are required. Okay. Now here that is extended. 2 RMPs opinions is required when the pregnancy is between 20 to 24 weeks. Okay. Now there are so many cases associated with this. I would speak of some of the cases, not all. Miss X versus Mr. Z. This was a very interesting case decided by Delhi High Court. It was a matter of a right to privacy. A woman was pregnant, and then she went to AIMS, and then she got the fetus aborted, and then this fetus was stored in AIMS laboratories in order to be kept in laboratories for the sake of study of the students. Then it was discovered to the husband that the woman had aborted the fetus. There were the relations between the husband and wife were not good, and that's why husband wanted to know whether he was the father of that fetus, and accordingly he sought for such information under right to information. Okay, the woman objected, saying that this right to information is not applicable to this and it would affect her right to privacy and right to privacy of the fetus as well. So the questions before the court was whether the right to privacy exists in such a way as a part of reproductive right and whether the fetus has reproductive rights. In this case, it was held that the fetus, when is separated from the body, cannot have a right to privacy because it is a dead tissue. Second thing, about right to privacy as a part of reproductive right of that woman, the court observed that woman does have a right to privacy so long as the fetus lies in the womb of that woman. When it is severed from her body, then over the severed fetus, she does not have right to privacy. Okay, this is a very interesting trend that we have seen. Such kind of case came before Delhi High Court, and it was held that the husband is entitled to know. Okay, in Neera Mathur versus Life Insurance Corporation, also the same came. The woman had joined the job of LIC and she had undergone the medical examination. She joined, and thereafter she wanted to know about her pregnancy test, and the menstruation reports were asked by LIC, and the women had objected. On the ground of her right to privacy, her right was upheld. In Suchita Srivastava's case also, such right to liberty as a part of reproductive right was considered. You may be knowing this case as a part of right to life under life and liberty under Article 21. This case was discussed. In this case, this girl was living in an institution that was meant for mentally retarded children. The girl was mentally retarded, and she was raped by one of the say employees in that institution, and she became pregnant. So in the capacity of parents patri, in exercise of that right, Chandigarh administration approached the High Court. The High Court allowed the abortion of that girl. Okay, and against this, a women's rights organization went to Supreme Court, in which all the discussion took place. Now, in this case, when the literal interpretation was taken up of Section 3 or Subsection 4 by the court, it was seen that in case of consent to be given for abortion, whose consent is to be taken. So in case of mentally ill person, mentally ill woman, the consent of guardian would be taken. So Chandigarh administration had claimed that it was the guardian, and that's why they were giving the consent. In this case, the court applied the best interest theory and asked the medical board to examine the women. Before the medical board, the woman, means that girl, told that she wants to be the mother. Now, whether mentally retarded person is considered to be mentally ill, okay, the definition of mentally retarded, mental retardation laid down by WHO was followed, and it was observed that mentally retarded child was not considered to be mentally ill. And that's why, in case of such mentally retarded persons, in order to protect their human rights, the consent of that girl has to be given due regards at par with otherwise normal people. This was the observation of the court, and it was held that such mentally retarded women cannot be discriminated against on this ground. And then she was her right to reproduction was upheld as a part of say human right. Okay. Now these are some cases associated with technology. I don't know how much time is left. Let me go little fast. Okay. I work in the area of medical biotechnology also, so that's why I have included these cases. But I think the time won't perhaps permit me to discuss all that. Okay, I have already talked about gender-based violence, how they are connected with the reproductive health. Okay, this is one more act that is connected with this. In case of Maternity Benefit Act, the women are given certain benefits under this. Even we have schemes to that regard in India. So, okay, so many a times, all of you know that under this 6 months leave can be taken by a woman who undergoes this um, uh, procedure, I mean, who delivers a child. Okay, but whether the question is whether such benefit is given to all women, that's the question. Many a times it is found that the women on contractual basis are not given this benefit. Many a times it is found that such discrimination is done based on the nature of job that is taken up by these women. So all women actually need to be treated alike, but that doesn't happen. And many a times it is seen that many of the employers avoid taking just married women on jobs on this ground, that once they join, perhaps they may go on maternity benefit. Now, in this regard, the government had taken up many other schemes also, like say national maternity benefit schemes. Then, in order to assure financial assistance for antenatal care, government has come up with Janani Suraksha Yojana. Then, to provide some compensation towards wage loss, government has come up with in the Matrutva Sahyog Yojana. Such kinds of schemes are there. Again, the question lies how far they reach out to women who deserve them. Regarding egg donation, commercial surrogacy, ART, so many issues are there that are related to reproductive rights. Coming to this part, mental health and reproductive justice, how they are connected to each other. In India, we have such social behavioral pattern that after marriage, if a woman does not conceive within a period of 1 year, the people start asking questions from within the family and outside the family about good news. What that woman wants, what that couple wants, it's strictly their personal choice. But when the people don't get satisfactory answer according to them, they start stigmatizing that women. And if that period prolongs, that such women are humiliated also. And then it certainly has impact on their mental health. They undergo depression. And this is the ground on which even there are other kinds of problems associated with this in their marital life. For example, such women are deserted by their husbands. He goes for another marriage. Okay, what about the health of such women? Mental health of such women. You can look at these pictures that are just representative of this. Some women deliver only girl children. Then also they have to undergo a different kind of treatment, discriminatory treatment in the family. As against this, there are some women who have many children and can't have control over deciding how many children should they have. They have to succumb to the pressure of the husband or the in-laws. And when it comes to burden of bringing the children up, it is considered to be the responsibility of the woman. And that's why this is a very complex social structure that we have, wherein the law alone would not be enough. There are many issues with regard to menstruation, menopause, pregnancy outcomes, sexuality, gender violence, sexually transmitted infections, family planning, uterine prolapse, obstetric fistula, infertility, and so on. Many a times, as they are considered to be women problems, they are not much discussed within the family, or even the women don't go to seek the medical advice in this regard, and the problem persists and then it worsens. Okay, when I talked about Suchita Srivastav, I forgot to mention an incident that had taken place in Pune. In 1994, there were almost more than 14 or 15 forced sterilization operation, forced hysterectomies in Pune, in Sasun Hospital. They were mentally retarded girls, and their parents always feared that during their lifetime they would take care of their daughters, but what would happen to them after their demise? With such a worry, some parents had approached and they were discussing such kinds of issues with them. The women that were taken to Sasun Hospital were the institutionalized women who didn't have any say in this regard, and such forced sterilization took place, and the matter then came before the Bombay High Court and came to the forefront. Okay, but at that time, such kind of say, I would say, agitation had not come up the way we have seen in recent past. Now, when it comes to reproductive health, it's not just men who are, it's not just women who are important. It's the men's participation. Rather, whole society needs to take part in arriving at such a situation where the women are considered to be a human being, who have the human rights, who need to be treated with dignity, and then only the rights would be meaningful, and then only the justice would be able to be imparted to them. Now, when it comes to mental health, this is some evidence that shows that we are lacking in so many things. We don't have sufficient infrastructure, sufficient manpower. Even all public health programs that we have here in India, it may be National Mental Health Mission, or NRHM, National Rural Health Mission, National Urban Health Mission, or it may be anything, even National Mental Health Mission program. Okay, so there is no proper coordination amongst all these schemes. In majority of the scheme, mental health is not regarded properly, and that's why NHRC or such kinds of bodies need to come up in order to give more stress on mental health relating to reproductive rights or relating to such kinds of aspects. During COVID-19, NHRC had come up with advisory relating to mental health, and this was considered to be a part of it. But I think this needs to be taken more care of. We celebrate mental health day and such kinds of things, but how far we take care of this? Unless we remove the causes associated with mental health, then unless we remove all such causes, unless we eradicate the issues associated with that, we won't be able to succeed. And that's why, what can we do? We need to work on all such bases. From law point of view, we need to do something. From government side, from judiciary, from society, from media, from all levels, we need to work. So we need to strengthen our public health infrastructure. We need to have proper budgetary allocation. We need to strengthen our reproductive health services that women can access and afford in various parts of India. We need to have cooperation with civil society and all other stakeholders. That's why such kinds of programs, when are taken up, not just in law colleges, but even in other institutions, perhaps the purpose would be served. For a long time, the human rights movement has focused on the public sphere dominated by men and neglected the private sphere largely populated by women. This needs to be changed. women rights are now recognized as human rights supported by all increasingly vocal and activist women's rights movement. It's not just women's rights movement, I would say human rights movement. With due regard to Professor Mahmood Fathallah. After all, from a woman's point of view, I would say that don't expect the society to do something for you. Don't expect legislature, judiciary, lawyers, courts, and others to do for you. खुद ही को कर इतना बुलंद कि खुदा तुम्हें पूछे बोल तुझे क्या चाहिए. Such kinds of things. So after all, a woman needs to educate, agitate, and organize for this. Okay, when this is followed, there would be a real woman empowerment, and then she would be able to enjoy her right. Okay, that is what we have seen in case of first slide that I showed in case of abortion rights of women in America. That is what I showed in the second slide of Google women agitating for this. Okay? So don't expect that somebody will come for showing favor to you. You yourself organize for this, educate yourself and agitate against the violation. Then only you would be able to enjoy your rights as human rights. Thank you so much for giving me a patient listening. If you have any questions, please.
Thank you very much, ma'am. As of now, no questions have been posted by participants in chat box. So we will conclude session 2. Concluding session, I would like to thank Professor Dr. Jyoti Bhakre ma'am for taking time out and joining us today for session 2. It was really an honor to have you today with us. Thank you very much. I would like to thank our principal, Dr. C.M. Rao sir, Vice Principal, Dr. Professor S.N. More sir, IQAC Coordinator, Dr. Aparna Kotapale ma'am, Coordinator for this training program, Dr. Cheetal Parhati ma'am, Mrs. Pratibha Girbhane ma'am for introducing us with the theme of today's session, teaching and non-teaching staff of MP Law, technical team for MP Law, and last but not the least, all the attendees for their patient listening. Thank you very much everyone for joining us. Thank you, Jyoti ma'am. Now I hand over charge to Zia ur Rahman Khan for session 3. Thank you very much.
Hello and good afternoon, each and everyone here. My name is Zia Rahman Khan, a student of BA LLB third year. Today, we all have gathered here for the very purpose of conducting the third session on violence against women and legislative remedies. In the presence of our Honorable Chief Guest, Soma Bhattacharya ma'am, Assistant Professor, TS NLU, Visakhapatnam. So without goofing off, let's proceed further. Initially, I take this opportunity to invite Dr. Anju Singh ma'am, our teacher coordinator, for giving the introduction of the theme of the session, that is violence against women and legislative remedies.
Thank you, Zia. Good afternoon, one and all. I welcome you all in the third technical session. And the sub-theme of this topic is very important, violence against women and legislative remedies. We know that violence against women, it is not a new problem. It is a problem across the world. It affects women of all races, groups, classes, and violence of women takes variety of forms, from domestic violence to sexual harassment, intimate partner violence, economic violence, emotional violence. More importantly, consequences of such violence is like it can cause depression, anxiety, and suicidal tendencies among women. All of these violences are violating the basic human rights. The Indian Constitution, which is the fundamental law of the nation, contains a number of provisions for the benefit and protection of women. There are relevant legislations to protect women from all forms of violence. And to deal with this topic, we are glad to have respected Soma Bhattacharya Madam, Assistant Professor, DS NLU Visakhapatnam, on behalf of Marathwada Legal and General Education Society's MANIKCHAND Law College. I thank the organizers for giving me this wonderful opportunity. Thank you.
Thank you, ma'am.
Thank you, ma'am. There is a small humble request for all the participants to kindly switch your cameras, mics off for the sake of better connectivity of this session and avoiding the interferences. And right after the address of our honorable resource person, there would be a question and answer segment. If there are any questions relevant to the topic thereof, kindly post those in the chat box. Those would be answered after the address. So now, desperately, I take this golden opportunity to introduce our honorable resource person, Miss Soma Bhattacharya ma'am, Assistant Professor in DSNLU Visakhapatnam. Ma'am has completed her BA with distinction and MA in Indian History and Culture. Ma'am has completed her law graduation in first class and a gold medalist. She has post-graduation in law with criminal law specialization with a distinction and gold medal. She has qualified UGC NET in law. She was working as assistant professor of law at Gujarat National Law University, Gandhinagar, Gujarat. She has attended, participated in various conferences, various seminars and workshops. She has been a part of the national consultation on evolving a curriculum framework for law, poverty and development courses in law schools organized by Center for Social Justice in 2013. He was a member of High Court Legal Services Committee. He has delivered guest lectures at the Gujarat State Judicial Academy 2011. He was the consultations coordinator, Western Zone on Consultation on Protection of Children from Sexual Offences Bill 2011, organized at Gujarat National Law University, and participated in the national level consultations organized at National Law University, Delhi, in association with NCPCR 2011. She has been working as she has been the resource person on vertical interaction course for prison officers in collaboration with the Inspector General of Prisons, Gujarat, and BPRD, Ministry of Home Affairs, Government of India. She has conducted police training programs sponsored by BPRD New Delhi in association with Gujarat National Law University, coordinated the training program of human rights in prison management, organized in association with BPRD in 2011. And last but not the least, she was also a judge for Stetson Law Moot Court competition. I welcome you, ma'am, in this third session and would like to request you to please share your words of wisdom upon the topic.
Hello, am I audible?
Yes, ma'am, you're audible.
Okay, I am trying to share one content, one PowerPoint, but it's not displaying actually. Is it visible?
Yes, ma'am, visible.
Okay. Now? Is it visible now?
Yes, ma'am. Yes, ma'am.
Okay. Now, good afternoon, all the dignitaries, all the teacher, all the students who are present here. The topic that is given to me is violence against women and legislative remedies. So first, when the topic was given to me, I was literally thinking how to approach this topic. What is the best way? Whether straight away go to legislative remedies and take it in a very simple way, or first to go down to the root of certain terminology and then to connect that root and then to proceed with the entire presentation. So the phase of my presentation will be, first I will be discussing few terminologies like violence, woman, and after connecting it, the next stage of my topic will be violence against women, that is inside the home, where all the intimate partner violence as well as domestic violence act that is assigned to me, those legislation that will come, and a little bit worldwide view on that particular inside violence, the inside the home violence that takes place, that I will be highlighting in the first phase. In the second phase, when the woman goes out, enters into the workplace, and at the workplace, the nature of not violence, we can say, but the harassment that they have to face, and what are the legislative remedies that are available to that regard, and what is the worldwide position, that I will be discussing in the second phase. And after that, I will conclude my presentation. So this will be broadly outline of my presentation. So starting with the first aspect, as I already told you, first thing, is it visible, all of you? Hello? Hello?
Yes, ma'am, it's visible.
Okay, okay. First, I started exploring the term woman. What amounts to woman? Is there any definition of woman? Is it possible to define woman, the term? And if we are using the term woman, are we looking at this concept from biological perspective, anatomical perspective, genetic perspective, or gender related perspective? That is the first thing that came to my mind. So, in order to answer, because I was looking for an answer, so in order to find in this process of quest, I looked into Convention on Elimination of All Form of Discrimination Against Women. And there, I could figure out one interesting aspect. And the interesting aspect was that in that particular convention, discrimination against women, this terminology is used. And how it is used, it is saying state parties to the convention are forbidden, are prohibited to commit any discrimination against women based upon, that is where, sex. Now, when it comes to based upon sex, are we taking it from biological aspect? Again, the same question came to my mind. Or anatomical aspect, or genetical, or gender based? Because if it is biological aspect, then in that case, are we restricting the meaning of woman only to someone who can produce the egg? Or if it is anatomical aspect, are we only taking care of anatomical structure in order to define a woman? Or if it is genetical aspect, what about the women who are suffering from triple syndrome or triple X syndrome? Whether they are included or excluded. Or if we are taking women from the perspective of gender, because gender is very social specific, assigning the role, respective role. So are we taking it from gender related perspective? So that is where I got a report from United Nations Women. That means the cell who is very active in submitting the reports related to the condition of women, intimate partner relationship, intimate partner violence. So that UN Women Commission, they had to state that the term woman cannot be given a restrictive meaning. That means, for our knowledge, it cannot be restricted only to biology, anatomy, genetic, or gender. It includes everything. Everything. Now, after getting that answer, I looked into the next terminology, and that was related to violence. Now, when it comes to violence, first thing that comes in my mind is that, is there any difference between aggression and violence? So, in many social literature, especially sociological literature, basically, you will find violence is seen as, it is not defined, rather than this violence is discussed. And violence is discussed mostly as an intentional, unwanted, unwarranted, non-essential, harmful act. Now, in the same sociological literature, violence is taken from the point of social psychological approach as well as from animalistic approach. Now, American Psychological Association has defined violence as an extreme harmful act. Extreme harmful act means which has the capacity to inflict extreme injury to the other person. Now, what is that word extreme means? How can you define extreme? It is not possible to define extreme, especially in present circumstances. Therefore, in social psychology approach, the researcher, like I have already mentioned it here, Dewall, Anderson, and Bushman, they are the researchers, especially with respect to that aggression and violence. They have done considerable amount of research. So what they did, when they saw the enormity of the term violence, they decided that it is better to restrict the term violence from physical infliction of harm point. That means they differentiated aggression and violence based upon the propensity of the harm that is caused. If the propensity of the harm is more, it is violence. If it is less, then it is aggression. Now, one thing where I am very critical to this approach is that the term violence cannot be restricted only to physical infliction of harm. Because after that physical infliction of harm, there are many mental elements that will come into place. Psychological trauma, emotional trauma, who will deal with that? Mental health issue, many things will come into picture. So, it is not possible to limit the term only to physical aspect. So, what I did, next I looked into the animal research approach. Now, animal research approach, they have to say that violence is something where it is a ritualistic behavior. And this ritualistic behavior is for a prolonged duration, where the victim has subdued, victim is submissive, victim cannot fight, but that violence, it continues. And it has a obviously very bad effect on the victim. That means victim not only sustains physical harm, but there are considerable amount of emotional injuries, psychological injuries also. Now, when I connected this violence against women, this terminology, then I realized that in many households, this type of violence is a regular phenomena. Not only this, for some, it starts from home and it continues at the workplace. So maybe at home, the intensity is more. Maybe at workplace, it is less. In the form of harassment, it is coming. But harassment also has a considerable amount of psychological and mental trauma. So, connecting these both words, violence against women, next thing what I did was that I straight away went inside. That means place where the violence for women starts. Now, here one thing let me clarify. Since it is violence against women, I'm only restricting to women-related legislation. But if you see this violence categorization in some family, it will start right from the childhood, right after the birth of a girl child. But since my topic is restrictive in nature, I am only taking woman-female based violence. So, after understanding this violence and the propensity of violence and the nature to which it can be aggravated, I entered into the home to basically explore this intimate partner violence. Now, unfortunately, on intimate partner violence, from a criminological point of view, we may have data: victim of dowry prohibition act, victim of rape, victim of domestic violence act. We may have those data, but data are not sufficient. We require to analyze those data in Indian context. So, when I did this intimate partner violence, when I started exploring this thing, I have referred to District Attorney Office, Los Angeles, their information on intimate partner violence, a study that was conducted by Washington Post on developing and underdeveloped nation, and plus I have considered the report that was submitted by UN Women. Now, in this report, first, first their approach was inside the home when we are talking about. Then, in that case, how do we define intimate partner violence? Sometimes you will feel that when you are doing such kind of topic, you are lost in definition, lost in interpretation, lost in translation. So when I started exploring the term intimate partner violence, one thing I have noted here is that it cannot be restricted only to married couples. Obviously, it is extended to those who are cohabiting, those couples who are in living relation. Now, the question here was that before UN Women Commission, that those couple who are dating and living separately, whether they can be incorporated in an intimate partner violence? And the answer was yes. Not only married, living relation, or same-sex couple, but also those who are dating, because it is seen that there is a considerable violence that is observed among the dating couple, even though they are living separately. So that was also incorporated in the list of intimate partner violence. Now, the next question was, who is mostly victimized? Prevalence and incidence of such intimate partner violence. Now, prevalence and incident of intimate partner violence, that shows that the nature of intimate partner violence is not static. It varies. Varies in the sense, sometimes it can be a shoving, sometimes it can be a slap, sometimes nothing physical, but ridiculing the person, name calling, humiliating the other partner in front of everyone. So, there is a list that was basically shown by UN Women, right from the point of shoving to the extreme point of murder. They have shown the categories, different categories of intimate partner violence, like pulling the hair, or abusing somebody, or using slangs. Everything they have covered within their list of categories. Now, next thing that was there is that, what is the risk factor that is associated? It is observed that mostly such victims are from lower economic class, or those kind of society where the education is given very less to women, patriarchal dominated society, where financial aspect, movement aspect, educational aspect, everything of the female is restricted. But please, there is one thing, let me tell you, these phenomena is observed there, doesn't mean that it doesn't exist in upper economic class or highly educated people. It do exist there. There are instances that it happens in those economic class also. So we cannot negate it, because in developed nation, in the statistics you will find 1 out of 4 women is abused, and 1 out of 9 men is also subjected to this intimate partner violence. So here I am not trying to be biased. I am only trying to tell you what is observed. This phenomena is observed more among lower economic class or lower educational class, because the data is available there. And basically, when we do research, we have this thing in mind that yes, it has to come from that particular part. So we may direct our research to that particular, looking into that particular phenomena only. But this may not be the situation. Because the next point that is observed is that mostly it is the divorced woman or separated woman who are subjected to intimate partner violence. The reason why divorced woman or separated woman, that they become a single lady, and after that they become very vulnerable to such kind of violence. Even one unique phenomena that is noted here by United Nations Women, is that the point when the woman is communicating to the men that she doesn't want to live with him. That particular communication is also fatal, because at that time, many murder has been committed by men in that fit of rage, in that fit of anger. So after that, when I looked into this particular thing, that what is the response of police with respect to the reports of intimate partner violence. Thank goodness in Domestic Violence Act, we have different three mechanism is there. Like we have police, we have magistrate, we have protection officer. But in other countries, police is the only recourse. And it is observed that the response of the police towards the female victim of domestic violence is more active in comparison to the male victim of domestic violence. Now, after reading this entire thing, the next step was that I thought of exploring our Domestic Violence Act. Now, when we started exploring our Domestic Violence Act, first thing that I noted is the objective and purpose of this particular act. What is the objective and purpose? The first case, that is Indra Sharma, that is saying that it is to provide protection to the woman. The whole concept is protection. And Vandana versus Shrikant, Madras High Court is saying that the purpose of this enactment is to implement the recommendation 19 of Convention Against Elimination of All Form of Discrimination Against Women. That is, recommendation 19 of CEDAW is implemented by implementing or enacting and implementing this Domestic Violence Act. In Ishpal Singh, Bombay High Court is stating that the purpose, the objective and purpose of Domestic Violence Act is basically to provide relief to those women who have nothing, no property, no means of income, nothing. So after looking into the objective, I have gone into the question of aggrieved person. Who is an aggrieved person? That is any woman. In Pilani versus Meenakshi, Madras High Court is stating that woman and that respondent, they must be in a domestic relationship, no matter how much time period they were there. And in Krishna Bhattacharjee, that is the next case, Supreme Court is saying that this act is even extended to those women who are judicially separated. Because judicial separation, according to Supreme Court, is nothing but a suspension of the relationship of husband and wife. So even the separated woman can avail the benefit of this particular act. Now, the next terminology that I have included, or that is there in the enactment also, that's why I incorporated, domestic relationship. Now, domestic relationship, it can be by virtue of marriage, that is daughter-in-law, sister-in-law, any widow, or it is by virtue of blood. For example, mother, daughter, sister. So that is specified in the case of Indra Sharma case. Further, when I looked into the term shared household, in the term shared household, Madras High Court has stated that the aggrieved and respondent must have shared household at any given point of time. May not be currently they are doing it, but at any point of time, they have shared the household. So that will be incorporated within the definition of shared household. After that, I have gone into the question of domestic violence. Now, when I have seen the definition of domestic violence, at least if you remember, we have just done the violence aspect. That is physical aspect. It cannot be restricted to physical aspect. It goes to emotional, psychological trauma. All these aspects, the legislatures have tried to incorporate in the definition of domestic violence. They have incorporated abusive behavior, physical behavior, emotional, traumatic behavior, sexual abuse, name calling, even the economic abuse is also incorporated within this list of behavior. In this particular case, Hiral P. Harsova, in this case, previously, there was a term in Domestic Violence Act that stated adult male perpetrator. Now, this terminology was struck down by Supreme Court in Hiral P. Harsova case, and they have stated that it cannot be perpetrated only by adult male perpetrator. It can be any relative of the respondent. So it needs to be seen from that particular perspective. Now, after that, I have gone into this question of if a female is a victim of this domestic violence, what are the options available to her? What she can do? Now, there I have seen the role of a protection officer. Protection officer is basically a facilitator between the aggrieved woman and the court. And his main duties is that he is kind of a, you can say, friend, philosopher, and guide to that aggrieved. He can file a report to the magistrate with respect to domestic violence, forward that report to the police station having a jurisdiction within which this offense is committed, assist the magistrate, provide legal, medical aid to the victim, in certain circumstances to provide her with safe shelter. Not only this, even there is something called service providers within the Act. Service providers are registered voluntary organization or NGOs who can provide safe shelter and everything to the woman. Now, the question comes that what is the procedure to file a complaint of domestic violence? First, as I was telling you before, that we have this particular mechanism. You can file this complaint with the police or protection officer, or you can approach the magistrate. And once you approach them, the duties of these concerned official is that they have to apprise the woman with respect to her right, tell her about the services available from the Office of Protection Officer or service provider, provide her legal aid. These are the basic minimum requirement that is to be seen. But with respect to police, we already have one Supreme Court judgment that specially in domestic violence cases, in this case also Supreme Court has stated that before registering FIR, there must be some preliminary inquiry. Please understand, preliminary inquiry is not same as investigation. Only a preliminary inquiry to find out the fact of that complaint, whether there is a truthfulness or not. Now, after it is done, there are several reliefs that are available to the woman. For example, protection order can be passed. Protection order in the sense, after giving a hearing to the aggrieved and the respondent, if the magistrate thinks there exists a case of domestic violence or there is a likelihood of domestic violence, then in that case, the magistrate may issue protection order. Protection order in the sense, telling the respondent not to commit any act of domestic violence, that is fine. Second, all types of verbal, non-verbal, electronic communication with the aggrieved is completely prevented. Not only with her, but with her relatives also, with her dependents also. Second thing is the residence order. Now, Madras High Court has made it very clear that residence order can take different forms. Normally, the crux behind residence order is that suppose I don't have any house, where will I go and stay? Who will house me? In such circumstances, I can stay at the shared household of my husband. But it is to be ensured that neither the respondent or any of the relatives are communicating with me. I am giving completely a separate space, but sometimes it is impossible. So in that case, I may take a separate accommodation and the respondent has to pay the rent of that accommodation. Apart from this, the monetary relief can be granted if there is a loss of pay or anything. Monetary relief can be granted, any destruction of property, any kind of maintenance order to women and children under 125 of CRPC. Custody orders can be granted. Custody order again, only the visitation right will be granted to the respondent. Next, if I have suffered a lot, mental or emotional trauma, for that the compensation can also be granted. Last but not least, that after giving hearing to the aggrieved and the filing of the affidavit by the aggrieved, if the magistrate thinks, judicial magistrate, first class or metropolitan magistrate, if he thinks that there is a domestic violence and there is a near possibility of domestic violence, then in such case, interim order and ex parte order can also be granted. Now, this is the situation in India. Moving ahead, after reading Indian laws, I wanted to explore what is the situation all over the world. Unfortunately, UN document has stated that these countries, these are only countries that I can show in the PowerPoint, who don't have any specific law on domestic violence. Nations that are improving, for example, Kyrgyzstan and Liberia, very recently in 2019, 19 they have introduced it. I think 2021 they have introduced this particular law, with respect of which, if the woman complains of domestic violence to the police, police is the only authority in their country, the police can make surprise check to find out the well-being of the woman. And in Tunisia, Jordan, and Lebanon, they have abolished their rape marriage law. Nations that have afforded, who have already laid down domestic protection, domestic violence act, is North America, Europe, South Africa. These countries are there. They are there. They already have this domestic violence act. But domestic violence act, more or less, in their domestic violence act, you will find more involvement of NGOs, voluntary organization, counseling, and all these things are there. And this is the recent report, that is prevalence of violence among women and girls. This 4-5 point is the recent report from UN Women document, where we have observed that intimate partner violence is more with respect to women and girls. Not only this, COVID-19 had an adverse effect. It is also endorsed by WHO, World Health Organization, that during COVID-19 lockdown period, women and girls were subjected to worse kind of harassment, worse kind of violence. In fact, in the country like Iraq, Sudan, and all these, there was a very bad condition. There was a condition even to the extent of murder also. Next point, it is seen that mostly the women, what they will do, instead of reporting the violence to the concerned authority, they prefer to report it to someone who is nearest and dearest to them, either their relative or their friends or whosoever they rely. Now, one very interesting thing that I have observed with respect to law on violence against women and girls, especially in certain countries, especially the Middle Eastern country, they have the tendency to see domestic violence more as an internal matter. So, the laws are also very softly drafted. If they have at all any law, that will be very softly drafted. Because of which it is observed that the extent to which these kind of violence will go, where one of the partners, for money or food or anything, they will be selling their own wives, children, especially the female children, at the hand of somebody else. And 2020 report of UN Women that shows that all over the world, there were around 81,000 women who were killed, who were murdered. That is also the reported statistics. Unreported, we don't know. And out of these 81,000, 48,000 were victim of intimate partner violence. Now, hello? Hello?
Yes, madam.
Yes, ma'am.
Okay.
Yes.
Okay. Now, after looking into this scenario of intimate partner violence, next thing that I did was just to go into what happens to women when she decides to go out and work. The kind of behavior or nature or aspect that they have to face with the outside world, that I decided to explore at the next stop. That is where it has come out with the sexual harassment at workplace. So I'm not starting with that initial thing that, what amounts to sexual harassment. Obviously, that I have to do since it is a legislative remedies. But first thing that I'm taking is, what are the different types or conduct that amounts to sexual harassment? You can see I have put it there. Any advances for someone, it is very cool to make sexually content remark. It's very cool, but it is not so cool with the victim, because since it is not a gender neutral legislation, so it is not cool with the woman. So that is where some kind of suggestion on the body, on clothes, slurring, making some sexual gestures, right? This I have listed out here. Not only here, in the next slide also I have listed out whistling, staring. It is very interesting. If you see guideline number 11, staring at the body part of woman. Now, interestingly, you will find Netflix have entered in their official policy that if two employees are talking, or employee or employer is talking, in that case, the eye contact shall not be more than 5 seconds. If the eye contact is more than 5 seconds, then in that case, that can be a ground for filing a complaint. Now, it has come under attack that how you will determine, in order to see that other person is staring at me, I also have to stare back. So these are the things, but please understand one thing, that such kind of policy was also incorporated with a company like Netflix. Now, you can see Eve teasing, gender-based remark and everything. This I'm not reading it. You can just go through it once. Now, after that, we straight away come to the famous case of Vishaka versus State of Rajasthan. I think most of you must be aware about the facts of the case. But what was implemented by Supreme Court here? Recommendation 12 of Convention Against Elimination of All Kind of Discrimination Against Women. Recommendation 12 was applied. Why I'm telling you? Because in most of the sexual harassment legislation all over the world, you will find these points which were incorporated in Vishaka judgment from recommendation 12 of CEDAW. First is what? Physical or sexual advances. Second, unwanted sexual remark, sexually colored remark, demand or request for sexual favor, showing pornography, any kind of unwanted verbal or non-verbal, sexually colored behavior. Now, in Apparel Export Promotion Council versus AK Chopra, another ground was added by Supreme Court. They stated that because of such behavior, there is a hostile environment and very negative environment that is created for women, where it is impossible and suffocating to work. In Medha Kotwal, it was basically noted by Supreme Court. It was brought to the notice, and Supreme Court has also noted, giving a strict guideline that this sexual harassment law, the internal committee, complaint committee, it has to be constituted in each and every offices. Now, what is this sexual harassment laws that we are talking about? First thing is that who is the aggrieved person? Now, it is not only the woman who is working at workplace, even a client and customers are also covered within this concept of aggrieved woman. The next is, who are the bodies? What are the bodies that are covered? I have already mentioned it. As far as possible, they have tried to cover these bodies within the terminology of workplace. Now, what amounts to sexual harassment? This was the question that was there before Delhi High Court. Now, Delhi High Court observed that sometimes what happens when a person is making a remark, that remark may have a sexual tinge. But that person may think that, okay, it is fine with me if I am making this remark. What is there in this remark? This is a simple thing I have said. If the other person is sensitive or say oversensitive, and if that oversensitive person thinks that no, this remark is very, very objectionable, because what is sensible, what is oversensitive, it varies from person to person. In my personal life only, I have seen that if somebody is giving compliment to someone that yes, you are looking nice, what is the harm in that? But other person is saying, I will go to ICC and file a complaint against you. That is where there is a role of internal complaint committee. And you will see in the judgment that I will show you, where it is time and again highlighted that they have a very responsible role to evaluate such situation. What amounts to employee? All the description is given here. Now, what amounts to workplace? Now, in Saurabh Kumar Malik, this is a typical case that happened. In this case, the victim of harassment was the senior woman, and she was harassed not at the office but at the guest house where she was staying, and that too by her junior, by her subordinate. And subordinate stating that the lady is my superior, my boss, so I don't have any mileage there. What will I get by doing all these things? And second, if at all
Hello.
his personal secretary. Personal secretary is sitting somewhere else. And when she complained, CEO has to say that it is not at workplace we are doing. That is an online platform. Now, that is where Delhi High Court stated that proximity to the work, control of management on that workplace, and the relationship which these people share. That means the employer and employee. So, considering this thing, even if something is done at online platform, the complaint can be filed. Applying that thing here in this case, Delhi High Court stated that this lady who has filed the complaint, she was transferred to this office where she was subjected to sexual harassment. And the guest house where she was staying, that is official guest house. She was staying in that official guest house. So that guest house become the extended workplace. And second, nowhere the act mentioned about senior or junior, it mentioned any woman. So regardless of her position, she is a woman, and this particular sexual harassment was directed towards her by her subordinate, and subordination is not the criteria. Criteria is it has gone from that man to that female. After that, one of the most heated topic is the internal constitution of internal committee. Remember, all these cases, it has to be seen and examined. What is extended workplace, where it has happened, who has caused it. This is basically, primarily, it is the responsibility of internal complaint committee, which must be headed by a senior woman and two officer from that department or from that officer, from that office, who is dedicated to the cause of women, who are sensible, approachable, and one external member from any NGO has to be there. Most of the state, for example, especially I remember Maharashtra and Telangana, they have come out with, even Gujarat also, they have come out with the notification that this internal complaint committee has to be registered. And those people who are not working at offices, for example, maid servants, or where the employment is less than 10, for them, there is a local committee, and local committee will be headed by a senior woman officer, one woman officer who is working at district or taluka level, and one external member, preferably from an NGO. Now, after that, after this mechanism is created, whenever a sexual harassment complaint is to be filed in this complaint mechanism, these are some of the essential things. It is good if it is followed while filing that particular complaint. First is, complaint must be well drafted. It must be directed to the IC member, internal committee member. It must be in simple language, narrate what has happened, if possible, detail of exact date and incident. Sometimes it may not be possible. So at least mention what has happened, in what circumstances it has happened, what was the circumstances before that, after that, what was the attitude of the complainant, any SMS, WhatsApp messages, any call, any kind of, email, that record has to be there. And most importantly, against whom you are filing, the name, designation of that particular person. And one important thing, don't mention any false or incorrect thing. Incorrect thing, that is the most important thing. Now, if the woman wants, if on her request, before starting the inquiry, there may be a conciliation procedure. But if there is no conciliation procedure, then it will straight away go into inquiry. Now, these are some of the things that is to be followed, like the complaint, how many copies of complaint. These are do's and don'ts. Within 3 months, it has to be filed before internal committee. These 6 copies, one of the copies will be given to whom it will be given? It will be given to the respondent. Within 7 days, within 10 days, respondent has to answer back. Within 90 days, this entire inquiry should be over. Report writing should be over within 10 days, and it has to be submitted to the employer. An employer has to take a decision within 60 days. This is basically the process in which it goes. Now, the Act provides for Prevention of Sexual Harassment Act provides for interim relief also. If the woman is too traumatized, then in that case, what to do with her? Grant her some 3 months of leave in addition to whatever leave she has. Not only this, If she doesn't want to work in that premises, transfer her somewhere. Transfer is not as a part of punishment. Transfer is just a part so that she can attain that peace of mind. So any other relief that is required for that particular aggrieved woman, that can be provided to them. Now, what is the nature of punishment and compensation? Normally, such kind of punishment in such situation should be mentioned in the service rule book. What will be the disciplinary action? What will be the nature that is to be followed? What will be the punishment? It should be there in the service book. If there is no service rule book, then in that case, normally in sexual harassment cases, you will find it may be a loss of increment, demotion, transfer, counseling, community services. Now, in extreme cases, it can be the dismissal after following the procedure. Now, for frivolous complaint, now there is one thing. Internal complaint committee has to make a distinction between a frivolous complaint and the complaint that the aggrieved person is unable to prove. If I'm unable to prove something, doesn't mean the nature of my complaint is frivolous. And the responsibility lies with the internal complaint committee to make a distinction between two. In case of frivolous complaint also, the same nature of punishment will be there, increment, loss of increment or demotion and all these things. And one of the most important thing is that throughout the confidentiality of the procedure should be maintained. Normally the case names only after it goes in appeal and all this thing, it comes out to show that the justice is done, the attitude of the court, so that it can deter the future offender. Now, internal complaint committee has to be constituted. If it is not constituted by employer, then there are consequences for that. He will be fined with 50,000 rupees. And there is a possibility that establishment may be delicensed. So employer has certain rights and duties in that line. First, he has to create a gender sensitive workplace. When new employees are entered, some kind of induction session based upon that entire thing, induction session where one of the topics can be of this gender related issue, apprise them about the enormity of this fact, penal consequences, have a wide dissemination of the internal policy, give the name of the members of internal committee, right? Treat it. See, the basic thing, the crux of the entire thing is that employer need to have a zero tolerance policy with respect to sexual harassment. Now, these are some of the anti-sexual harassment policies. Normally, if you go to any associate, they will say that if you are making any sexual harassment, anti-sexual harassment policy, if you want to apprise your employee, this is the thing, this is the basic thing that one has to follow. In the policy that is regulated by the or that further implemented by the employer. Now, there are other laws. We have IPC, we have Industrial Employment Standing Order 1946. We although not directly talking about sexual harassment, but wage regulation, time regulation, dignity of the worker. So in a way, that dignity aspect, automatically it brings that protection to the employee within this realm of industrial employment standing orders. Now, these are few cases. First thing, in these two cases, what constitutes sexual harassment? Now, here, I'm not discussing the cases separately, but just I'm clubbing it and saying that Delhi High Court has observed that if female employee is going out of station, even out of station is also incorporated within the meaning of extended workplace. Second thing, where it was observed by Kerala High Court that deliberately the terminology workplace, we have come over a period of time what amounts to workplace, but deliberately it is not good to define workplace, because over a period of time the concept of workplace may likely to change. We have seen the definition, which bodies are covered and all those things, but over a period of time there is a possibility of change in the terminology of workplace. So it is better not to define it now, leave it to the time. With the passage of time this terminology will develop. Now again, there you will find that, see, not only this, when we talk about sexual harassment, apart from recommendation 12, it is also stated, and in most of the foreign legislation you will see that creating hostile environment also amounts to workplace violence. Now, there are cases where it is seen that a single intemperate behavior, one day I may shout on somebody, that doesn't amount to sexual harassment. Shouting can be on any issue, that why are you late or why you have not done the work, that doesn't amount to sexual harassment. But when it is continuous and when it becomes personal in nature, then it is creating a hostile working environment for women. Now, coming to filing of the complaint with the IC, anybody can file a complaint. Even my co-worker or my colleague, if she is seeing that I am going through this worst phase, but I don't have that capacity or strength or that guts to file a complaint, she can do that, provided I have to support it. That is also necessary. It should not happen that she has filed the complaint on my behalf and what I do, I simply trail away. Not only this, even if there is an availability of alternative remedy will not disuse. Alternative remedy means if you are filing a writ petition before High Court will not say that first go to ICC and then come to us. The victim can avail that writ petition also in this particular judgment of Delhi High Court, Sarita Verma versus New Delhi Municipal Corporation. Now, how can IC be constituted? One of the essential element of IC is that in all the judgment, it is stated very clearly, whether it is High Court or Supreme Court, that there must be an external member. External member may not be well versed with the provision of law, but external member must have dedicated some time or dedicatedly worked towards the cause of women and children. That is the qualification that is to be seen. Now, what are the powers of IC? With respect to the powers of IC, it is observed that internal committee can grant relief, interim relief. Not only they can grant interim relief, they can enforce the attendance of the witnesses, they can enforce any document. So, in short, this particular internal committee, they can decide their own procedure, provided it must be based on the principle of natural justice. Now, conducting these inquiry proceedings, with respect to conducting these inquiry proceedings, in all these judgment, it is observed that it must be within 5 kilometers from the place of incident. And the court having a jurisdiction on that particular place of incident can take cognizance of that matter. Why this issue has come up? Some sexual harassment happened at Kolkata. In Kolkata, some restaurant, this issue happened. Some party group had gone there. Some office group has gone there for party and it happened there. Now they wanted to file the case somewhere else. So that is where it is stated that since it happened within the jurisdiction of Kolkata, so there the court has the jurisdiction to take cognizance. In fact, the employer's rights and employer, not only they have a zero tolerance policy, but employer also has to see that there is a statutory body IC, it is constituted within their office. Otherwise, there is a possibility that they will be penalized for them. Now, there is a wider interpretation of what constitutes to sexual harassment. We have seen even the workplace, depending upon the situation, workplace hostility is also incorporated here. Employer's failure will cost him 50,000 plus the derecognition of that particular office, that is possible. And there is always an external member who should be there, right? Extended workplace, so far out of station is there, but even extended workplace can be anything. Suppose I am going to pick up somebody from airport. So if I'm picking up, I'm going with my colleague. If my colleague does something to me, then in that case, that again extended, it will be interpreted as a part of extended workplace. Now, if there is a conflict of interest among IC members, conflict of interest means suppose you are a president of IC, chairman or chairperson of IC. Now something happened before you. You have witnessed it. It is better to recuse that matter. Because if you don't recuse it, there will be an issue of conflict of interest. So, whenever there is an issue of conflict of interest, court will see such situation. Suppose what if there is an allegation of biasness against the committee? They will stop functioning. They will hold it for a moment. And they will see whether there is really a biasness or not. After that, they can continue with the inquiry. Now, improper investigation. For example, we have seen that a copy of that particular complaint should go to the respondent. What if it is not done? It will vitiate the entire inquiry. Normally, the high courts will not interfere in such inquiry, but it is stated very clearly that the court will not interfere, but if principle of natural justice is not followed, irrelevant factors were considered, relevant factors were completely, was not looked into. If the decision arrived is such which has no connection with the facts, only in such circumstances, the court will interfere. Normally, all these things, all these aspect, punishment and everything, it should be there in the employer's service rules. If it is not there, then in that case, employer in their sexual harassment policy, they have to mention all these aspects. The limitation period is 3 months, but if the aggrieved person is not able to submit the complaint within a period of 3 months, then in that case, extension of time with reasons can be provided by internal complaint proceedings. There is also a criminal proceeding remedy under this Prevention of Sexual Harassment Act. But here, in this case, it is stated by Karnataka High Court that if a person was given a clean chit by internal complaint committee, then again filing FIR based upon the same facts, it will be nothing but a waste of time. Now, after looking into this point, I have gone into the worldwide scenario. Now, worldwide scenario is, I mean, somewhere it is happy, somewhere it is sad. For example, if we are taking Australia, they are talking about undesirable behavior of sexual nature at the place of at workplace. In Czech Republic, they are saying unwanted behavior. Denmark and Israel has made their sexual harassment law gender neutral. France is saying that sexual harassment is possible only from someone who is a person of authority directed it towards someone who is inferior or subordinate. That is their definition of sexual harassment. But what if it is committed in between the employees? Then in that case, France is saying it is not a sexual harassment, but it is a moral harassment. Pakistan is on its way to draft its sexual harassment laws. Philippines have categorized it. They have made several categories and they have provided procedure for that. Several categories means women at workplace, trainees, applicants, student. For them, separate aspect, separate sexual harassment aspect they have provided with separate procedure. Poland has also made it clear that unwanted, undesirable behavior at the place of work, which has the capacity to create hostile environment. Unfortunately, in Russia, Moscow Center for Gender Studies, they have shown that although Russia has sexual harassment laws, but it is not taken seriously by the court of law. In Switzerland, they have a series of gender equality laws, gender equality, prevention of sexual harassment at workplace. United Kingdom, they are mostly on this issue that any behavior, it should not disturb the workplace environment. And in United States, not all kind of sexual harassment is not all kind of sexual harassment or all kind of behavior, untowards behavior or sexually oriented behavior is not treated as sexual harassment. They have their own categories under fair employment practices. Only the aggrieved one, which has the capacity to disturb the work environment, they are taking those as a sexual harassment. They are taking those things as a sexual harassment. Now, after doing this, my main thrust is to see that where do we stand? What else we have to do? Now, one thing I realized, see, I'm reading this law, I'm talking to you. So maybe somewhere in your mind, you will have that notion that there is something called protection officer. Or when I'm reading it, I also get to know that yes, there is something called protection officer, service providers are there if I'm in need of them. But think about those people who are not aware about these enactment. Forget about enactment. They are not even aware that what they have to do. So my only humble suggestion is that when we celebrate those kind of thing like 8th March as International Women's Day and all this thing, why not to declare that month as a kind of women awareness month? And there our legal service committees which are there, which are in the institutions, they have the major role to play, and they are the one who can create awareness about these factors. Not that what will happen or teaching them the provision, no. These are the things that are there, and if you are in need of them. And in case you don't know what to do, at least come to us. We are there to help you. I feel this minimum level of awareness is required. If that is there, then in that case, I think these acts will be of glaring success. Thank you. Hello.
Thank you. Thank you so much, madam. Thank you so much. Yes, Zia, continue.
I'm not able to hear you. Hello.
Hello, madam. Can you hear us?
Yes, ma'am. I can hear you now.
Yes. Okay. There might be some network issue in another computer
Yeah.
lab. Thank you so much, madam, for your informative speech. I think there are no any questions in the chat box.
Yeah, I have checked that.
So on behalf of MLNG Society's MANIKCHAND PAHADE Law College, Aurangabad, I thank you, madam, for sparing time for us and for giving such a wonderful and informative speech. Okay, thank you so much, madam. At the same time, I am thankful to Principal Dr. C.M. Rao, sir, Vice Principal More, sir, IQC Coordinator Kotapalle, madam, teacher coordinator of this session, and all the participants. So with the permission of chair, I declare this session as over and immediately will be moving ahead for our last session, which will be on human rights. I request Mihir Karnik to take over the charge. Mihir, are you there?
Yes, ma'am.
Okay. Thank you, madam.
Thank you, ma'am.
A very good afternoon to one and all present here. Myself, Mihir Karnik, a student from BA LLB 4th year, welcome you all on behalf of MLNGE Society's MANIKCHAND PAHADE Law College, Aurangabad. We are gathered here for the 4th session of online national level training program on correlating women's rights and human's rights, a human developmental approach, organized by MANIKCHAND PAHADE Law College, in collaboration with National Human Rights Commission, New Delhi. I take this opportunity and cordially welcome our resource person for this session, respected Dr. Banerjee Chakta sir, Dean and Professor of Law at VIT AP University, Andhra, and also the teacher coordinator of this session, Dr. Dinesh Kolte sir. This session will focus on the human rights. Therefore, to introduce the theme of this session, I request respected Dr. Dinesh Kolte sir to kindly take charge of this.
Thank you, Mihir. Good afternoon to one and all present here of this and respected resource person of this session, Honorable Dr. Banerjee Chakra sir, Dean and Professor of Law, VIT AP University, Andhra Pradesh. I welcome you, sir, in these first sessions of these sessions of National Online Training Program on correlating women rights and human rights, a human development approach. The theme of this session is UDHR, constitutional provisions, international covenants regarding human rights, Protection of Human Rights Act 1993, compositions and functions of NHRC. Human rights are a set of principles concerned with equality and fairness. They recognize our freedom to make choices about our lives and develop our potential as human beings. They are about living a life free from fear, harassment, or discriminations. Human rights are moral principles or norms for certain standards of human behavior and are regularly protected in municipal and international law. They are commonly understood as inalienable fundamental rights, which a person is inherently entitled simply because she or he is a human being, and which are inherent in all human beings, regardless of their age, ethnics, origin, locations, language, religion, ethnicity, or any other status. They are applicable everywhere and every time in the sense of being the same for everyone. And they are egalitarian in the sense of being the same for everyone. Magna Carta or a Greater Charter was one of the world's first documents containing commitments by sovereign to his people to respect certain legal rights. Rights and respecting those rights. This means that rights involve responsibility and duties towards other people and the community. Individuals have a responsibility that they exercise their rights with considerations for the rights of others. The human rights covers. Human rights cover virtually every area of human activity. They include civil and political rights, which take part in the civil and political life of the committing without discriminations or operations. With this, I welcome our respected resource person, Dr. MANIKCHAND, in this session. Thank you. Over to you.
Thank you very much. I think, can I start?
Sir, just a second. We are extremely honored to have Dr. Banerjee Chakkar with us today, and I would like to take this opportunity and say a few words about sir. Dr. Banerjee Chakkar graduated from Andhra University with LLB. Sir subsequently pursued his LLM, MPhil, and PhD along with a PG diploma in learning, teaching, and research in higher education from National University of Ireland, Galway. Sir has been an international scholar at School of Oriental and African Studies and also at the Hague Academy of International Law. Sir has also been a legal advisor to the International Committee of Red Cross and a researcher at Center for Studies and Research in International Law at Hague Academy of International Law. Sir has also been a judge on prestigious moot competitions like MANIKCHAND International Space Law Moot, Philip Jessup International Moot, Henry Dunant Memorial, and many others. Sir is currently working as the Dean Professor of Law at VIT University, Andhra. It is a great honor to have you with us today, sir. I would just like to inform the attendees in order to ensure the smoothness of this session, I request all the attendees to keep their microphones muted and also their video cams turned off. And also, if you have any questions, please leave them in the chat box. We will be dealing with those questions after the sir has completed with his address. Without any further ado, I now request our respected resource person, Dr. Banerjee sir.
Yeah. Thank you very much. And I hope it is audible to all of you.
Yes.
Yeah,
sir.
thank you.
Yes, sir. It is audible.
Yeah, thank you very much.
Presentation is also visible.
Yeah, thank you very much, and very good evening to one and all. And first of all, I would like to thank MANIKCHAND PAHADE Law College for inviting me to deliver this lecture. And at the same time, I would like to apologize. I supposed to speak about this basic human rights mechanisms during the morning session, but due to my pressing meetings back to back, I requested the organizers and Professor C.M. Rao sir to keep it in after post-lunch session. Then they took all the pains and all the things to accommodate me in this. I'm really, really grateful to all of you. So once again, I thank the college management and particularly my teacher, Professor C.M. Rao sir, who has always inviting me to be part of this discourse of human rights whenever it has been organized by MANIKCHAND PAHADE Law College. And I'm so honored all the time and being a part of these events and very wonderful and important events and sharing some of my thoughts with you. So today I'm going to take you to the very important mechanisms of international human rights treaty mechanisms. Like the topic which allocated to me to cover the aspects of the emergence of Universal Declaration of Human Rights and international covenants on human rights, along with the constitutional provisions which we have in our Indian constitution and in domestic law. And subsequently, we are also looking at, we have this national human rights institutions which adopted by the government of India way back in 1993. Almost it is 30 years, 3 decades of wonderful work conducted by the NHRC, where we could see that today it is NHRC, because of the NHRC advocacy program, we are able to reconnect again. And we are going to discuss their what is the act and the composition and the functions of National Human Rights Commissions. So if you look at that, the kind of an introduction to the human rights and the human rights mechanisms, primarily from the day one, we are trying to talk about that. Just give me a minute, my dear friends. Sorry. So if you look at that, the entire idea of human rights, now the sessions which we had in the morning, I happened to participate in the inaugural session. And inaugural session, both the chief gets keynote address given by Professor Poonam Saxena ma'am, and inaugural speech given by the Justice M.M. Kumar, the former Chief Justice of Jammu and Kashmir High Court, presently who is a member of the National Human Rights Commission. They have extensively spoke about the rights and where we need to bring a different kind of dimensions to the rights of women. Like if you look at that, Professor Soma Bhattacharya madam has nicely put that what is the relevance of this particular law when we are not able to create the space. She has given wonderful judgments and she highlighted everything, and I'm very, very thankful because you all have got the foundations of this entire system. So my lecture and my discussion today is going little backwards of what are the foundations for all these things. These foundations are not a new thing. They are there. And they said it is a normative practices of the each and every society. If you look at that, the idea of human rights is not as a kind of new phenomena. And some of the people, they are saying that, oh, it is only emerged in 1948 after the Hitler's massacre, which was committed against the Jewish population in the during the Second World War. Suddenly, the Western world has woke up and tried to give the human rights. So I think that is not quite clear. What I would like to say that it is there in every culture, in every civilization. It is there in the historically rooted in every culture. It's a normative practice. And if you look at that, it is associated with the individual rights against the injustice and the exploitation. So if you look at that, the former Supreme Court judge, Justice V.R. Krishna, has spoke about it. That is ultimately humanity has to have a commitment to the history to make human rights are a very viable reality. So if you look at it from the perspective of this particular statement given by the Justice V.R. Krishnaiah, it is the duty of us to create the place and spaces for each one of us to realize the rights which are mentioned there. Whether it is the rights of the children, or rights of girl child, or rights, protection of women and empowerment of women, and whatever the rights we are talking, we must be able to show our commitment to the humanity, makes available these rights, and we need to create an ecosystem. So that is where we will have to see that. And please remember that it is not as a Western concept. It is not that it is only came out suddenly from elsewhere. If you look at that, the roots of the protection of the rights, we can trace back as early as the Babylonian civilization and the laws, the cultures, and they have the human rights despite of the differences in the various content and context, but it is there. So, but some, if you look at it in our jurisprudential aspects, we have these human rights rooted through the various ancient societies by the philosophical concepts of natural law and natural rights. So we all say that we have naturally inherited the basic rights, being a virtue of humans. We have the basic rights which we have inherited from the nature. It is not that given by someone else. It is not the charity. Rather, it is the basic right. Today, we all say that, oh, we need to create a special mechanisms for the women empowerment. We need to create special provisions for the women. Who are we to create? It is there. It is there. But over a period of time, because of some political, cultural, and economic reasons, we have not recognized them. Let me put it very clearly. Today, we talk about that we need to protect our children and we need to protect their rights. We only talk about the protection of their rights, but are we creating the ecosystem? Are we have the system which we anciently inherited and rooted through the system of law? Yeah. So that is what we will look at it and we will say, and it is very important. Like Greek philosophers, if you look at that, recognize the idea of the natural rights. As we say, it's a naturally inherited rights across every human being, irrespective of their identity. Today, only after liberalism came, we speak about that, no, we need to recognize. And what happened from the ancient societies to the emergence of liberalism here? During this particular period, because of the influence of certain religions, because of the influence of the certain economic, social conditions, what happened? They are not able to realize the rights of the people. So that is why we will have to look at it from the perspective of what we are to create a spaces for the enjoyment of the rights. So here I would like to refer a Roman jurist like Alpine. He says that the nature and the state, they have eschewed all the rights of the human beings, and that means we have to create a certain kind of mechanisms, and that particular mechanism cannot be compromised. So that means every individual will have to be respected, every individual will have to be protected. So this must be taken into care of when we talk about the human rights of the people. So here, why we have to say that it's not a man right, it's not a child right, it is not a women's right, it is not the rights of the aliens, it is there for everyone. So, but only for the purpose of a bit of a facilitation, what we would like to see that where every individuals have to be recognized first. So, but only for the purpose of specific emphasis, we have segregated like rights to the foreigners. Even foreigners, aliens must be treated in the same way. If you look at that, the natural principles of international law, which emerged from way back in the 1st century AD and 2nd century AD, the principles of law are much before in the Roman and Greek cultures, which has contributed greatly to the development of international law and human rights law and the entire legal system. These Greek and Roman philosophers have laid down the foundations of entire the principles of natural law and the human rights. Later, we have recognized them as a legal, enforceable rights of the individual. So that is how we have constructed. So what I would like to say here, Primarily, I would like to say this. I'm trying to bring my argument and say that human rights are not a new phenomena, what people have thought about it. Rather, it is a normative practice which was there from the human genesis itself. Maybe different form. Like we have seen Romans and Greeks, how they have recognized the rights of the people, rights of the citizens, the rights of the aliens. They have not discriminated, but rather the special focus have been given. The same way, if you look at that, the modern concepts of human rights can be traced back from the adoption of the famous Magna Carta. Like right now, while introducing, some of them have quoted also about the importance of the Magna Carta. Magna Carta is almost almost 800 years. And more than 800 years, this Magna Carta, so whatever form it was adopted, and it was trying to provide a complete charter of the civil rights and liberties. So the people could able to think that progressively to provide a charter of rights to the people, a civil rights, liberties against the state actions. If you read the history of Magna Carta, you will come to know that how the state was dictatorial during the time, how people have realized. How did people have realized it then? They have realized because it was there. And this Magna Carta, later, it has made it a revolutionary impact on the modern day lives of every continent and every state. So this bundle of civil rights and liberties, that is a Magna Carta, was limited when we compare to the today's world. Simply because, kindly try to understand, 800 years ago, look at that and how the socio-economic conditions of the people. The simple one example I can give, the charter prohibits collection of timber or wood or grass which cut and cultivated by the people, taken by the representatives of the state, is completely prohibited. Today, when you look at when you compare that particular provision which is there in the Magna Carta, and we say that, oh, a timber or wood or grass, but here you should not see that material, but the inherent right which was there. That is the economic means of protecting the people. And also wood, timber, which is very essential to protect people from the various natural calamities. The inherent rights were there. That is why timber was one of the important material which was protected by the individuals, but that was exploited, appropriated by the state and their agents. That is why people have to revolt against that. That's how we need to compare. When you compare this one, the modern day rights of the civil liberties were very limited, but the impact was revolutionary. And also, it is facilitated the realization of the recognition of the individuals. It says that, yes, these rights are there against repression of the state. When the state is appropriating the rights of the people, when the state is not recognizing the individual and their liberties, and we must enforce it. That's how which we have started in the context of our human rights mechanisms. Then further, if you look at and say that how this particular concept of the fundamental human rights of man, which has come, and these fundamental concepts of the human rights of the man, which have come with the advancement of the liberal ideology across the world, with the influence of Magna Carta. If you look at it, the famous so-called social contract theories. If you look at that, the social contract theory, and all the three theorists have laid down very beautiful and important principles. That itself is a contract between the state. That's what, if you look at that, Thomas Hobbes, John Locke or Rousseau, if you look at it, what are they saying? They're saying that we have a contract with the state. The state cannot appropriate. We are not given any of our absolute rights, but we have given in a sum. We have given a little freedom in order to respect our rights. That's a social contract. If the state is not respecting the social contract of the people, we must question the state. We must speak with the state. We must take up with the state, and in order to protect and enhance our protections which are there. So that has been reflected in almost all the world's constitution, whoever have adopted in the light of liberal democratic theories. And in India, if you look at that, we are much, much ahead of any of these countries. If you look at this India's constitution and its adoption of, this particular right, it is a very path-breaking initiative taken by the drafters of the Indian Constitution. They kept the very important part of entire Constitution to the people-centric. If you look at that comparatively other the constitutions, the Indian Constitution starts with recognizing the rights of the people and their sovereignty. If I recall the opening words of our Indian preamble, we the people of India, we have solemnly resolved to constitute India into a sovereign. That means we ourselves have recognizing the rights of the people. Very beautifully started with recognition of the rights of the people in the very beginning of the constitutional foundations. And later, while the actual drafting articles have come, part 3 and part 4 are reflecting the ideology what we have enshrined under the preamble. Generally, we the constitutional teachers walk into the class, say that, yeah, differences between part 3 and part 4. Part 3 of Indian Constitution enforceable, part 4 not enforceable. But the debate is ended long back. We should not differentiate anymore. Okay, when the Constitution was drafted, that's a different thing. But what I would like to mention here, both part 3 and part 4 of the Indian Constitution was introduced during that time, after much thought, went inside, and then they kept it in exactly how the people will have to be protected. So that we will have to look at it, my dear friends. Now, let me just quickly look at that, how this particular human rights word have come. And the first person, you all know that. I think I don't require to know again to inform you that, but it's a kind of reminding ourselves how it has come. Thomas Paine from the French Declaration, the rights of man and citizens. He was the first person who has used this kind of narratives. Subsequently, when the UDHR was adopted in 1947 and 48, and it was the rights of man was replaced with the human rights while introducing in the Universal Declaration of the Human Rights. And little before that, if you look at it, the adoption of the United Nations Charter 1945 and 1948, it is a kind of a consolidation of the entire human rights process in the human history. It is a consolidation, enumeration, recognition of normative practices which are there. So in this direction, UN Charter has made a significant advancement in the direction giving to the human rights. So this is one of the very momentous occasion for human rights law students to see how the rights of the individuals have been recognized by the international documents. If you again go back to the preamble of the United Nations Charter, it reads in the same as like Indian Constitution. We the people of United Nations. So that means the very essence of entire legal system, or whether it is international human rights mechanism or domestic legal rights mechanism, it is recognizing the rights of the individuals, my dear friends. So this is where we will have to reconnect ourselves. So that is where we will have to look at it. So I don't require to spend much time on what is a human right and rights have come up. But if you look at that, to remind you of this Article 1 of the UN Charter, it proclaims the entire fundamental freedoms which we have in the entire normative practices of human rights treaty mechanisms. That is the first step. And the second, if you look at that, the Charter in various provisions, they created a kind of an influential mechanism of various provisions like Article 1, Article 13, 55, 56, like that, so many articles which we can cite. And that particular charter which created, it's like what we call it as the students of law and international law. It's a kind of a golden thread. From the Charter of United Nations Charter, Preamble 2, unto the last article, there is a single golden thread which goes into in order to protect the entire mechanisms. Even if you look at that, one article which I would like to bring to your notice, Article 2, Clause 4, the prohibition of the use of force. Why we need to prohibit the use of force? Because it is adversely affecting the human rights of the people. If you look at that, the powers and functions of the United Nations Secretary General in Article 24 and the Security Council, they say that for the promotion of the peace and security and human rights of the people, if any situation aggravates to the or detrimental to the enjoyment of the rights of the people, we must. So that was recognized one of the purposes and basic objectives of the United Nations Charter. And also what again the students of international law call, and scholars of international, they call that it is a standard, an international standard, which we need to observe for the protection of the rights of every individual in every country. In between, there was some kind of deliberation. Here, I would like to little digress a little towards a different regime. That is with regard to some people, they say, oh, human rights are to do with the culture. I will even explain it to you what is that culture. In Western world, people have given very much liberty, and the children cannot be even told. Children will be given up on a very every freedom, and recognizing them as a kind of a full-grown individual. But whereas in the Asian culture, it's not like that. It is the duty of the parents. Even if the child is going in some different direction, they can punish. It's a kind of benevolent human rights mechanism you could see by having some kind of authority of the parents. So in this context, I hope I'm making myself clear to all of you. In this context, if you look at that, human rights of the West is different from that of the human rights of the East or maybe global South. That's what they say. But my dear friends, it's not like that. Wherever you are, the international standards and norms of the human rights must be recognized by every country, and every individual must be provided the same space as it's supposed to be. So that has to be told to everyone. Now, UDHR was the first, they have taken up by the United Nations General Assembly, and United Nations General Assembly has taken up the mandate from the United Nations Charter in order to carve out important principles. And subsequently, that was established the Commission on the Human Rights to implement the provisions of the UN Charter and human rights related, and also the Bill of Rights, which we are going to look at it after some time, that is other covenants and Universal Declaration of Human Rights. So here, in order to achieve whatever the aspirations which we have under the normative practice and the international norms and standards, in order to achieve that, the Economic and Social Council was given a task to provide a blueprint of human rights, narration, re-narration, enumeration of the human rights, to give the clarity to the people. So that is where 1948 UDHR was accepted, and where the UDHR is consists of 30 articles, and the first 15 articles consist of civil and political rights, and from Article 16 to Article 30 consist of economic, social, and cultural rights. So this is a kind of an integral part of it. And quickly, there are no kind of a direction given to every state, mandated to every state. Some people say that, oh, it is only a mere declaration. They do not have any kind of a binding value. We have some positivist international lawyers and positivist scholars and students. They say that UDHR is only a kind of guidance. It's only declaration. They don't have binding obligation. But my dear friends, UDHR is only a re-enumeration of the rights which are existed under the charter and the normative practices in the society. That one has to remember. So when the debates have come, suddenly what they have done, they said that, okay, let's look into that and give the more clarity on that. Subsequently, they have adopted the two important famous covenants, that is International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights. And that is, they have given much clarity. The first 15 articles of the UDHR was developed and kept it in the covenant, International Covenant on Civil and Political Rights. And the other part of UDHR, that is Article 16 to 30, they have come up with a covenant on economic and social and cultural rights. Here, if you look at that, these two covenants are trying to build an effective legal regime and legal mechanism to protect the people from the all rounds of development: civil, economic, social, political, cultural rights. And in order to give an effective implementation, they also created some optional protocol. Whoever parties to this particular covenants, they must have a responsible legal mechanisms, and they must implement it in their domestic legal system. And in order to monitor that, this optional protocol, which was adopted for the civil and political rights, creates a monitoring mechanisms. That's where very important. That means the internationally you are monitored. How are you going to implement the rights which are there under this international treaty mechanisms? And this optional protocol, the first optional protocol and second optional protocol, provides standards. Like the ICCPR second optional protocols even prohibits the death penalty. But no, some countries, they have not still continued to maintain their penal codes death penalty, like countries like India, China, and the US. But most of the countries, they have prohibited the death penalty because various reasons which we can see why death penalty should be abolished. So I will not go into the details of that one. Now let us look into that. Another draft optional protocol which we have, that for the International Covenant on Economic, Social, and Cultural Right, which adopted in 1985. That is another effort made in 1985 to give the enforcement of the social and economics and cultural right. And along with that, we have another branch of rights mechanism, which is specifically trying to protect the people, those who are caught in armed conflict. Like if you look at that ICCPR, Article 14, Article 4 and Article 6 says that in case of emergencies, in case of warlike situation, your human rights will be compromised. That's what some states have interpreted, but that's not correct. They say that if the state of the security of the nation is threatened, the state can suspend some of the rights. That's interpretation given, even like countries like India. We have given some reservations to that, but it's not true. But still, since in such kind of incidents are there, what the human rights law scholars as well as international humanitarian law scholars said that no, human rights is still to be protected even during the kind of conflict, where during the situations of international armed conflict or non-international armed conflict or even insurgency movements, and there are specific mechanisms. And that specific mechanisms which we have under the international humanitarian law, that we have 4 Geneva Conventions of International Humanitarian Law, which was adopted in 1949. That's a special branch of law. They will only apply. For example, today, look at the Russia-Ukraine crisis. When Russia-Ukraine crisis is happening, suddenly everybody stranded, particularly the Indian medical students. You all know that. And now here, international humanitarian law is talking about the protection of the rights of the foreign citizens, those who are living in there when the conflict was broke out. Now you have seen both the conflicting parties, they demonstrated their restraint in order to protect the rights of the students those were stranded during the situations of armed conflict. And they allowed the government of India to take them back, and they were expatriated from the Ukraine crisis. So it's a special branch of law. And coming to this, human rights of protection, ultimately people say that, do we have the enforcement mechanism? Was it effective? That's where now we have seen not only domestic legal system, we have a rich history of Indian judiciary, how they have protected. Number of cases are there. I don't require to go back and tell you that your constitutional teacher must have been told you. Judicial activism, Article 21, how it has been expanded. Article 14, how it has been expanded. That itself, each article, each provision is a jurisprudence in itself. You can write volumes on that. That is a kind of development which we have seen in the jurisprudence of the human rights system, particularly with regard to the enforcement. But unfortunately, some countries, when the system was not in place, how are we going to protect the rights of those people? That's why the United Nations have come up saying that they established some ad hoc tribunals and also international criminal legal system in order to prosecute the people, those who are perpetrating the violence against the people and committing the crimes against humanity, and then they have been prosecuted by these international criminal legal system, which are very successfully providing new dimensions. If you look at the jurisprudence of the international criminal law, much refined. Still, some of the domestic legal system also did not address that particular problem. Gender-based violence. Still today we are talking about the gender-based violence. We are talking about that recognizing sexual violence against women in the conflict situation. We are talking about that in workplaces. But if you look at that international criminal system mechanism, jurisprudence is much ahead of many of the countries. So that's how the contribution of international criminal legal system for the effective enforcement of the international human rights law. So along with that, we have so many treaty mechanisms. One of the very important treaty mechanisms which today's context what we are discussing is that is elimination of discrimination against women. Elimination of the discrimination against women. That's one of the important treaty which adopted by the United Nations treaty mechanisms. That is where our whole focus since morning we have. Like India was a party to this particular Discrimination Against Women Convention 1993, and subsequently, the famous judgment. Today everybody quotes that famous judgment as the genesis of the entire debate on the protection of the human rights. That's a Vishaka. If you look at that observations made by the Justice Verma, only made one beautiful statement on that. The government of India during that time, they said that no, we have obligation, we know Indian constitution, but we cannot take international obligations. When Justice Verma and the other council has cited this discrimination against women, during that time, government councils, they made different arguments. In response to which Justice Verma had said, do you think that until the government ratifies, we should keep quiet, not to provide the protection to the women? Should we wait? The government of India will recognize someday, enforce and implement the international legal obligations in domestic law. You are expecting us to not to talk about it? If you are expecting, and he said that we are sorry, but you will have to do it. That is where that is a famous and Vishaka judgment came, and the guidelines have been given. Now, since then, 30 years, that's what I think Professor Soma ma'am has said. Instead of celebrating International Women's Day on March 8th, but we need to observe sensitization of people about this kind of matured legal system and provisions of law where it is available in the legal system. Now, coming to quickly, I would like to give you and provide a principal international human rights treaty mechanisms. Why I am calling that a principal international legal mechanisms in the context of human rights? Because all these treaties, there are so many treaties, but what few treaties have a specific monitoring mechanism, how the states are implementing. For example, India is a party to the ICCPR and ICSCR. It is an obligation on the part of the government of India. They have to submit periodic reviews to the Human Rights Council every year. It is an if they are default, and they will be called out in the Human Rights Council. If you look at the Human Rights Council's reports today, and who are all defaulters submitting the periodic reports about the implementation of these treaties in their countries. That's a good way of reminding the state parties about their obligations about international human rights law. So that is why if you look at that, after 1993, Visakha judgment is a reflection of the convention which talks about the elimination of all forms of discrimination against women, which was adopted by the United Nations during 1970s. That's precisely 1979. It took maybe few years, but still after 1993, from then to until today, we know how it has been, but a lot to be done. That's very, very underlining point we need to remember, my dear friends. Now, coming to that, the constitutional process. This is what the entire international legal mechanism, which I just want to highlight. And now, coming to that constitutional provisions. Whatever I said in international legal mechanisms, you can see our entire legal system of India is a clear reflection of all the obligations which are there. Like I mentioned, fundamental rights, which is a consist of the civil and political rights, which are enforceable in the Indian Constitution by way of going to the court. That is the tool which is given by the Indian Constitution to the people. It is the foundation and spirit of the Constitution. It is a guarantee to every individual. Forget about gender discrimination. Forget about the discrimination based upon the class, caste, color, region, etc. It is a foundation, the spirit of the Constitution to guarantee the rights of the every individual. For that, what we have weapon? We have weapon in the hands of the people. That is Article 32 and Article 226. And this particular article ensures the protection of every individual by achieving that in all the rights, when these rights have come under attack by the state. From the dictatorial and the other regimes, we can protect the rights of the people. That is the power of Indian Constitution, which is there under the Part 3 of the Indian Constitution. Coming to Part 4, though I said a little bit beginning of this lecture, we the teachers teach by saying that it is a kind of enforceable and non-enforceability. No, it's not that. The entire judicial activism which we study, reflection of bringing synergies between the Part 3 and Part 4, where without having social, economic, cultural right, you cannot have basic civil and political rights. Without your social life, how? Can a person, without having an enforcement of the social rights, Let me put it one simple example. The simple example is that Universal Declaration of Human Rights and ICCPR is saying that every person should entitled to have a family. I put it that under the social right. I need to have a family. You cannot expect a person to live without having a family. So now if you say that, okay, by way of giving divorce to the members of the family because of their irretrievable differences, irreconcilable differences between the spouses, then what happens to the right of the child? Here I have another criticism also. Now, if both the spouses, they have the irreconcilable disputes and differences, if they cannot resolve the dispute, they can go and separate according to the new jurisprudence. And also, they can go to that, so many family mediations have come today in order to expedite the process of a dissolution of the marriage. But what happens to the rights of the children over there? The child required to have a family which is a social embodiment. How are we going to look at these rights? So that is why it is interwoven. I mentioned earlier, it is a golden thread. It is interwoven. That's why you cannot say that Part 4 is not enforceable. It is enforceable. The thread which lies over there, and we need to, unless pull the string, you cannot. So that's why it's very important. But why did they keep it under the Part 4? Because that is made as a kind of obligation to the state. As I told you, that rights are not a charity. It is not that the state has to give. It is the duty of the state to ensure protection, where without a realization of the social, economic and cultural rights, you cannot have the political, civil rights. So that's where it is a duty of the state. So that is how we need to understand the integral part of the rights which are provided under the Indian legal mechanisms in the Constitution with regard to the constitutional provisions. I think, I hope I'm making myself clear to all of you. Now, quickly looking at this National Human Rights Commissions, how it has come. Like we have the obligation, like I told you that we have obligations under international law. We have United Nations Charter, we have UDHR, we have ICCPR, and a whole plethora of international legal instruments. And subsequently, and along with international developments, we are also developing very well oiled and structured legal mechanism for the protection of the rights of the people. And these particular rights and the structures of the rights must be enforced. Now, states are there in order to enforce, courts are there. But if sometimes if people are not able to access to the courts because of the kind of system which we have, how are we going to? That is why an additional system of protection support has been designed and designated by way of human rights institutions. And the covenant, or the covenant of civil and political rights, its optional protocol, which warrants monitoring in the state level itself. That is where in 1991, the famous Paris Principles, which speaks about that every state who are parties to the international human rights covenants and treaty mechanisms, they must need to have their internal human rights monitoring body like NHRCs, whatever the name you call it. So these national human rights institutions are state bodies. It has to have it, which came from the mandate of this protocols as well as Paris Principles of 1991, and with the constitution of their own. They need to have the constitutional mandate and legislative mandate in order to provide and promote and protect the rights of the people. First, you need to promote. See, let's look at that. Today, the NHRC is associated with us to disseminate the knowledge of the rights of the women. So this is a promotion of the rights of the people in order to protect, and it is empowered by the constitution and legislative mechanisms. That's one of the beautiful works of human rights institutions which they can do. It is a realization of the Paris principles which are there under 1991. So these mechanisms, they are primarily a state funded by the mechanisms. It is managed by the state, but they need to maintain their autonomy. So these institutions are the foundations and cornerstones of the protection of the human rights system in the domestic level. There are a lot of readings have come, writings have come, how the national human rights institutions are functioning across the world. Through which you can see, in India we have NHRC, along with that, every state has the state human rights commissions. But state human rights commissions are not that effective as NHRC due to various reasons. But NHRC work is very much appreciated, and it has made its mark while protecting the rights of the people. If you go and look at it, NHRC website, it is evident. So this particular mechanisms, when they are increasingly used by the people, because you can walk. Today, if you are in Delhi, you can walk to Loknayak Jayaprakash Narayan building and go and sit there and meet one of the advocacy members of that committee, NHRC. You can file your complaint. You can go and tell your information. So that is how accessible these institutions are. Let me come back to that, how these institutions are supposed to function. They are the state institutions with a specific mandate, like what I said, is to promote and protect human rights. And they are headed by the number of members. Morning, if you happen to participate in the inauguration, we have a member, a judicial member from the NHRC, Justice M.M. Kumar, who is heading that now today. Now, what is the core of these functions of these people? The core functions of these people, though the state is there, if the state is involved in the actions against the people, then this investigation committee will do their independent functions. They investigate into the matter, they inquire into the matter in order to bring justice to the people. And for that, as I told you, they even have individual complaints mechanism. You don't require anything. You just walk in and tell. There are so many occasions. The NHRC, the individual complaint receiving cell, keep on working in individual complaints. And once they find, then they will follow investigations. And they have the authority to make recommendations. In a number of cases, this Indian National Human Rights Commission has made a remarkable contribution towards the protection of the rights of the people. Now, look at that, the composition of India's National Human Rights Commission. As I said, that it is established in 1993 with the adoption of the National Human Rights Act. And it comprises of the chairperson, who is generally a retired former Chief Justice of India. And along with that, they have members. Like if you see one either former or sitting judge of the Supreme Court, and Chief Justice of High Court, one former or sitting, and two persons having the knowledge of the practical experience in human rights. They may be academician, they may be working in a civil society, they may have a administrative background, or they may be having another background. If they have, they can. And also 4 deemed to be members who are chairpersons of the commissions, like Women Commission, Minority Commission, SC/ST Commission. By virtue of their office, they are also members of that National Human Rights Commissions to represent a special concern of these commissions. That is here what I should say. one of the very, very important and interesting mechanisms which we have, my dear friends. Then coming to that appointment of the chairperson, how do they appoint? The chairperson of the National Human Rights Commission is appointed by a committee, and the committee will give the recommendations to the President of India, and the President of India will appoint. So that's a constitutional body, and this committee is headed by the Prime Minister of India, and members. Here it's very interesting to see Speaker of Lok Sabha, Home Minister, Leader of Opposition in a upper house, Leader of Opposition in the lower house, and Deputy Chairman, Rajya Sabha. So these are the constitutional dignitaries who will sit together and think about the appointment of the members as well as appointment of the chairperson of National Human Rights Commission. That means it's one of the very, very important body in additional body to guarantee the rights of the people. Now, if you look at that NHRC, I can fully and 100% I can say that they are fully compliant with international obligations and international norms, and also Paris principles. They are autonomous, they are independent, they have a wide mandate. The NHRC, though it was established by the members of a committee which is headed by the Prime Minister of India, but they will act autonomously. And it's a statutory organization, a constitutional body. It is created by Act of Parliament. They have an autonomous. They know no one can influence them. They have their own system. They're independent, and they can take the decision and express its own views on different human rights issues. No one can stop. See, for example, if you keep on looking at the various incidents across India, there are beautiful jurisprudence was developed by in the context only. The famous jurisprudence which came out of this with regard to the refugee protection, that is state of Arunachal Pradesh versus National Human Rights Commission. Khudiram Chakma versus National Human Rights Commission take up that matter. Khudiram Chakma's case with regard to the refugee law is concerned, and against the state of Arunachal Pradesh, and there the Supreme Court has given the very good jurisprudence with regard to the protection of the rights of the people, those who are coming from the conflict zone from the foreign territories to India. So wide mandate. They are not only trying to protect the rights of the citizens of this country, but also foreigners and aliens. It's a very wide. It caters the different sections of the people. So that is why I said the beginning of this particular slide, Indian NHRC is one of the very best enforceable mechanisms which we have in India. And sometimes what they do, they take a sumoto action, sumoto cases and inquire into it. Like particularly, there are a number of occasions. One occasion I can tell you that in the state of Bihar, about the human trafficking. And they have taken the cases in sumoto basis. And they asked the State Human Rights Commission to go and look into it. What's happening in the children homes and juvenile homes? Why the trafficking is going on for various illegal purposes? Sumoto way they have taken by looking at the newspaper. They inquire into it, or they whenever the petitions are filed by the people, they look into all these things, whether the human rights violations or abetment has been going on in this particular context, or any kind of omissions by any of the officers or the state in terms of discharging their duties, or dereliction of their duties, negligence of their duties, in order to prevent such violations or prosecute the people. The NHRC will take very serious cognizance of this, and they will intervene in any of these proceedings where the alleged violations of human rights are pending before the courts. So it has got a very wide, effective legal mechanisms in order to respect the rights of the people. Further, if you look into that, they also visits jails or other institutions under the control of the states. Like I mentioned, juvenile homes, or care homes, or rehabilitation center, anything. Look at that, wherever individuals, they are under the violations of the rights by the state or any other, the state will, NHRC will interfere into it, and they make recommendation and taken actions. And along with that, what they do, they study the international treaty mechanisms and other international instruments of human rights, and they make recommendations for the effective implementation of those recommendations in India. It's a recommendatory role which they have very good in the context of India also. And if you look at the website of the NHRC, they undertake and promote the research in the field of human rights. They spread human rights literacy among the various sections, like what we are doing today. Students can go and engage themselves with NHRC by way of undertaking the internships. Teachers can undertake project works. You can conduct a moot courts with in consultation with the NHRC and their support. Their advocacy programs will promote awareness among the people about the safeguards which are available under the protection of the rights. And it is also to mention they have very good publication division. They have the media, seminar, and other available means. They try to. They also encourage efforts of non-governmental organizations, those are involved in human rights, for the effective implementation of the rights which they do it. Like if you look at this quickly, what kind of matters the commission will inquire into, and what rights they have, and what kind of legal capacity they have. Here they can summon. It's like a civil court in respect to any of the cases are concerned, and they can summon, and they can ask anybody to attend as a witness, and they can examine them on oath, and they can go and produce any document and discovery, and any kind of receiving of the evidence of the affidavits, and even they can requisitioning of any public record copy from any court or office for the purpose of verification and other purposes. As I say that it is wide varieties of duties and rights they have for the purpose of protection of the rights of the people. So finally, if you look at that, complaint, it's a very easy process. If anybody wants to know about how it works, it's very simple. Complaints can be entertained in any languages. Language should not be the barrier. And the mode method is not the barrier. They can either post or telegram, online registration, fax, email. And even, as I said, if you happen to be in Delhi, if you are going to the building, NHRC office, you just go and meet and just give the complaint. That's how it's a very simplified process. So this is how the entire national human rights system is working. I think I will stop it here. And if you have any questions, and I am very happy to answer them. Thank you very much. So any questions or any observations, my dear friends?
Thank you, sir. Thank you for your words of enlightenment. It was a very informative session. I don't see any questions in the chat box. Therefore, I would like to move on with the concluding part of this session.
Yeah, please.
At this juncture, I express my deepest sense of gratitude to our resource person, respected Dr. Banerjee Chakka sir, for gracing us with his presence. I thank our respected principal, Dr. C.M. Rao sir, our vice principal, S.N. Mure sir, IQAC coordinator, Dr. Aparna Kotapalle ma'am, teacher coordinator for this session, Dr. Dinesh Kolke sir, and the coordinator of this program, Dr. Sheetal Bharati. Also, I thank all the teaching, non-teaching and the technical support staff who was involved to make this session a great success today. I thank all the attendees for their valuable participation as well.
Thank you. Thank you. Thank you so much. Yeah.
Thank you. Honorable Advocate, Secretary of the MANIKCHAND Society, Aurangabad. I hand over the task to my colleague, Ms. Chetrali Daborkar, to start the next. Over to you, Chetrali.
Thank you very much. Coming to last session, that is very session. For this, we have with us Advocate Dr. Kalpalata Patil Marathwada ma'am, who is Secretary of MLNG Society, Aurangabad, and we have with us Dr. C.M. Rao sir, Principal of MP Law College. Now, I would request Dr. Sheetal Bharati ma'am to brief us about the event.
Thank you, Chetrali. I am clearly, whether I am audible? Chetrali?
Yes, ma'am.
Okay. Respected Chief Guest of Valedictory Function, Advocate Dr. Kalpalata Patil Bharati Madam, Secretary of MLNG Society, President of this valedictory function, Principal Dr. C.M. Rao sir, Vice Principal Sir, IQC Coordinator Dr. Aparna Kotapalli Madam, Teacher Coordinator of this session, Dr. S.J. Shirsat sir, faculty members and dear participants. While placing before you all this brief review of this training program, which is organized by our institute in collaboration with the National Human Rights Commission, New Delhi, I must share with you that we have started with inaugural session wherein Professor Poonam Saxena Madam, Vice Chancellor of National University, Jodhpur, gave keynote address. In her address, she classified the rights of women as 4+4+4+2. That is rights in her natal family, matrimonial rights, rights of self-sufficiency, and so on. She referred various landmark judgments. She also shared her real life examples and emphasized on the implementation of these laws wherein women's rights are given very properly. Further, this training program was inaugurated by Honorable Justice M.M. Kumar sir, former Chief Justice of Jammu and Kashmir High Court, founder president of NCLT, and presently a member of the NHRC. Honorable Sir has referred to several seminars, training programs, and workshops conducted by NHRC, which actually lead to positive impact in regions where they have conducted such a programs. Respected Sir also referred to various landmark judgments wherein women rights are protected. We heard the thorough discourse of Advocate Rama Sarodya Madam, human rights activist, in our first session, which was on the rights of women. While explaining various rights of women, respected Madam also discussed various real-life examples and judicial decisions. In the second session, we had with us Dr. Jyoti Bhakre Madam, HOD Department of Law, Savitribai Phule, Pune University, Pune, who dealt with women and health rights, wherein Madam focused her discussion on women and mental health, reproductive and maternal health, and space-related issues amongst the women. In the third session, discussion was there by Soma Bhattacharya Madam from DSNL Visakhapatnam on violence against women and legislative remedies. Respected Madam elaborately discussed about violence against women, sexual harassment of women at workplace, and complaint mechanism. She also had a comparative analysis of sexual harassment of women at workplace, which is prevalent in various countries like Australia, France, Russia, Pakistan, UK, US, Poland, and India. In the fourth session, Dr. Banerjee Chakka sir from VIT AP University, Andhra Pradesh, gave his discourse on human rights, wherein he gave a detailed account about evolution of human rights. He discussed various articles of UN Charter of Human Rights and human rights treaties. Further, respected sir has discussed a part 3 of Indian Constitution, National Human Rights Institution, NHRC, and its functioning. Now in this session we have respected Dr. Marathwada madam with us. She will be sharing her knowledge with us in her valedictory address. All these resource persons, they have given intellectual feast to the participants by their discourse. Definitely they sensitized our participants about various rights of women, which was one of the objective of this training program. Various rights contained in various international instruments and national legislative enactments. Definitely knowledge about these rights will enable our participants to work towards the proper implementation of these rights without any violation, and this will be helpful in overall development of the woman or human development of the woman. I am thankful towards all the resource persons for sharing their valuable knowledge with us. Equally, I am thankful to the chief guest of this function, Dr. Kalpalata Patil Mahasarkar Madam, who is with us for the valedictory address. Once again, I am thankful to NHRC, all the respected members of MLNG Society, faculty members, Vice Principal Sir, IQC Coordinator, again for always motivating us to conduct such programs. With this short review of this training program, I will stop here. I am thankful to the organizers for giving this opportunity to place a brief review about this training program in front of you all. Thank you so much. Chetrali, over to you.
Thank you very much, ma'am. Before we move to actual address, we have with us two participants who are willing to share their feedback with us. First, I request you to please switch on your mic.
Chetrali, you were not audible.
Okay. Am I now? Am I audible now? Okay. We have two participants with us who are willing to share their feedback about this training program. Now I request Dr. G.S. Satish, Assistant Professor from RL Law College, Davangere, Karnataka, to share his feedback with us. Satish, sir. Okay. I request Mihir Inamdar, sir, Department of Law, Savitri University, to share his.
Mr. Mihir Inamdar, are you there in the meeting?
Hello, yes, madam.
Yes, okay. Go with feedback, please.
All the guests have excellently described many complex and recent socio-legal issues related to women rights as well as human rights at national and international level. For better understanding of concepts, various case laws were also discussed. This training program organized by MP Law College, Aurangabad and NHRC Delhi was really helpful for all as it created general awareness of various human rights and legal remedies to deal with the issues related to these rights. Thank you all.
Thank you very much. Moving further. I request Dr. G.S. Yatish, sir, to please share his feedback with us. Yatish, sir, am I audible to you? Okay. There might be some technical issue. Moving further, now I request Advocate Dr. Kalpalata Patil Marathwada ma'am Secretary, MLNG Society, Aurangabad, to address the attendees. Kalpalata ma'am, over to you.
Thank you, Chaitrali. Good afternoon, everyone. First of all, I'd like to congratulate MP Law College team led by Dr. C.M. Rao sir and NHRC for arranging a much needed training program that is particularly on correlating women's rights and human rights, a human developmental approach. It was much needed training program and many more such programs are required. Needless to mention that women's rights are human rights. Human rights are the inherent rights for all human beings to be enjoyed by all the people, no matter who they are, where they live. It includes civil, political rights, right to life, liberty, free speech, privacy, and many more. 1945 Charter of United Nations sets out one of its goals to reaffirm faith in fundamental human rights, in dignity and worth of human persons, and in the equal rights of men and women. Article 1 of the Charter further stipulates one of the purposes of United Nations is to promote respect for human rights and fundamental freedoms without distinction as to race, sex, language, or religion. The Universal Declaration of Human Rights 1948 was adopted. It too proclaimed that equal entitlement of women and men to the rights contained in it, without distinction of any kind such as sex. In drafting the declaration, there was considerable discussion about use of the term all men rather than a gender neutral term. The declaration was eventually adopted using the terms all human beings and everyone, in order to leave no doubt that Universal Declaration was intended for everyone, men and women alike. In 1967, United Nations member states adopted the Declaration on Elimination of Discrimination against Women, which states that discrimination against women is an offense against human dignity and calls on states to abolish existing laws, customs, regulations, practices which are discriminatory against women, and to establish adequate legal protection for equal rights of men and women. Less than a year later, a proposal for legally binding treaty on women's rights was made. The Convention on Elimination of All Forms of Discrimination against Women was adopted by General Assembly in 1979. Its preamble explains that despite the existence of other instruments, women still do not enjoy equal rights with men. Here, I'd like to stop and mention that just now Dr. Banerjee dealt with United Nations Charter and all the Human Rights Convention and its correlation with Indian Constitution, provisions of Indian Constitution, fundamental rights, directive principles. I'd like to go further and say that even in fundamental duties, there are provisions. Now coming to Indian Constitution. Indian Constitution guarantees equality before law and equal protection of law. Then Article 15 prohibits discrimination on the basis of sex. And it further provides protective discrimination in favor of women and children. There are a number of laws for the protection, upliftment, and empowerment of women. There are legislations to curb female feticide so as to protect her in womb. There are so many legislations providing for equal right of education, primary education, even higher education, equality of opportunity, equal pay for equal work. There are so many decisions of Honorable Supreme Court regarding that. Then right to property, right of succession, even co-partnership right. There are legislations for protecting women in society from different crimes, particularly rape, acid attacks, obscenity, pornography, and many more. There are legislations, there are different judgments. There are legislations for protecting women behind door, even in her own home. That is protection from domestic violence, cruelty, dowry demand, etc. There are legislations for protecting women at workplace. That legislation came long after the judgment of Honorable Supreme Court in Vishakha versus State of Rajasthan. Of course, there have been very progressive judgments by Honorable Supreme Court, just like judgment on triple talaq, and even many more such judgments. There are large number of judgments and legislations in favor of women. Each legislation will require detailed analysis to examine the benefits, the loopholes, the changes which are required. In today's program, training program, we have considered different aspects of human rights and correlation of human rights with women's rights and developmental approach. That is what is the effect of it. In keynote address, Professor Saxena dealt with different judgments and rights of women in beautiful manner. And I'd like to say that participants must have been enlightened with thought-provoking deliberations by the legal luminaries. Honorable Mr. Justice M.M. Kumar very well said in his inaugural address that there are so many laws, but still there is rise in the cases of violence against women. As rightly said by him, pulse of people beats in parliament, but the weaknesses of laws are tested in courts. So he rightly said that there is need to be sensible and sensitive while applying and interpreting laws. And I'll request each and every participant in this training program to keep in your mind that you need not only know law, it is necessary to be sensible and sensitive while applying and interpreting laws. So many of the participants must be future judges, some will be future advocates. You keep in mind that it is necessary to be sensible and sensitive while applying laws. And not only this, you should be you can apply your knowledge in practically in helping others. Just like legal literacy camps, we held legal literacy camps. Even otherwise, you can help others in getting justice. All of us are from legal fraternity and we know the importance of law, but only law cannot change the society. We need to change the patent, inherent, inbuilt prejudices, which are, we need to change our mindset and mindset of others, which we know that if we feel that I need to change the mindset of somebody, which I feel that it is not, which I feel that it is just patent prejudice. If somebody is having patent prejudice against this concept of women empowerment, or like that developmental approach, against that, if we feel we can do something to change that mindset, it is, I know that it is very difficult to change the mindset, but at least every one of us can try to change the mindset of one person. And if we can do this, definitely we can change the mindset of the society. Let us join hands together to work for achieving the goal of attaining equality among men and women and eliminating all forms of discrimination against women. Thank you. Thank you very much. Over to you.
Thank you very much, ma'am, for your kind words. Before we move ahead, a request to all the attendees. A feedback link has been sent in chat box. We hope you will put your feedbacks in the given link. Now, I request our principal, Dr. C.M. Rao sir, to give presidential address. Rao sir, over to you.
Respected Secretary Madam, respected members of the ongoing program, I would like to thank all the participants for your active participation in the program and all the resource persons who joined us for a wonderful training program for the benefit of our enthusiastic participants. So I would like to thank the coordinator, Setal Barhate Madam, and supporting Dr. Aparna Kottapalli for arranging this wonderful training program for the benefit of students. Once again, I thank all the persons who directly, indirectly supported this program. Particularly National Human Rights Commission, who collaborated with us to make awareness among the students. Thank you one and all. Thank you, Chaitanya.
Thank you very much, sir. Now, I request Dr. Shashikant Shirsat sir to present vote of thanks.
Very warm welcome at the end of today's online national level training workshop, which we have organized to have the deliberations relating to the correlative human rights and human rights, human development. As we all from the legal fraternity knows about our rights, knows about the duties, knows about the laws. Moreover, education is a continuous process. It is like a living organism. So what happened in the past, what we are experiencing in present, and what we can do for future, for that such training programs are organized. And therefore, this year, MLNG Society's MANIKCHAND Law College has organized this wonderful program. And we are on witness of it. For organizing such august gathering, it cannot be complete or get success without having a good teamwork. And therefore, I am very thankful to the Marathwada Legal and General Education Society and all honorable office bearers of this society who have consented to organize this program for all the intellectuals. Not only that, it cannot be complete without having the financial support. And National Human Rights Commission New Delhi also provided us a financial support to organize this training program in a good manner. And therefore, I am thankful to the National Human Rights Commission and their office bearers for consenting and making this collaboration with MP Law College. At the same time, I am thankful to our beloved Secretary of MLG Society, Advocate Dr. Bharaswarkar Madam, for giving the presidential address for this valedictory function. Dr. C.M. Rao, sir, Principal of MP Law College, for consenting and also giving the keynote addresses and also providing the resource person for this August gathering. I also thankful to our Vice Principal, sir, Sri Kishan More, sir, IQC Coordinator, Dr. Aparna Potapalle Madam, and also the instrumental, the young and dynamic, multi-talented coordinator, Dr. Sheetal Bharati ma'am, who has given this opportunity for us to have the dialogues. It is also necessary that there are many hands directly or indirectly contributed to get the success of this training program. So therefore, I am thankful to all those people who have contributed their help. No doubt, all the resource persons, our anchors, student anchors, our teacher coordinators, non-teaching staff, as well as technical support, Sri Shubham Jaiswal, Sri Deshmukh sir, Sri Abhay Jadhav, Sri Kulte sir, Kirbane madam. I am thankful for them for their contribution. Last but not the least, I also thankful to all the attendees who have spent entire day to have different deliberations or the discussions to discuss this very important issue, which laid a foundation for tomorrow's morning. Therefore, dear friend, I am thankful to all those attendees as well as the students of MP College for their presence in this August gathering. I am also thankful to all the media people as well as the people who are instrumental to organize this program. And lastly, I am thankful for the organizers who have given me this opportunity to vote of thanks. With this, I will take your leave. Over to Chetan. Thank you.
Thank you very much, sir. a request to all the attendees to switch on their cameras. We need to click a photo so that as a remembrance for this session, all the attendees who can switch on their camera immediately, please switch it on. Thank you very much, everyone. Now, with the permission of dignitaries, I hereby declare that online national level training program on correlating women's rights and human rights, a human developmental approach, which was in collaboration with National Human Rights Commission, New Delhi, has been successfully completed. Thank you very much, everyone, for joining us. Thank you. Feedback link has been sent in chat box. Please, those who have not filled it yet are required to fill it. Everyone.